Test, test.
I know. Yeah.
I'll be flipped around the building.
Okay. Is Andrew around?
No, he'll be in on Monday.
Oh, okay. Is he still not feeling well?
I think he's doing better.
Okay.
Yeah. Andrew has just found it impressive.
What's that?
I said it looks like, yeah.
Yeah, it looks that way. So can we start? Okay. 5 minutes early. Here we go. The grind continues. I think MEA has another couple of witnesses.
That's correct.
Sorry, if I could do one preliminary matter.
Oh, yes, absolutely.
Just regarding OPC's witness availability,
Mhm.
I just want to note that Mr. Garrett, Mr. Fitzhenry, and Miss Whited are all here in person, so we would really request they go today. Normally, I wouldn't really be concerned, but I'm not exactly sure how long Mr. Balakumar is going to take.
Nobody is.
So, yeah, I would really
List
insist
of witnesses.
we try to get through at least them today. Mr. Madsen is also available virtually today if we
Thanks.
have time.
If you need it tomorrow.
I believe he's available Monday, he is available Monday as well. I think there's a slight preference to maybe go in the afternoon. I know that would be out of order because he has a
Well, I mean,
thing,
I
but
mean,
he's available to whenever.
okay.
I believe.
Thank you. Anything else?
That's it.
That's it. Okay.
Your
So-
Honor, I have one preliminary matter.
Sure.
Staff has indicated that they wish to recall one of our witnesses, company witness Nelson, and the company is amenable to that, but he would be unable to appear until after lunch.
Okay. Okay, we'll try and fit all this in then. Is he here right now? Or he's not here yet?
He's not here yet.
Okay.
Yes.
All right. Well, if there's nothing else, let's proceed to the next MEA witness.
Thank you, Your Honor. MEA would like to call to the stand Dr. Stephen Kime.
I wonder what happened to my list. It was here somewhere. No, it's okay. I mean, it doesn't really matter.
I do.
Good morning, Dr. Kime.
Good morning.
Would you please state your name and title for the record?
Stephen Kime, and I can spell that Steven, Kime, Kihm.
And your title?
I am a regulatory consultant.
Do you have a document in front of you titled Direct Testimony of Stephen Kime on behalf of Maryland Energy Administration?
I do.
And does that testimony consist of 35 pages of testimony and 3 accompanying exhibits, SK1 through SK3?
Yes. Yes, it does.
Your Honor, I'd like to mark for identification Dr. Kime's direct testimony as MEA Exhibit 5.
So marked.
Thank you. Dr. Kime, was the direct testimony prepared by you or under your supervision and direction?
Yes.
Do you have any corrections or deletions to make to your direct testimony?
No.
If I asked you the same questions as in your direct testimony under oath today, would they be the same or similar?
Yes.
Your Honor, I'd like to move Exhibit MEA 5 into the record.
Without objection, so admitted.
Now, Dr. Kime, do you have another document in front of you titled Surrebuttal Testimony of Stephen Kime on behalf of the Maryland Energy Administration?
Yes.
And that document consists of 16 pages?
Yes.
Your Honor, I'd like to mark for identification Dr. Kime's surrebuttal testimony as MEA Exhibit 6.
So marked. Did you want to move it into evidence or just mark it?
I will want to move it into evidence as well. I'll just ask a couple
Okay.
of preliminary.
All right. No, I just misheard what you were saying, so that's...
No, that's. Thank you. Was the surrebuttal testimony prepared by you or under your supervision and direction?
Yes.
Do you have any corrections or deletions to make to your surrebuttal testimony?
No.
If I asked you the same questions as in your surrebuttal testimony under oath today, would they be the same or similar?
Yes.
Your Honor, I'd like to move MEA Exhibit 6 into the record.
Without objection, so admitted.
Thank you. The witness is available for cross-examination.
Company.
No questions.
Okay. AOPA. OPC.
A few questions, Your Honor.
Go for it.
Good morning, Mr. Kime. How are you doing?
Good morning. Good.
Do you agree that Pepco and utilities in general are very low-risk companies compared to the average company or the S&P 500?
Objection. This sounds like it could be friendly cross.
So I am getting to a point that I
I'm gonna sustain the objection, reword the question. How about that? Can that be possible? Well, give it an effort. Actually,
well, I think I think the line of questioning. What I was getting to was the line of questioning. I'm going to this particular question may not, but the line of questioning I'm getting to is getting to the point that while MEA is recommending a 9.0 ROE, we're recommending a 7.7% ROE, which is just about as far from MEA as MEA is from Pepco, and so I'm trying to get at the divide.
yeah, okay. Well, you know what? I'll allow it. Overruled.
The outstanding question is very low risk. I never like to use the adverb or adjective very. It's a low risk stock.
Are utilities perhaps the lowest risk type of company you can think of?
The three groups that are the lowest risk are utilities, consumer staples like Procter and Gamble, and healthcare.
Okay, thank you. And so, given that they're low risk, would it be fair to say that the utility cost of equity should be perhaps well below the cost of equity of the average company in the market?
Yes.
Okay. Could you go to your direct testimony at 23? Page 23.
I'm there.
Okay. Starting at line 11, to paraphrase generally, you're talking about various expert estimates of the cost of equity for the S&P 500 at large, right?
That's correct.
And one of the experts you cite is Professor Aswif Damodaran, correct? I'm not sure
That's
I'm saying that right, but
Damodaran, that's correct.
Yeah. And so Professor Damodaran is generally a well-cited and respected figure in finance, correct?
Yes,
Could you explain a little bit of who he is and his importance?
certainly. So he is a professor at New York University Stern School of Business. He is widely cited in regulatory proceedings, and he actually appears on CNN, or CNBC, excuse me. He's written many books. He's a very applied academic. He has a website, Damodaran Online, that's used across the industry.
Okay, thank you. I have a exhibit I would like to distribute, if I could approach.
Yes, go ahead.
Can I send it this way, I suppose? Do I have enough?
Can I have one, please?
Enough numbers for your body?
No, I need more.
Okay.
You're the numbers guy.
Yeah, I was just.
Okay. So this is a printout of the cost of equity estimates from Professor Damodaran's website that you cite in your testimony at page 23, line 16. Do you recognize it? It's the Excel version, but
Do you want to mark this at all?
I'll get to that in a second.
Okay.
So just to be clear, I didn't cite to this document in my testimony. I did cite to his website.
Mhm.
Just want to make sure I'm answering your question.
Sure,
Yeah,
sure. You did.
it's the same person.
Yeah. Do you generally recognize
Yes.
that? Yeah.
Yes, I do.
Okay.
Objection. This witness did not create this exhibit. This was created by OPC, if I understand the questioning correctly. So that would suggest a lack of foundation for this exhibit.
OPC didn't create this. This is publicly available on Dr. Damodaran's website. We downloaded it and printed it.
Overruled, I'll allow it.
And so I would like to mark this as OPC exhibit. Sorry, I'm actually, where are we? 30?
So marked.
So if you go to the last page of the document, at the very bottom, the third column of numbers is the one that is cost of equity, right?
That's correct.
And at the bottom, you can see here, total market. He has a cost of equity estimate of 8.02%.
That's
and
correct.
then without financials, it's 8.37%.
That's correct.
Okay. And so, do your
Your objection, Your Honor. I would like Dr. Keim to have the opportunity to review this exhibit before he asks a lot of questions about tables and numbers in that.
Sustained.
I guess let me know when you're ready.
I'm actually familiar with this.
Oh, are you?
It's on his website, so I
Oh, okay.
know this document.
Then proceed.
And so, to your understanding, like, total market without financials would be basically the stock market as a whole, and then I guess without financials would be about the bank possibly or something.
I'm sorry, I didn't hear the last part.
Sorry, total market would be for the stock market as a whole generally, or just a lot of companies in the stock market as a whole.
Yes.
Yeah, the estimate. And then if you look up at line 4 from the bottom, the one that says utility general, and that has a cost of equity estimate of 5.02%. Is that right?
That's correct.
Okay. Thank you. So it would be fair to say that, well, actually, let me strike that. In your testimony going back to your testimony, actually, let me first, I would like to enter OPC Exhibit 30 into the record.
Without objection.
Yeah,
so
I'm
admitted.
going to object to this. Again, this document is something that was gathered from a website. It's not specifically referenced in Dr. Keim's testimony, so I object to the entry of it.
I would say that Dr. Keim cited to Dr. Demoteran's website. Dr. Demoteran's website you can't actually cite to specific pages on the website for some reason. He cited to it. He also just stated on the stand that he was familiar with it. I think that's enough foundation.
Overruled.
Okay, so going to your testimony on page 28, line 19.
I'm there.
Page 919, you state, well, I guess it starts on 18, you state, so I begin the deliberate long-run process of moving the ROE into the reasonable range, right?
That's correct.
So it would be fair to say that your recommendation of 9.0% is is part of a stage of a long-run process of moving Pepco's ROE into a reasonable range. That is, it's an incremental step.
Yes, my testimony talks about moving gradually, and the range that I estimated was 7.7% to 9.2% for the reasonable ROE. I'm now going from 9.5 to 9.
Mm-hmm. But Pepco's true, fair, whatever.
Objection, Your Honor.
I haven't finished the question, but
Go ahead.
okay. But Pepco's, it's possible that Pepco's cost of equity and fair return on equity could be significantly lower than that.
Don't answer. You still object?
I think Dr. Keim is capable of answering this question.
So first of all, we have to pick your question apart. Cost of equity and ROE are different returns.
Mm-hmm.
So Mr. Garrett and I agree that the cost of equity is about 7 point. Your witness and I, the cost of equity, a strict financial term, is about 7.7%. The ROE is a different return. The ROE is the one the commission authorizes. So you're asking me, is the cost of equity lower than 9? Yes, absolutely. Now, where the ROE should be is a policy decision of the commission. So I don't know. I can answer your question with respect to cost of equity. Yes, it's lower. But what is your question with respect to ROE?
Could the fair ROE be significantly lower than 9%?
Yes, my range is 7.7 to 9.2. The reason I'm at 9 is I'm stepping into that range from gradualism.
Okay, thank you. And then at page 30, lines 1 to, starting at line 1,
Yes.
you talk about how there's no concern, there's no the commission shouldn't have any concern about Pepco being unable to raise capital at a 9% ROE.
Yes, that's my testimony.
Again, I'm going to object on this line of questioning. OPC is asking the witness about kind of sub 9% ROEs. That seems to be aligned with their position, which is to lower the ROE, and they're attempting to use this witness to get information on the record that below a 9.0 ROE is appropriate.
That's our position.
These are all friendly cross.
And that's a different position than what MEA has.
I'm going to allow it. Overruled.
Okay, so sorry, I'm going to restate the questions so my own head has it straight. So you state here that the commission shouldn't have any concern about Pepco raising capital if it receives a 9.0 ROE, correct?
That's correct.
Nor would there be any such concern at a 7.7% ROE?
Objection. That is definitely friendly cross. That is their position, the 7.7%.
Okay. Nothing further, Your Honor. Nothing further, Your Honor.
Okay. Staff.
Staff has no
one
questions
one
for this witness.
objection. I initially said that Pepco does not seek to cross this witness, but after hearing OPC's friendly cross of this witness, I want the opportunity to do a cross. Again, we have the burden of proof, and typically when we do cross, Pepco goes last. The other parties do their cross first, and then we conduct our cross. So we would have normally, in a usual circumstance, had the opportunity to ask questions last. So I request the ability to cross this witness based on the testimony or based on the cross of OPC.
I'll only respond to say that I don't believe the line of questioning you all permitted of Dr. Keim was friendly, but I don't have an issue with Pepco.
Then I'll allow it. Staff.
Staff has no cross for this witness.
Well, there we go. There we go.
Okay,
Proceed.
just one question. Good morning, Dr. Keim.
Good morning.
One question on the exhibit that OPC just distributed to you. There was a line that says utility. I believe it's 4 lines up from the bottom of the last page. Utility and in parentheses general. Now it says 14 as the number of utilities. Do you know the 14 utilities that are in that category?
I do not.
So even though this document was presented to you, you're not familiar with the data that supports this particular exhibit.
I did not construct it. Is that responsive? I don't know anything more than what's on the table.
Okay, thank you. No further questions.
All right, we will proceed to I'm
Uh,
sorry. Redirect. Excuse me.
No redirect.
No redirect. Okay, in that case, we'll proceed to the members of the bench, starting with Commissioner McLean.
Good morning.
Good morning.
In discussing your recommendation with Mr. Shu, you indicated you went from you arrived at a 9.0 for gradualism purposes.
Yes.
So is it fair to say that you consider a 50-point reduction to be gradual, sir?
That's about as far as I would go and still call it gradual.
Okay, fair enough. Are you aware of any other commission decisions that have authorized either a reduction or an increase the same or similar magnitude, sir?
Are you asking about this commission or any commission?
Maryland Commission, sir.
No, I'm not familiar with that reduction of that nature.
Or increase as well? Okay.
I'm not familiar with that.
Thank you, sir.
Commissioner Linton,
No questions.
Commissioner Suchman,
No questions.
Commissioner Hoover.
One question. So the company's rate of return witness, Mr. McKenzie, was of the opinion that gradualism is a fine item in the toolbox, but not necessarily in application to rate of return. Do you have a response or reaction to that?
Yes, if, for example, if you look at the regulation of public utilities by Charles Phillips, 1988, discusses gradualism as a term for ROE. It's been in the industry for at least 30 years.
All right, thanks.
I just have one question. I was just curious. You referred to Mr. Damodaran as an applied academic. What does that mean? Does that mean he works for a company? What is?
Okay, so theoretical versus applied finance. So what he does is produces items that actually can be used by practitioners. His books are written for practitioners. As I said, he's on CNBC. So even though he is in an academic institution, he's far from an ivory tower. He's an applied financial economist.
Okay, thank you. I have nothing else, so thank you very much, sir.
Thank you.
If you can call your next witness.
Yes, MEA would like to call Mr. Nikhil Balakumar to the stand.
And Your Honor, for cross, I would ask for this witness that we be allowed to go last.
Granted.
Thank you.
Good morning, Mr. Balakumar. Would you please state your name and title for the record?
Yep, good morning. Nikhil Balakumar, CEO of Eclipse and consultant for the Maryland Energy Administration.
Do you have a document in front of you labeled Direct Testimony of Nikhil Balakumar?
I do.
And does this direct testimony consist of 72 pages and include 4 exhibits, NB1 through NB4?
Yes, it does.
Your Honor, I'd like to mark for identification Mr. Balakumar's direct testimony as MEA Exhibit 7.
So marked.
Thank you. Was the direct testimony prepared by you or under your supervision and direction?
Yes.
Do you have any corrections or deletions to make to your direct testimony?
No.
If I were to ask you the same questions under oath today as in your direct testimony, would they be the same or similar?
No. However, as Ms. Lombardi said yesterday as well, given the removal of the fully forecasted test year and the upcoming exhibits we're expecting or have been filed, you reserve the right to update our investment numbers.
Thank you. Your Honor, I'd like to move Exhibit MEA 7 into the record evidence.
Without objection, so entered.
Mr. Balakumar, do you also have a document in front of you titled Public Surrebuttal Testimony of Nikhil Balakumar, totaling 77 pages, and which includes public exhibits NBSR 3, NBSR 5, and NBSR 7?
Yes.
Your Honor, I would like to mark for identification Mr. Balakumar's public surrebuttal testimony and accompanying exhibits as MEA Exhibit 8.
So marked.
Was this public surrebuttal testimony prepared by you or under your supervision and direction?
Yes.
Do you have any corrections or deletions to make to your public surrebuttal testimony?
No.
If I asked you the same questions as in your public surrebuttal testimony under oath today, would they be the same or similar?
No, but similar to my previous response, we reserve the right to update our numbers and briefs based on the fully forecasted test year removal.
Your Honor, I'd like to move Exhibit 8 into the record evidence.
Without objection, so entered.
Do you also have a document in front of you titled Confidential Surrebuttal Testimony of Nikhil Balakumar, which consists of 77 pages and includes 4 confidential exhibits, NBSR 1, NBSR 2, NBSR 4, and NBSR 6?
Yes.
And NBSR 6 contains 3 subparts, correct?
Correct.
And does this also include the public exhibits NBSR 3, NBSR 5, and NBSR 7?
Yes.
Your Honor, I would like to mark for identification Mr. Balakumar's confidential surrebuttal testimony as Exhibit MEA Exhibit 8C.
So marked.
Was the confidential surrebuttal testimony prepared by you or under your supervision and direction?
Yes.
Do you have any corrections or deletions to make to your confidential surrebuttal testimony?
No, but it was previously said a caveat of we reserve the right to update our numbers and briefs.
And to clarify, you mean you would answer the same but for the numbers?
Correct.
Yes. Your Honor, I would like to move Exhibit 8C into the record evidence.
Without objection, so entered.
I would like to confirm I've moved all 7, 8, and 8C into the record evidence. Thank you.
Yeah.
Your Honor, this witness is available for cross-examination.
AOPA.
Your Honor, I have no cross-examination, but I just want to have some data responses admitted. I'm going to ask the witness a couple of questions about them.
Okay. Yeah. What? What's that?
Your Honor, I just passed out copies of data responses to Mr. Balakumar. It's AOBA Data Request 1, responses 1-1, 1-2, 1-3, 1-4, and 1-5, which I'd like to have marked as AOBA Exhibit 17.
So marked.
Mr. Balakumar, do you have that in front of you?
I do.
And are you the sponsor of those data responses?
I am.
And are these true and correct to the best of your information, knowledge, and belief?
Yes.
Your Honor, I would like to have AOBA Exhibit 17 admitted into the record.
Your Honor, I have no problem with the admission. I would like to note for the record that this data request response includes an objection within it that we would request that the Commission also consider when it considers this exhibit.
What objection?
It says MEA objects to these data requests to the extent they are overly broad, require legal conclusion, or seek information that is irrelevant, confidential, privileged, otherwise non-disclosable under law, or uniquely within the knowledge of the requester. Without waiving those bases for objection, MEA provides the response.
So with us noting that objection, you don't object to it being
admitted into
okay. Under those circumstances, without objections, so entered.
So, Your Honor, I just want to understand what that means. Does that mean that the objection is not being asserted?
Apparently.
Because
I do not have an objection to the moving of the document into the evidence.
So are you withdrawing the objection? Or you just kind of want us to take this, that you're not a big fan of it, but you'll let it in? I mean,
that's the way I interpreted it.
I wanted it to be noted for the record that this answer had an objection, and without waiving those objections.
But this is the time
Right.
Yes.
to assert those objections. So you're either waiving them or you're not. I don't care which you do. I just want to make sure, everybody wants to make sure we're clear on what you're doing.
Yeah, we do not have an objection to this going into the record.
All right, so
it's
you're
waived.
waiving it.
Okay, yeah.
So
Okay.
we need to be clear. Are you waiving? You're asserting an objection. You're asserting it now. Are you then waiving it by allowing it to come in, or are you objecting to the admission of the document? You have to one or the other.
Yes, I will waive the objections for purposes of inclusion into the record.
Okay. And are you waiving the objection? So you're waiving the objection.
Yeah.
At this point, yes.
Thank you.
Okay.
That's all I have, Your Honor.
Okay.
Did you say it was admitted?
It's admitted. Right. People's Counsel.
We don't have any questions for this witness, but good morning, Mr. Bella Kumar. How are you?
Good morning. How are you?
So I guess one line of friendly cross. So.
Okay.
No objection.
Yeah.
Okay. Staff.
Staff has no questions. Thank you very much.
Pepco.
Could you turn to page 32 of your direct testimony? It's been marked as MEA Exhibit 7 and admitted. Let me know when you're there, sir.
Page 30?
32.
32.
And I'm focusing on lines 4 through 9.
Oh, damn it.
Yes.
And there you indicate that Pepco should develop an integrated data platform that serves as a one-stop shop. Is that correct?
That's correct.
And how much would the development of an integrated data platform cost to implement, if you know?
That would vary depending on the utility and the requirements. Our recommendations were focused on going through a process to figure out these details and ultimately propose such a solution.
And do you have any idea what it costs other utilities to implement such a process, sir?
I have a range, but it really depends on the specific data types and requirements and the specific capabilities of the utility. I will say we jointly scoped a data platform with Commonwealth Edison, which is under review in their investment plan today.
And what was that range, sir?
Yeah, so that range was approximately $29 million up front and $11 million annual reoccurring. I would note this platform is meant to address multiple needs, both internally within the utility and externally. But it was considered a foundational investment for grid modernization.
And Commonwealth Edison, is that a utility that serves the greater Chicagoland area in northern Illinois?
That is correct.
And if Commonwealth Edison or Pepco implements such a program, should those costs be recovered from customers?
I didn't speak to recovery specifically, but that is typically how it's done across the country. Correct.
I need to get an exhibit marked, and I believe I am on Pepco Exhibit 51.
That's what we have. Yep.
May I approach the witness, Your Honor?
Yes.
Sorry.
What number is this?
Oops.
Mr. Balakumar, I hand you what I asked be marked as Pepco Exhibit 51, and those are MEA's responses to Pepco DR 173, 174, and 175. When the DRs came in, there wasn't a sponsor listed, but it was directed to your testimony. So is it safe to say, sir, that you are the sponsor of these 3 data request responses?
Yes.
If you could, so I would move the admission of Pepco Exhibit 51, Your Honor.
Without objection, so admitted.
Oh, I'm sorry, Your Honor. This exhibit did have an objection, which I do not waive.
All right.
Both questions.
You are objecting. You want to make a counter argument to this?
Sure. First of all, if there should have been an objection, they should not have answered and they should have filed a motion here. I mean, they say they object, but I'm just looking at items 1 through 3 here. This question is not overly broad or unduly burdensome. He was able to provide an answer.
Overruled. I'll allow it.
If you could, sir, look at DR 1-73. Does that indicate that you're aware of 3 states that have implemented a platform?
At the time of this discovery, yes. Since then, there's been additional developments.
Right. And so these are the 3 states that have the integrated data platform in full implementation. Is that correct?
Correct, or a version of it. Integrated data platform is a broad term for a lot of different data types.
Okay. And then I asked you each state that has under development. Do you see that, sir?
Yes.
And in DR 1-74, you were able to identify Massachusetts, New Hampshire, and Illinois, the ComEd plan and the Ameren UE plan.
Correct.
And then in DR 175, which has been admitted as Pepco Exhibit 51, I asked you beyond the items in 173 and 174, you're not aware of any other state-wide data platform initiatives. Is that correct?
That is correct.
So based on your expert knowledge, you're only aware that there are 6 states that have a platform or will have a platform. Is that correct?
To my knowledge, that's correct.
And so 44 states do not have an integrated data platform. Is that correct?
Objection. I would want to note that Mr. Balakumar's response said it would be overly burdensome to identify each state. However, if Mr. Balakumar can respond, I would like to note for the record that he did say that as part of this response.
Let me rephrase my question.
Well, you can say that on redirect, can you not?
Sure.
Proceed.
Mr. Balakumar, you're only aware of 6 states that have it. Is that correct?
So I think there's a little more nuance to this question of, an integrated data platform as the way we were proposing it was a more modern, automated, electronic way of sharing data from utilities to third parties. There are platforms across the country and several states that are sharing data today with third parties. I mean, the point we were really making is the way the data is being shared right now is incredibly difficult to access and creates significant barriers for DER integration, utilization, and broader, third-party markets. And so I would say data sharing is happening across the country. There's, utilities have published hosting capacity maps across the country. They have a few of them have implemented a version of what you would call green button, attempting to share customer data. The challenge is a lot of these platforms and solutions aren't working the way they're supposed to. And so part of what we're proposing is a new modern way forward.
Fair enough, sir. And you would agree with me that Pepco uses a form of green button?
A form of it, yes. To the degree to which it works and helps out third parties is a different question.
All right, I want to talk to you, sir, about NWA screening processes.
Sure.
I need to get an exhibit marked, and it would be Pepco Exhibit 52.
Thank you.
You're welcome. Sure. Fran. Mr. Balakumar, I've handed you an exhibit that I asked be marked as Pepco Exhibit number 52. again, there was no sponsor listed when I got it, but it's asking a question about your direct testimony at page 42, lines 18 through 22. Are you familiar with this exhibit, sir?
Yes.
And you are the sponsor of that exhibit, sir?
Correct.
So I would move the admission of Pepco Exhibit 52.
So marked and without objection, so admitted.
Now, this question asks you to identify the states that you're aware of that have adopted a formal NWA screening methodology. Is that correct?
Correct.
And if I counted right, you've identified 4 states. Is that correct?
Yes. I mean, this list was, what we could put together in the time we had. It is not exhaustive, but this is the list we could put together in the time that we had.
Okay, so do you know when we sent you this data request?
We've had quite a few over the past couple of months. I cannot recall the date.
And you know that you have a continuing obligation to update data requests if you find more states?
Yes. I mean, to amend my response, these were the non-wires alternatives frameworks we were aware of at the time, but it was not we did not do an exhaustive analysis to find every framework in the country.
Okay, so these are the only 4 that you're aware of that have a formal
Objection,
NWA?
Your Honor. First, this is asked and answered. And second, the response starts with Mr. Balakumar is aware of multiple state regulatory commissions, including, so the 4 that he's listed.
And my question was, what other ones are there?
Overruled, I'll allow the question.
The discovery reflects the frameworks we are deeply familiar with.
Okay, but it says there, as your counsel points out, you're aware of multiple commissions. What other commissions are you aware of, sir?
It's a long list, but I mean, Maine, Connecticut, what else do we have here? New Jersey, Oregon, Washington. There are quite a few. I work in a limited number of states on a day-to-day basis, so I provided the ones that I have worked on and I'm deeply familiar with.
But that wasn't the data request question, correct?
Correct. I mean, it's again, as you work in the industry, you talk to a lot of folks. You are generally aware of everything that is going on. Do I know, has the framework been approved? Has it been proposed? Are they just talking about it? There's a lot of unknowns there. And so, the way I interpreted this discovery was, what are the frameworks that I'm truly aware of that are in place that, are being implemented? And so that's how I answered the question.
Okay, so you're just truly aware of these 4?
Correct.
All right. Would you agree with me that New York was put in place in 2016?
To my knowledge, yes.
And California was put in place in 2018?
To my knowledge, yes.
And Massachusetts was put in place in 2024?
To my knowledge, yes.
And that's what it says in the data request response?
Correct.
And then, last but not least, Illinois was put in place in 2025. Is that correct?
So this framework was the latest framework that Commonwealth Edison had put into place. My understanding, though, is ComEd had implemented non-wires alternatives before that. Was there a formal framework? Not to my knowledge.
Need to get another data request marked, Your Honor, be Pepco Exhibit 52. 53, I'm sorry.
I think we might.
Here's what's been marked as
We need
Pepco.
another one.
Oh,
Hold on.
I'm sorry.
I think, need another one for Commissioner.
I hand you what's been marked as Pepco Exhibit 53. Sir, are you familiar with that?
I am.
And are you the sponsor of that?
I am.
Now, when you say a formal non-wires screening process, you mean specifically identified and required to be conducted by the company, by the regulated utility. Is that correct?
So my interpretation of that is two sides to that. Either a commission-approved framework or the utilities updating their planning processes on their own to implement such a framework.
Okay, fair enough. Now, in this response, you indicate that it is frameworks, right? And would you agree with me that a framework is not a formal NWA screening process?
I think framework can be interpreted rather broadly. I would interpret that as a process. A framework would include a process within it.
Okay.
Or
Would you
could
agree?
at least.
Would you agree with me that Pepco has a process?
As of, I believe you mentioned yesterday, and we saw it in the record that as of 2025, Pepco has a documented process.
And as of 2024, Commonwealth Edison has a documented process.
Commonwealth Edison has a documented process as of 2024, but to my knowledge, they were deploying non-wires alternatives in 2018 and 2019.
Okay. Is it your testimony that Pepco has not deployed any non-wire alternatives in its service area, sir?
I believe we asked Discovery on that, and to my knowledge, that is correct.
So you're not aware that Pepco has a battery storage facility at the Montgomery County bus barn located on Linden Lane in Montgomery County?
When I'd have to find the Discovery on this, but when we asked, and I guess our Discovery was had non-wires alternatives been deployed in the last 10 years, I believe our Discovery said none had, so I was not aware of that. But I'd have to go back to the Discovery.
Would you agree with me that the Discovery said, had we deployed non-wire alternatives to delay a substation?
Could you repeat the question?
I won't belabor the point. You're not aware of whether or not Pepco has deployed battery storage systems in its service territory. Is that correct?
Based on the Discovery and what we saw, I was not aware of that now.
Okay. Are you aware of the fact that Pepco has had employed on its system conservation voltage?
I was aware of that.
And isn't that a non-wires alternative, sir?
That would depend on the framework and how you interpret non-wires alternatives. I mean, as it specifically relates to this case, and when we looked at the White Flint substation, we looked at a variety of solutions, and yeah, it includes a broader suite of solutions. Yeah.
I'm not asking about the White Flint substation, sir. I'm asking about on Pepco's system. Pepco has had various non-wire alternatives in place in 2015 and 2016 because we've had conservation voltage on our system since then.
Objection. Is counsel testifying?
I'm asking him a question.
I would say, yeah. Oh, sorry.
Overruled, I'll allow it.
Yeah, could you repeat the question?
Are you aware that Pepco has had conservation voltage on its system since 2015?
I'm aware that Pepco has had conservation voltage. I was not aware of how long that has been available.
Okay, and it's been reported in Empower Maryland reports for quite some time.
I haven't looked at the Empower Maryland reports, but I'm aware that Pepco has that capability.
Okay, and are you aware, sir, that Pepco has had various load management programs that customers can enroll in?
Yes, generally.
And that's a non-wires alternative, isn't it, sir?
If used in that context, yes.
And you would agree with me that Pepco uses it in that context. Is that correct?
I mean, as you'd spoken to before about previous non-wires alternatives that Pepco's implemented, I'm not aware of a specific not successfully implemented non-wires alternative using demand response or customer programs.
So you're just not aware of whether or not Pepco uses demand response. Is that correct?
Objection, Your Honor. This is going beyond the scope of his testimony and also is asked and answered.
I'm happy to address both of those.
I'll overrule. Well, look, I'll overrule the objection, but wind it up.
Fair enough. That's the last question on this topic.
Could you repeat the question?
Yes. Are you aware that Pepco has had demand response on its system since 2015?
I'm aware Pepco has had demand response for quite some time. Whether demand response is used as a non-wires alternative, I have not seen that. And a non-wires alternative being specifically for deferring distribution system upgrades.
I need to get another exhibit marked, Your Honor, but I would move the admission of Pepco Exhibit 53.
Without objection, so entered. No, not really. But he's been.
Mr. Balakumar, I've handed you what I asked be marked as Pepco Exhibit 54. Is this MEA's response to Pepco Data Request 166, sir?
Yes.
And it's directed to your testimony, so I assume that you're the sponsor. Is that correct, sir?
Yes.
All right. And does that indicate that you identify in this response the 2018 decision that established the formal NWA screening process in California? Is that correct?
It wasn't called that, but yes, that is generally my understanding.
I need to get another exhibit marked. It's Pepco Exhibit. I do. I'll move the admission of 54, Your Honor.
Without objections, so admitted.
So, Mr. Chairman, I just want to make clear that anytime we move these into evidence, that MEA counsel understands that she's waived her objection.
Yes, because in this instance, I will state in.
Right, we're not asking for a blanket waiver of all of your objections, but
That's
every
correct.
time it comes into evidence, you understand you've waived your objection.
I understand, and for this one, that is correct. The objection here was only about.
Well, you don't have to explain that. You're just
Okay.
affirming the fact that you're waiving your objection.
I appreciate that clarification.
This would be 55.
Mr. Balakumar, I hand you what I asked be marked as Pepco Exhibit 55, and that's MEA's response to DR 164. Is that correct?
That's correct.
And again, that references your testimony, and you are the sponsor. Is that correct?
Yes.
And this DR cites the commission proceedings that approved the Reforming Energy Vision that sets out the non-wires alternative framework in the state of New York. Is that correct, sir?
Yes.
And you're familiar with that framework, sir?
Yes.
And that's one of the states that you've worked in, sir?
Correct.
And I also note, sir, and I think we've talked about it a little bit, but I want to make sure I understand. You also are part of, at your direct testimony, sir, page 4, lines 9 through 11. You're also part of the Illinois work group that's doing the grid modernization both for Commonwealth Edison and Ameren UE. Is that correct, sir?
It's a work group, I guess. We've been in their past proceedings. We are in a variety of work groups, and we are collaborating jointly on several initiatives with both utilities.
And you're familiar with what's going on in that work group, is that correct?
A little too much.
I appreciate that. Did you participate in the work group when the New York staff presented its non-wires alternative to the Illinois grid plan in May 6th, 2025, that's been admitted into the evidence here as Pepco Exhibit 13?
I have not, not in that particular work stream at the time. My involvement in the non-wires work in New York was really from 2017 to 2021. We still work there, but not aware of that specific filing.
I'm sorry, this
Yeah.
is about the Illinois work group. This was a presentation given to the Illinois Grid Plan Workshop.
Oh, to Illinois.
Yes, and
Okay.
I'm sorry if I
Yeah.
misstated my question. Let me restate that and avoid the confusion. Did you attend the Illinois, are you participating in the Illinois Grid Plan Workshop?
The Illinois Grid Plan Workshop is a series of workshops throughout the year. Whether I participate in that particular day, I do not know.
Okay, so you're not aware of the New York State Department of Public Service presentation on non-wire alternatives in New York?
I don't think so, no.
All right. Sir, at page 44 of your direct testimony, you discuss the fact that Pepco's sister utility, Commonwealth Edison, has non-wires alternative screening process. Do you not, sir?
Correct.
And would you agree with me that ComEd did not have a formal non-wires screening alternative process in place in 2027?
2027, next year?
Or
Yeah.
2017?
2017. So, the difference here is, and I'd mentioned that dichotomy of, what is required statutorily or by the commission versus what the utility may have in place on their own. So my understanding is ComEd had their own internal screening and framework in place in 2017 through 2020 or 2023, and then the Climate Equitable Jobs Act passed in 2023, which required them to publish it and have it formally available as part of their multi-year grid plan.
Right, and so the formal plan was adopted, I think, in 2024, is that correct?
Correct, yeah, the commission approved that grid plan.
And so before then, they had an informal process that the company undertook on its own, is that correct?
Yeah, that is correct to my understanding.
Need to get another exhibit marked, Your Honor. It'd be Pepco Exhibit, I'd move the admission of Pepco Exhibit 55.
Without objection, so admitted. And yeah, 56 would be the next one.
Your Honor, I do object to this Pepco 55.
You know what? I asked without objection. You didn't object at the moment.
It was an assumption of without objection.
Well, I didn't say it super fast, though. I didn't and I am known to go really fast
That's
at
fine,
times.
Your Honor.
Let me hand you what I asked to be marked as Pepco Exhibit 56. Now, Mr. Balakumar, in your direct testimony, you cite to the ComEd multi-year integrated grid plan, the refiled grid plan. Is that correct?
Correct.
Okay. And specifically, you cite to Chapter 4 of that grid plan. Is that correct?
That is correct, my understanding. I think I
And
cited
so-
a couple places.
Yeah, and I'm not trying to trick you, sir. What I did here, just so we can all get on the same page and I can try to avoid objections, I've got the cover page of the grid plan that is dated refiled grid plan March 2024, and then I've attached Chapter 4 that you cited in your testimony, capacity expansion investments. Do you understand that, sir?
Yes.
And you're familiar with that, sir?
Yes.
All right. Thank you. Could you, sir, turn to page, and I'm looking at the bottom of the page, page 17 there, sir, and it's figure 4.7 at the top.
Yes, I'm there.
Does that set out the NWA framework process that is used by Commonwealth Edison, sir?
At the time of this filing, yes.
And is it your testimony that that has changed?
We're in a live grid plan right now, so a lot of things are evolving, but I would say this is the latest one used to inform the most recent investments.
And this is indeed the plan that you cited in footnote 77 on page 45 of your testimony, specifically pages 17 through 20, correct?
Correct.
Now, let me ask you, you've reviewed Mr. Allo's rebuttal testimony, is that correct?
Yes.
And you've looked at TOA R-1, is that correct?
Let me pull that up and confirm, but I believe I have.
And you have it up there with you, sir?
I do.
All right, could you turn to Allo rebuttal schedule TOA-1? And I'm looking at page 14 of 106, sir.
Yep. Give me 1 second.
Yeah, thank you. That's where it starts.
Could you give me the reference
sir.
again?
Page 14 of 106, TOA R-1.
14. I'm there.
All right. And could you, sir, would you confirm with me that that is the Pepco Holdings non-wire solution evaluation, sir?
Yes, published in 2025, correct.
100% published in 2025. Now, looking at page 17 of the ComEd plan that we talked about, figure 4-7, and
I'm there.
Could you turn to page 27 of 106 of TOA R-1, sir?
Yes. I'm there.
Would you agree with me that both ComEd and Pepco have a very similar screening process? Is that correct?
I have not reviewed the 2025 Pepco requirements in detail. I could provide a high level assessment, but I didn't review the 2025 NWA framework because, as relevant to our case, we are focused on what happened in 2017, 2019, 2022, and I would love to read this on a Sunday morning with coffee and figure out how we can collaborate on it in the future, but I have not reviewed it.
So you didn't think it was important when you put together your
Objection,
testimony?
Your Honor. That's argumentative.
Sustained.
Nonetheless, Pepco has a NWA framework process. Is that correct?
As of 2025, that is my understanding.
And a written one. And our sister utility, as of March 2024, had a published framework. Is that correct?
Objection, Your Honor. The witness has explained the scope of his testimony, and this is beyond that scope.
No, it's not. Part of this witness's testimony is that Pepco should adopt a formal NWA solution and a formal framework. And so I'm asking him about that part of his testimony. That is clearly one of his recommendations.
Overruled.
Could you
Answer the question, please.
Could you repeat the question?
ComEd's plan, written, formal, NWA solutions plan was filed on March 2024. Is that correct?
The original statutorily required plan was filed January 2023. As I'd said before, ComEd had their own process that was not required to be formally filed before that.
Mm-hmm. And you would agree with me that Pepco had its own process before it filed, or before it created its written process in 2025. Is that correct?
My understanding is, at least from the White Flint example, that, non-wires alternatives were, supposedly evaluated, at least informally. Whether there was a formal process to do that or not, we don't have any evidence or documentation of that. Just that there was an informal analysis per witness allo.
And the only thing you asked about, you being MEA, was the White Flint project. Is that correct?
In general, or could you be more specific in your question?
In general.
As it relates to non-wires alternatives?
Yes.
In this case, we were focused on the investments in this case, and so yes, we were focused on the White Flint substation. As part of that, per our analysis and our recommendations, that investment and how it was performed and the information of the company at the time raised serious concerns for us, and so we made our recommendations there on the investment itself, but we also put down, as witness Lombardi said, forward-looking recommendations because, what we saw here was very concerning. And so for us, it was this investment should be addressed here, but we put forward-looking recommendations because, we wanted to make sure this never happens again. And we think it's at the full discretion of the commission to make sure that that happens in this case.
And in fact, Pepco produced this document that we're talking about in response to a MEA data request. Is that correct?
The 2025?
Yes.
Yes.
And so you would agree with me, even though there's no commission requirement for Pepco to have such a document, Pepco has prepared such a document. Is that correct?
Yep. As of 2025, but not at the time of the White Flint evaluation, which was the focus of our testimony.
And so does that mean that in this testimony, MEA is not requesting the direction that Pepco implement a formal NWA processor?
So as you had mentioned, Pepco has developed this on their own. We have not reviewed it. We're not sure, frankly, what my personal position or MEA's position is on that. So we would have to review that. But I think regardless, I think we would continue to recommend the commission direct this and memorialize it, and ensure stakeholders have input on that.
Would you turn to, could I move the admission of Pepco Exhibit 56?
Without objection,
Mr. Mike
so
Heel,
admitted.
Mr. Mike Heel, and I don't know if this is just me, my copy only has the odd pages. I'm not sure if that's your intent, and I'm not looking to kill more trees.
Is that true for everyone? I'm so sorry.
It's okay.
Yeah.
It's
Yeah.
it's
It's not a problem.
the odd
You ask
page.
questions on the odd pages.
yeah.
Right.
Well, It's
Yeah.
odd that you say that, but I think I do only have question on the odd pages. But that is not why I did it, and I will provide, and my apologies to the commission, I will
I just
provide.
want to make sure the record was
No.
clear, so
Very good. I will get,
no worries,
I
no
will get a
worries.
copy at lunch, and we'll have,
Odd and even.
I'll press the right button on the copier.
Who among us?
Sir, luckily for us, well, maybe not.
Yeah, right, 20s.
Could you turn to page 13, which I think you have?
Let's find
I
out.
think everybody has that.
Of the ComEd grid plan
Yes, the
attachment?
ComEd grid plan. I'm sorry.
I am there.
It says there the existing tools used for forecasting and planning at ComEd are over 20 years old, and updates or additional functionality are not supported. Is that correct?
That is what it says.
And then at page 11 of that document under load forecast, it indicates that for the capacity planning team starts with the probabilistic peak load for the 90th percentile or the 90-10 weather conditions. Is that correct?
Could you tell me which paragraph that is?
Yeah, it's the third paragraph under B load forecasting, sir. On page 11.
Yes, that's part of ComEd's planning process.
Okay. Thank you very much. I'm going to leave that document because I only have the odd pages. And I will get the right document after lunch. Again, my apologies. Need to get another exhibit marked, Your Honor. The Pepco Exhibit 57.
Thank you.
Thanks. There we go.
Mr. Balakumar, I hand you what I asked be marked as Pepco Exhibit 57, and that is MEA's response to Pepco Data Request 154. And it goes to your direct testimony, page 8, line 1 through 8. Are you indeed the sponsor of that data request, sir?
I am.
And you're familiar with that answer, sir?
Yes.
Your Honor, I would move the admission of Pepco Exhibit 57.
Without objection, so admitted.
All right, sir, could you turn to your, sir, rebuttal testimony?
Yes.
Do you have a page number?
Yes, sir. I just wanted you to get there. Could you turn to page 21, lines 1 through 3, sir? And let me know when you're there.
I am there.
Let me get there. I'm so sorry.
No, take your time.
Um,
Actually, can I respond to the original discovery you provided?
there's no question
yeah.
pending.
Okay, will do.
And there you provide on page 21, lines 1 through 3, you note that the Orange and Rockland West Warwick project is documented in the New York Public Service Commission case 17M0178, and that the West Warwick Battery Storage System Annual Report was filed on December 19th, 2025. Is that correct?
Yes.
And, sir, in your, I believe it's Schedule NBSR 7,
Nailed it. There's a lot of schedules.
you attach, I believe, 3 documents, and let me go through these and you tell me if I got them right. You attach the Orange and Rockland Annual Report that was filed December 19th, 2025. Is that correct?
Yes.
You attach the Orange and Rockland petition filed on February 13th, 2027. Is that correct?
Yes. Or 2027?
I said 2027
Yeah.
again. I'm looking forward to that year
Yeah.
for a
Me too.
forecast. Yes, I'm forecasting.
It's been a long year.
That's my retirement forecast year. For 2027, sir, I'm sorry. And then I believe you also attached the Orange and Rockland press release dated May 15th, 2023. Is that correct?
Correct.
All right. Now, could you turn, sir, to your NBSR7? And I'd like to first talk to you a little bit about the attached petition of Orange and Rockland there. And I don't know what page it is because I didn't see page numbers, sir, on this, so I can't cite to a page.
Yeah, no problem. Let's figure it out.
Yeah.
NBSR, so here we go. And
And
this would be the West Warwick Annual Report?
No, it's the filing made. It's the petition of Orange and Rockland signed by Enver Acevedo.
Okay, I'm there.
Okay, you've got that?
Yep, yes, sir.
All right, thank you very much. Would you agree with me, sir, that on page 23 of that document, that's where Orange and Rockland is making the non-wires alternative request. Is that correct?
Let's see here.
It's on page 23, top, Roman numeral 3, non-wires alternative.
Yes, I believe they talk about several different projects here, but yes, I generally believe this is where
Right.
West Warwick was included.
Right, and this is the document that you gave me, right?
Yes, I've been reviewing a lot of documents. I needed a refresher, but yes,
Sure.
you're correct.
Take
yeah.
your time and let me know when you're ready. If you could, sir, would you agree with me on page 24, first paragraph, that it says the company is proposing recovery of the costs for the West Warwick battery over 10 years through an energy cost mechanism? Is that correct? An ECA is what they call it?
Correct.
And that's a rider that would give Orange and Rockland recovery of those costs. Is that correct?
Yes.
And they're also requesting that the benefits of this project be split 30 and 70 between customers and shareholders. Is that correct?
Yes, to my understanding.
Okay. And so any benefits that are achieved from this project, customers get to keep 70% of those, and shareholders get to keep 30% of those. Is that correct?
Yes, under this specific proposal from Orange and Rockland.
And that's consistent with the proposal in New York that you're very familiar with. Is that correct?
Yeah, generally there was a benefit sharing mechanism that would flow down back to customers.
Okay. And you would agree with me that they're asking for cost overruns or underruns will be split 50-50 between Orange and Rockland and its customers. Is that correct?
That is what it says.
And that's consistent with the New York framework for NWA?
I believe this was specific to Orange and Rockland's request. This was a evolving framework at the time, and there was some flexibility across utilities. But I believe this is specific to Orange and Rockland, to my knowledge.
To your knowledge. That's fair enough. And then if you could turn to page 25, sir, it says incentive report, or incentive structure.
I'm
You
there.
See that?
I'm there.
And it says, the company proposes to establish a financial incentive applicable to all of its future NWA projects consistent with that approved by the commission for Con Edison. Is that correct?
Yes.
And so does that indicate that along with Orange and Rockland, at least Consolidated Edison in New York has this same kind of incentive? Is that correct?
Correct. I would say that, while there was an incentive in New York, I think all utilities have an obligation to propose and invest in the most cost-effective solutions.
Yeah, I'm just focusing on this document that you put in for Orange and Rockland, sir.
Sure.
And then in the Con Edison, they're authorized a 70-30% sharing of the net benefits between customers and shareholders, respectively. Is that correct?
That's what it says. Correct.
And that's consistent with the plan in New York, correct?
Yes. At the time.
And has that changed, sir?
I believe there's several different avenues for non-wires alternatives now, and different cost-sharing frameworks that are continuing to be explored. And so it's a live issue that's still being iterated upon, but at the time, this was the split, correct?
And you don't know whether or not that's still in place?
We're iterating through that at the moment.
Okay. And what docket are you iterating through that in the moment in New York, sir?
I would have to find the case number. I don't have that on me, but I'm happy to provide it.
And what is your involvement in that iterative docket, sir?
I represent the Joint Solar Parties, or the Solar Energy Administration, or SEIA. I'm forgetting the trade association for the DER industry, and so we've been working through this for several years, and I worked directly with the commission in a previous capacity.
Okay, is your client in New York supportive of these type of incentives?
Yes, and I think as my direct testimony stated, we retracted this as Joyce, Ms. Lombardi said we're going to include this in the cost control petition, but we did include a performance accountability framework, forward-looking, to address the incentive gap.
Okay, and so you're aware that you're going to include that in the petition, is that correct?
I can't speak to the petition itself. I know that this was in my direct testimony, and we withdrew it, for consideration along those lines.
Could you turn to page 27 of that document, sir? I'm looking at the last paragraph there. It says, further to spur the company to manage and reduce costs associated with an NWA project, Orange and Rockland proposes to adjust the incentive as necessary throughout the NWA project implementation, consistent with the Con Edison shareholder incentive proposal. Is that correct?
That's correct.
And so that's the framework that the West Warwick project went forward under. Is that correct?
Yes, to my knowledge.
You also had attached to your testimony, I believe you said you had attached the press release. Is that correct?
That's correct.
And does that press release indicate that the project was started or was put into service in 2023? May 15th, 2023?
Yes.
And in that press release, I think at page 3, it notes that the battery is under the Climate Leadership and Community Protection Act passed in 2018 in New York. Is that correct?
Yes.
All right. You also attached, I believe, in that schedule, the annual report for the West Warwick Battery Energy Storage Project dated December 19th, 2025. Is that correct?
Yes.
And if you could, sir, turn to page 2 of that document, and it talks about lessons learned. Do you see that, sir?
I believe I have this one. Give me 1 second.
Okay.
Yes, I'm there.
And so in the first bullet, it indicates under lessons learned that there was a fire at this battery in 2023. Is that correct?
Yes.
And so they needed to replace the batteries at that project. Is that correct?
Yes, and I want to be clear here that when in Mr. Ello's rejoinder in live rebuttal, the fire speaks to part of the story, but doesn't speak to why the fire occurred. The fire was due to weather and water issues, is not due to the technical viability of the battery. In fact, the battery discharged all of last year 45 times for a total of 2,437 megawatt hours. I would also note that as several of these documents say, Orange and Rockland also deployed another battery in 2020 with the same vendor, which has had no issues and is continuing to perform today. And so when you look at those two examples together, the battery itself and its technical viability and performance is not in question. It was a water and weather related issue.
And the battery that Orange and Rockland put in from that particular vendor simply leaked.
Leaked as in
Let water get into the battery, which caused a reaction with the lithium-ion battery, and it caught fire.
Yeah, an external weather-related event, not due to the actual technical chemistry or viability of the battery.
Okay. And you would agree with me that in the Pepco exhibit that Pepco put in, it indicated that Orange and Rockland produced a root cause analysis that indicated that the 2023 fire was caused by a manufacturing defect in the Powen branded Centipede model battery, allowing water to get into that battery that caused the fire. Is that correct?
Objection, Your Honor. Can counsel provide a document or anything that
I can.
which he's referring to?
I can.
And I don't know if Mr. Balakumar has knowledge of that.
Yep.
He does have knowledge about the water damage related to the battery.
May I approach the witness, Your Honor?
Yes.
I hand you what's been marked and admitted in this case as the Pepco exhibit. One second. I got the wrong one. Pepco exhibit 16. And Pepco exhibit 15. Does that indicate on the highlighted on the top there that a manufacturing defect is the cause of the battery fire?
It does.
And
I'll overrule the objection since you have the document.
so it was a manufacturing defect. Is that correct?
Yeah, that is what it states. I will say, this is one example in one of these cases. Orange and Rockland used the same vendor in 2020 and has a battery still operational today as part of their Pomona project that has had no issues to date.
And you would agree with me, sir, looking at the lessons learned there on page 3 that you attached in the annual report, that Powen, the battery company, filed bankruptcy. Is that correct?
Yes.
And the Orange and Rockland company noted that there's a limited market for operational software and service repairs for a battery. Is that correct?
Yes.
And that's all at the time this battery was being built and put into service. Is that correct?
I believe this is a lessons learned, so I believe that would be after the battery is put in place. But, the statement reads as it does.
And so after the battery fire, the first battery fire, that battery storage system was offline. Is that correct?
It was, and I believe they installed new batteries after that.
Okay. So they had to install new batteries after that. So they put 3 batteries in, there was a fire, and they put 3 more batteries in. Is that your understanding?
I believe they put in 2 batteries. These were 3 separate energy storage systems dispersed at 3 different locations.
Okay. Would you agree with me on the unlucky day that the company filed this annual report on December 19th, 2025? They had a second fire at the West Warwick battery storage project?
Yes, and my understanding is the initial assessment of that it was caused due to weather issues.
Okay. And so for the second time there was a fire, and that was the battery storage project was put out of business.
It's been a couple months, but I believe that battery is out of commission at the moment,
So it's not serving customers at the moment, is that correct?
to my understanding.
So they're going to have to, Orange and Rockland's going to have to find a distribution replacement to solve the issues for the lack of power being generated at that battery.
I think that's up to Orange and Rockland, but I would assume, given the battery is fairly successfully addressing some constraints, something else will have to do that.
Okay, and you would agree with me that the West Warwick battery was done by an outside vendor, Convergent Energy?
Correct.
And you would agree with me, given that there were 2 fires at West Warwick, that probably demonstrates some gaps in Orange and Rockland's vendor selection?
I won't opine on how the company selects their vendors. I'll leave it at that.
All right. And that's a successful project that you based your analysis on in your sir rebuttal testimony, correct?
Correct. And I'd like to say there's a good amount of data that showed when there weren't weather issues, when there weren't water issues, this is performing quite well to defer a substation.
And that deferred a substation. It didn't replace a substation. Is that correct?
Correct. I mean, non-wires alternatives in general, aren't typically not meant to be permanent. They're meant to defer more expensive infrastructure, so that we can have more cost-effective infrastructure in the near term. So, I would say non-wires alternatives are not meant to be permanent. They're meant to defer infrastructure.
Thank you, sir. Could you turn to page 32 of your testimony, sir rebuttal testimony? I'm sorry, sir.
$32?
Yeah.
I'm there.
And I'm focusing on line 19. That's where you start your cost-benefit effectiveness analysis. Is that correct, sir?
Correct.
And you would agree with me this is new analysis that did not appear in your direct testimony?
That is correct. We attempted to get data several times through discovery, and we finally got data right around sir rebuttal to do our analysis.
And can you identify the data request that you asked Pepco that sought this data?
Yes, it's data request 19, where we asked for historical hourly loading data. The company said they don't maintain hourly data for the past 5 years. And discovery request number 53, we asked for hourly data on the Park Lawn substation, and the data provided was in an unusable format and not all 8760 hours in the year. And finally, in data request 7, which we received a week before sir rebuttal was due, we got the data we needed to do an analysis.
Okay. And in all of those data requests that you cited, data request, I believe 531973, Pepco provided a response. Is that correct?
They provided a response, but not with the data requested, and with contradictions as well. I mean, the first one said we don't have hourly data. The second one gave it in a way that was impossible to use. And finally, we saw their data requests come in with additional data, and we're like, let's give it another try. Let's be as possibly specific as possible. And we got something we could use.
And the MEA didn't suggest that Pepco's response to those data requests were unresponsive. Is that correct?
No, I mean our testimony, our direct testimony, addressed White Flint and said we do not have enough information to assess the prudency of this investment. So that my direct testimony reflected the lack of data we were able to receive.
And if you know, MEA didn't file a motion to compel with this commission suggesting that Pepco hadn't answered those data requests. To your understanding, is that correct?
Correct.
Now, let me ask, did your cost-effective analysis, your cost analysis on the West Warwick battery account for the fact that multiple batteries were installed at that location due to the fires?
So our cost-effective analysis was focused on running an alternative analysis to the White Flint substation. We referenced West Warwick as an example.
So, could I just, this is really, did you account for the fact that multiple batteries were installed at the West Warwick project, yes or no?
Yes.
So, how many batteries at the West Warwick project does your NWA analysis assume?
So our analysis assumed, and the way we approached this was, we looked at the company's forecasts, right? And I need to
Your
provide.
Honor, I need him to answer the first question of how many batteries did his analysis assume, and then he can explain. I'm happy to have that happen.
Yeah, I believe that's correct. If you have the number, state that, and then feel free to expand upon your answer.
Okay. Yes. So our analysis acknowledges one that West Warwick deployed 3 batteries, and our alternative analysis also included 3 separate phased rollouts of a battery. And as a part of that, the reason we laid it out that way was for several reasons. One of the reasons that the company gave for why a non-wires alternative couldn't be deployed was due to land, right? And so, there's several ways you could do this. You could deploy one big battery on a piece of land. You could disperse them. So that was one of the reasons we chose 3. The other reason we chose 3 was, Witness Allo, continuously mentions as part of the load forecast that it was 2 things. It was increasing and it was persistent. And I would dispute both of those. When you say increasing, when we look at the 10-year forecasts between 2017 and 2019, in 2017, the forecasted overload is expected at 2022. And that's when the project initiated. In 2019, when Exelon approved this, the forecasted overload moved from 2022 to 2024. And then 2021 and 2022, as this construction was paused and we were doing this quanta study, the first overload moved on to 2025. And so as we look at these forecasts, the first overload moved out 3 years. So that's point number 1. Point number 2, as you look from 2017 to 2019, from when the project was initiated to when Exelon increased or approved the project.
Your Honor, this is way beyond the scope of my question. I asked him how many batteries were there.
Well, I told him to answer the question and to elaborate if he wanted to, so I'll allow him, but wrap it up.
Yes, sir. My final point there is, as we looked at, every 2 years at every major decision point, the forecasted overload keeps getting pushed out from 2022 to 2025. But between 2017 to 2023, in that time range of when it started and when the quanta study happened, you also see every single forecasted year, the forecasted load is decreasing. And so when we looked at that, if we were looking at this in 2017, that would raise concern. We would pause and say, well, the forecasts are going down, the forecasted overload keeps going out, maybe we should be more cautious and take a phased approach. And this is where with the 3 batteries, this is exactly why you would use a battery, where it's like the forecasts are uncertain, let's deploy the first battery, let's see what happens. And that's why we did a phased approach of 3 batteries.
My cross-examination in any way, shape, or form.
I think we got your explanation.
Yeah. Thank you.
Mr. Balakumar, you're not an engineer, is that correct?
I'm not, but as my testimony states, I have over a decade of experience in this industry. I've worked for utility technology companies, ER technology companies, and I'm jointly collaborating with several utilities, including National Grid, ComEd, Ameren, on very technical issues and joint programs.
And you would agree with me, sir, that you've never performed a load study, is that correct?
I would not say that. We've participated in several non-wires alternatives processes where we've been given data that we could analyze to assess how you would assess a non-wires alternative.
And you've not performed the study, is that correct?
We've performed studies with our teams looking at this data to assess how that forecast would inform investments.
And you're not here to offer your engineering opinion on anything because you're not an engineer, is that correct?
I'm not an engineer, but I think if 3 utilities are working on us with joint programs that are rolling out that are completely refining how we do distribution planning, interconnection operations, I think I'm qualified to speak on this.
Okay. So it's now your testimony that you're qualified to provide an engineering opinion?
I'm qualified to
Objection,
provide
Your
it.
Honor,
Yeah.
that's misstating his
Yeah,
answer.
sustained.
All right. Would you agree with me, sir, that your analysis at page 33, line 21 through 28 of your rebuttal testimony uses battery costs from 2021 to the 2027 period? Is that correct?
I'm sorry, what page and what line again?
Page 33, lines 21 through 28 of his rebuttal testimony. I'm focusing specifically on line 23, 2021 to the 2027 period. Is that correct?
Correct.
And you would agree with me that the decision to build White Flint was made in 2027 and 2029? Is that correct? 2017 and 2019, is that correct?
You're really looking forward to next year.
I am indeed.
Yes, I would say that. And if I could explain why we did that, our entire non-wire solution analysis, our intent was to make this as conservative as possible. We used battery costs that were later on because, as you know, generally is trending, battery costs are getting cheaper. We use land costs from 2026 because land also typically gets more expensive over time. We oversized the battery to create some margin, and also we compared it against 136 million of the 256 million of the substation because we broke down the White Flint analysis, and 136 million of that we felt with high confidence could be potentially deferred. There was another 100 million that we could have been deferred, and so that could have been at 230 million, but we chose to do a conservative number just to show that at the most conservative assumptions, we feel that a battery, given our high-level assessment, could have been more economical than the White Flint investment.
You would agree with me, would you not, sir, that battery costs were higher in 2027 through the 2019 time frame? 2017 and 2019 time frame, is that correct?
That's correct.
And that's not the time frame you used. You used the 2021 through 2027 time frame, correct?
So that is the data that NREL had at the time. We tried to go back, but that's correct. Yes.
So it's your testimony that NREL does not have any data for battery costs in the 2017-2019 time period?
Objection, Your Honor, that is not what he stated.
I think it is.
He did not speak to what NREL has in
Yes, sustained.
2017.
Sir, at page 33, lines 27 through 28, you would agree with me that you assumed the useful life of a BESS system at 15 years, is that correct?
That's correct.
And you would agree with me, sir, at page 34, lines 4 through 9, you used the real estate costs for Baltimore County, Maryland, is that correct?
That is correct for 2026. And I acknowledge this. The substation was in Montgomery County, right? And so there would be land cost differences. We were trying to find a general Maryland number and doing something over 10 years out, because land costs generally increase, to be conservative.
And you would agree with me that land costs in Montgomery County, Maryland are a lot more than land costs in Baltimore, Maryland. Is that correct?
I am a Marylander and grew up in Montgomery County, so I can attest to that.
I'm a Marylander and live there.
Yeah.
You would agree with me, sir, that the Park Lawn substation is located in a very urban area. Is that correct?
I would consider Montgomery County to be more suburbs, but yes, and an urbanish suburb, yes.
Well, it's southern Montgomery County, and there's other than parkland, there's not a lot of open space. Is that correct?
That's my understanding, yes.
And so there's not a lot of space. You're suggesting your analysis is assuming that Pepco would buy 3 dispersed plots of land for the batteries that were needed, correct? Like West Warwick?
That was our assumption. As I stated before, this was our high-level analysis intended to demonstrate feasibility. Doing a full-blown analysis would require more data and more time. But the purpose of our analysis is to demonstrate a non-wise solution could have been done and should have had, and any alternatives analysis should have had the data and assumptions to justify that.
And you would agree with me, sir, at page 33, line 14 of your analysis in your sir rebuttal testimony, that it uses a net present value of the deferred White Flint substation for 15 years. Is that correct?
That's correct.
And on page 33, lines 4 through 10 of your 2 scenarios, you use a battery capacity of 48 megawatt hours. Is that correct?
That's correct.
Sir, could you turn to page 25 of your sir rebuttal testimony? And I'm looking at your table there. And I guess it's kind of close to line 1. It's the bottom of the table, sir.
Yes, sir.
And I'm looking at that second column over 2031 and the number 48.60. Do you see that, sir?
Yes.
Does that table demonstrate that based on your analysis, within 6 years, in 2031, the overload at the Parkland substation would be greater than the 48 MWH required? Is that correct?
Correct. Now, I think it's important to consider here that we're talking 15 years, right? And we were looking at this from the perspective of 2017, right? And so we would be, at 2031, we would be right around that time frame. I also think it's important to recognize that, we've been, throughout this, actually, I'll end there.
All right, and that's exactly where I'm going. The cost analysis assumes the substation, your cost analysis assumes that a substation is deferred for 15 years. But the table on page 25 demonstrates that the battery that you used in your cost analysis would be insufficient to serve that load by year 6. Isn't that correct, sir?
Can you say that one more time, please?
The cost analysis that you use assumes that the substation is deferred for 15 years, and you told me that. But the table on page 25 demonstrates that the battery you use would be insufficient by year 6. Is that correct?
Could you specify which year 6 means?
Yeah, 2031, where it's at 48.60.
So as I mentioned, right, we were assuming this battery would be deployed in 2017. This went out to 2031. That is 14 years. Part of the reason we stopped at 2031 is because that is the extent to which we had data on the 10-year forecast.
But that's what the analysis shows, that the battery runs out in 6 years. Is that correct?
Well, I wouldn't. I mean, 6 years from today, or I'd say it's 14 years, approximately 15 from when we estimated the battery would be deployed.
The table that you have in your sir rebuttal testimony shows deferrals from 2025 to 2031. Is that correct?
So that doesn't indicate the years of deferrals. That indicates, we've been, I think, throughout this week talking about hourly analysis, 8760 analysis, and Mr. Allo has repeatedly said that this is my preferred methodology.
Your Honor, I didn't ask him anything about 80/60 analysis or anything about that. I asked him about these tables, and that is not responsive to the question.
Take another shot at his question.
Could you repeat the question?
I'll just withdraw the question, Your Honor. I have anybody? I have nothing further. Thank you, sir.
Thank you.
Nice suit choice.
We're almost matching. Yeah.
Redirect?
Yes, Your Honor. Mr. Balakumar, do you recall Pepco counsel asking you about one-stop shop and data sharing plans?
Yes.
Does your cerebral testimony address your data sharing recommendation and how it changed from the direct to cerebral?
Yes. I think we acknowledge this in our testimony on two of our issues, that the company has made significant advancements regarding their DER roadmap and DERMS deployment, and specifically an integrated data platform. As part of the company's drive filing, they have committed to some of what we are asking for. They've committed as part of their drive filing to provide access to customer data. Our full recommendation was related to not just customer data, but system data and rates and tariffs data. Customer data is one part of the equation to integrating DERs and scaling their use in VPPs and other ways. Grid data is the second half of that, and the rates and tariffs component brings all that together for the market to figure out the economics. And so we acknowledge the company's advancements there, and that's why we modified our recommendation. But we continue to recommend the company commit to a broader platform that shares all the data that's needed to truly scale DER integration and utilization.
Thank you. And do you also recall Pepco counsel's questions on Pepco's NWA analysis?
Yes.
And do you recall the response you received from Pepco in response to MEA Data Request 6-1, which is included in your direct testimony, NB4, page 2?
I object. This is beyond the scope of my cross. I
It
didn't ask him
directly-
any questions about Pepco's NWA analysis.
That actually does respond to the whole line of questioning that Pepco counsel had about whether Pepco considers NWS solutions and what years it considered.
Overruled, I'll allow it.
So I'll direct your attention to MEA Data Request 6-1, which was included in your direct testimony as NB-4, page 2.
Give me 1 second. Could you repeat the discovery number, please?
It's Pepco's response to MEA Data Request 6-1. It's in your direct testimony as NB4, page 2.
Yes, I'm there.
And do you recall Pepco's response? Can you please read the first paragraph? It discusses what Pepco has done with NWS.
This is 6-1, correct?
Yes, it starts, Pepco has recently developed.
Yep. Pepco has recently developed a high-level non-wire solution guideline and analysis framework, which will be used to evaluate NWA alternatives. Please refer to Maryland case number 9820 MEA DR 61 This document provides analytical guidelines rather than prescriptive requirements and is not intended to define the detailed technical specifications of an NWS analysis or outline interconnection-related considerations for NWS alternatives.
And
But-
do you,
Yeah.
go ahead.
There's another paragraph. Would you like me to read it?
No, that's okay. And do you understand this Pepco guideline to be an internal Pepco guideline or one in which stakeholders had had an opportunity to provide input?
My understanding is it's an internal guideline.
Can you also explain how you understood the second paragraph of Pepco's response to MEA Data Request 6-1?
My interpretation of it?
Yeah, you can read it or what you understood they
I-
were saying.
I will read it and then I will speak to it if that's okay. Pepco will continue to advance its capabilities for evaluating NWAs in alignment with COMAR 20.50.15, published in 2025. Pepco has not yet received guidance from the Maryland Unified Benefit Cost Analysis UBCA work group regarding cost analysis requirements for NWA solutions. Pepco is awaiting the work group's final recommendations to ensure that any future analysis are fully compliant with the UBCA framework. And you're asking for my interpretation of that paragraph? As we're seeing it, Pepco has developed an initial framework that's meant to be guidelines, not prescriptive requirements. It appears they are, they're waiting for, guidance and regulations, before truly implementing a final framework.
Okay. And now turning to Pepco Exhibit 57, you wanted to provide a further response to that exhibit?
Could you remind me which exhibit that was? I don't think I have the exhibit numbers. Thank you.
It is, you got it? It's 1-54.
Yes. So this recommendation was made in direct testimony, right? And it says, let's see here. The Commission should not approve capacity expansion upgrades without full and transparent documentation of the company's consideration for non-wire solutions and a broad cost-benefit analysis. I think this was stated in our direct testimony before we got data to do a true analysis. I think this continues to stand. I think our arguments, go beyond that now that we have a substantive record, demonstrating that a non-wire solution could have been cost-effective, that an hourly analysis wasn't conducted, and that the company did not fully understand the full scope of the problem, and therefore could not have assessed what the most cost-effective alternative was. I want to make a point here and get back to the point I wanted to make earlier, which was that we've been talking about hourly analysis, 8760 analysis throughout the week, and I apologize if we've heard that term way too much. Witness Allo said this was my preferred methodology for analyzing solutions. I would say that if you are going to truly do a prudent analysis of your system and make cost-effective investments, you want to take all the data available to you, understand at a most granular level what those constraints are, and make investments, the most cost-effective investments based on that. In addition to that, Mr. Allo said even if they were to do an hourly analysis, he first said that they first assessed that a battery storage solution was not technically feasible, and thus they did not need to do an hourly analysis. I would argue it's the reverse. An hourly analysis is a prerequisite to developing a battery solution. We talk about hourly analysis, we talk about 8760, but what does that really mean? There are 8,760 hours in a year, and Mr. Allo said this. This peak load was persistent, right? And I would disagree with that. If let's just say you have a substation that's overloaded, there's a 2 megawatt overload, and if that 2 megawatt overload is happening a majority of the year, 4,000 hours out of the year, 6,000, the full 8760, versus what we identified as 1 hour in 2025, 6 hours in 2026, maybe 130 hours in 2031, which is less than 2% of the year. That spectrum of whether that load persists for one half of the year versus the other, we're talking about very different solutions. If we're on the 8760 side, that's where we're talking about a $250 million substation. If we're talking about 1 hour in the year in 2050 or in 2025, that's exactly the reason for deploying battery storage. Mr. Allo speaks to this and says that battery storage is for daily peaks, daily short peaks. And so the real question here is, is it prudent, is it cost effective to spend $256 million on 1 hour of the year, of 6 hours of the year? Or is there something alternative that we can deploy?
Thank you. Do you recall Pepco Council asking you questions about Warwick Battery Project? Do any of the questions Mr. McKeel asked you about battery fires change your position on the usefulness of the Warwick project in comparing the decision timeframes and analysis process Pepco used in scoping
I'm going to object.
and solving its forecast overloads?
I'm going to object, leading the witness, Your Honor.
Your Honor, this was a question he was asked a lot about and provided documents to explain the Warwick Battery Project and the incidences there, and I think this is his opportunity to explain why he still considered that.
Overruled. Overruled. Answer the question.
Yeah, thank you. So we were aware of the fires. We understood the causes of them, but this did not dispute the fact that non-wire solution was considered technically viable around the same time frame as the consideration of the Whitefield substation. It didn't dispute the fact that this was procured successfully. It didn't dispute the fact that it, in several consistent years, addressed a substation overload quite successfully, and does not question the technical viability of the solution.
I think the question was, did that, notwithstanding all the facts that were brought up with respect to those fires, did that change your opinion? That was the question, if you could answer that.
No.
Were you required to do an NWS analysis to opine on the prudence of White Flint's scoping of the problem and NWS considerations?
No, it's the burden of the company to prove the prudency of their investments.
Thank you.
Thank you.
Meekan, for 1 minute. That's all, Your Honor. Thank you.
All right, questions from the bench will proceed in this order. Commissioners Linton, Suchman, Hoover, McLean, and the chairman. Commissioner Linton.
Thank you, Mr. Chairman, and it gets me good morning still. Just barely. Good morning.
Good morning.
I just have a couple of questions, just for my own clarification. And I wanted to make sure that I had a chance to just be clear about what you see, because you're recommending disallowance of the entire substation. Is that correct?
We are recommending a disallowance of the amount of the substation, which, not including the fully forecasted test year, was 136 million. This was based on our analysis of, we broke down the investments into what we felt was confidently could feel was capacity driven.
Okay. So, the company, of course, is saying that there was a projected overload at this location. So, do you accept that portion of their testimony and statements that there was an overload at this location? Or do you think that that wasn't actually true?
Oh no, I agree. There was an overload, but the nature of the overload, I think, is really important in assessing what the most cost-effective alternatives are.
Okay, so I know you've suggested. I know we've heard this 8760 study a lot, and I know we don't have one, and I know that you have recommended we should have had one. Were you here when witness Allo testified?
Yes.
Okay. So I believe as part of his testimony, And he also stated that there was some projected expansion of other facilities in that location. So I believe he talked about buildings that were going to be built larger than what they were now. And so they were building that into their analysis at the time to determine that even though the load wasn't there, it was going to materialize in the future. Were you aware of that portion of their analysis as part of your discovery and your studies to make your testimony?
We were aware there was general load growth, and that's where, data means everything, right? Which is why we requested the forecast, we requested the hourly data to truly understand, what the company was seeing. And so, ultimately, there may be load requests, but what are the forecasts, right? And what does the data tell you? And the data told us, even under these circumstances, the peak load was for a very limited period of the year.
Okay. So without the 8760, how do you reach the conclusion that either with those additional peak forecasts that they had internally for themselves or anything else, that the solution that they came up with wasn't the best one?
So we did do an 8760 analysis. Our assertion was, and Mr. Ellis said this, they did not do one. Mr. Ellis said they had hourly data at the time. They use hourly data to inform planning, but they chose not to do an hourly analysis as part of fully understanding this constraint. In our fourth discovery request, we finally got 5 years of hourly data. We asked for 2020 to 2025 or anything beyond that, or anything before that, and we got 2020 to 2025. And so we took that data, we combined it with their forecasts, and we forecasted out to understand what the degree of the constraints would be. So we performed our own independent one.
Okay.
It was DR set 7, not 4.
Did I say 4? I apologize. The DR set 7 is when we got the actual hourly data in a format we could use it in.
Okay. That's all I had. Thank you, Mr. Chairman. Thank you.
And now I can say good afternoon, Mr. Balakumar.
Good afternoon.
So the challenge is that the company did build out White Flint.
Correct.
So that we're looking at, the numbers I have are, Park Lawn was 82.5 MVA, and now White Flint is more than double that. So 95 MVA. And I guess my question is now that it's been built out, and there's some question about whether there was a need to build it out and to build it out to the extent that it was built out. How effective would non-wires alternatives be now, or have we lost the window, at least in terms of White Flint?
And we were focused on what the company knew at the time in 2017.
No. So this is actually so I'm actually asking you in your expertise in the various proceedings you've been involved in. It's happened.
Yep.
So sort of looking forward. Regardless of whether we allow for cost recovery or not, where's the value for non-wires alternatives now in terms of White Flint, or have we lost an opportunity there?
As you mentioned, Commissioner, what's been built is built. I think the company mentioned several new developments that are coming on, and so it's the infrastructure is there, and I think now we just need to use it. I think moving forward, and this is why we were analyzing White Flint in this case, but provided forward-looking recommendations. For us, this doesn't look good. Are we really willing to pay $256 million for 1 hour of the year, or are we going to do something more flexible moving forward? Even going beyond that, and this is in the record, looking at this substation, when we looked at the forecasts, and some of these are confidential, but the one number that was mentioned was 20 megawatts of overload. And when you look at the infrastructure itself compared to what the overload was, it's just 3 to 4 times our maximum overload. And so even this was overbuilt. And so from our perspective, worst case, this never should have been built, or at least deferred. Best case, this substation, a substation is built and then it has a certain amount of transformers attached to it, which allows you to use the full capacity. From our perspective, several of those, didn't match the need at the time. And so worst case, this never should have been built. Best case, it was overbuilt. And so our forward-looking recommendations in this case, we put forth a non-wire solution framework and a BCA framework in this case because, we want to make sure this never happens again. For us, this is very concerning, and so we believe it should be at the commission's full discretion to address this in this case for the company.
Okay, and so, in terms of overbuilding, so the problem with overbuilding, I'm assuming from your testimony, is that you eliminate any opportunity to consider non-wires alternatives because the focus is just on the substation and building out the substation. So there's a loss of opportunity now and in the future.
Yeah, so in this case, there's I think there's 2 points of overbuilding, right? The first one in 2017, 2019, where we didn't do a battery. The second one is, even if you are going to go forward with the capital investment, a full traditional one, make sure you're sizing it right? It's align it with the forecast, and if there's a substation and you're building 4 transformers instead of 2, you're doubling how much and transformers are expensive, and so build the substation out and build the transformers out to the actual load and the actual data, not doubling that not based on any data available,
Okay.
not at least to us.
Thank you. That's all I have.
Thank you.
So one of the company's arguments in support of the White Flint station was this anticipated new growth that they'd see from potential economic development projects along the lines of what Commissioner Linton was talking about. And they had one specific example that was a proposed sort of health computing facility that was going to be built in that area and served by that substation. And in fact, part of the information they gave us was a press release. They did a ceremony announcing this thing, including the person who is the boss of MEA. Is it your view that Pepco could serve that load and the other potential future economic development activities without building the White Flint station?
So it really ultimately depends on the data, right? What does the data tell you? And so I think the key here is, once you estimate those loads and you put them into your forecast, are you overloading and by how much, right? That's it. Is that firm capacity getting you right above? And then there's a couple hours in the year where you need to shave off. And so it really depends on what those loads are, how they were built into the forecast, and what does that curve look like throughout the year. This is where we're hearing this term called grid utilization more and more, and that's all about the grid is dynamic. It's changing over time, and so as you're planning, you should be accounting for that, and as you're operating the grid, you should be as well. And so ultimately the data doesn't lie, sir.
Okay. All right. Thanks. McLean.
Good afternoon, sir.
Good afternoon.
Just a couple quick questions in follow-up to Mr. Michael's discussion with you on your cost-benefit analysis. I know you indicated you used battery prices from 2021 and you used Baltimore County prices for land rather than Montgomery County. Had you used, I guess, prices from 2017 for batteries or 2019 and the Montgomery County land prices, how, if at all, does that impact your cost-benefit analysis, sir?
Yeah, and so
if you can answer that.
Yeah, I will admit we got Discovery a week before and we were rapidly putting this together, but we put several buffers in there to account for this, and so we'd have to see, because our land costs were 10 years later, right? And so we'd have to take a look at how does Baltimore look like 10 years later versus Montgomery County, and so and on the battery costs, battery costs were more expensive then, right? And so, I mean, we were looking at conservatively, once you look at the final numbers of the benefit cost analysis, at a $3 million benefit. Now that was comparing this against 136 million of the 256, right? And so that was what we felt very confident could have been deferred. But there was another 100 million that we felt could likely be tied to this investment and deferred. And so we compare this against a $130 million investment. Once you add another 100 million in there, it may have penciled out. We would have to run the numbers.
Okay, that's fair. Also, on the Warwick battery project that you discussed with Mr. Michael, I think you had indicated that used several parcels for batteries. Is that correct? Land parcels?
Yeah, and so the reason we used that was there's multiple ways you could deploy a battery solution. You could buy a bunch of land, put it all together, or you could disperse them if land is an issue, or you wanted to pull these one at a time to give you optionality to see where the forecast goes. But that's correct.
Sure. So in our or in Pepco's situation, is there land or was there land available at the different decision points, or are we just kind of, I don't want to say assuming, but are you assuming that there was land to purchase to put these batteries on, sir?
Yes. On discovery, the company said, assumed one parcel in their response, right? If we did one parcel, this would not work. And so our response was, take a look at multiple ones, right? Go do a procurement and get some creative ideas on this. And so our analysis was meant to be high level and say, you could have done one parcel, but here are some alternatives. We did not do a full comprehensive land analysis of the area.
Okay, thank you, sir.
Thank you.
I think Commissioner McLean got a bunch of my questions, but let me just to clarify this in my mind. These utility scale batteries have a lifespan of 15 years, correct?
Yeah, based on give or take, based on our
Okay.
assumptions.
And what is the lifespan of the substation or whatever? What is the lifespan of that?
It can vary, but based on our assumptions, around 40 years. That's what we put in our model.
So in your analysis, did you factor in the replacement of batteries through that period of time?
So the way we did it was we had 12 megawatts of batteries, right? 4 megawatt batteries, which we would deploy over time. And so, but ultimately, that's only going to defer you 15 years, right? And so then the substation would likely have to kick in. And so calculating what that deferral
Hold
cost
on.
is.
Let me just again
Sorry.
ask my question. If to make the numbers simple, if a substation lasts for 45 years, 15 times 3 is 45. So did you in your analysis calculate a set of batteries, a second set of batteries, and a third set of batteries?
Correct. As part of one battery solution, yes.
So you did do that?
Yes.
In that fashion, okay. And then finally, I presume that you made this calculation for lithium-ion
Correct.
technology? You didn't go to sodium-ion or
No, lithium-ion, and what was used at the time by multiple utilities.
Okay. That's all I have. So thank you very much.
Thank you.
So scheduling issues. I was thinking about just doing a half-hour lunch and starting it now, but I want to turn to OPC and see what is the status of your witness. Do you have somebody who has to go right now, or because if that's the case, we can take that witness and then do lunch. So I just want to accommodate you.
So I don't know if the witness has to go at this moment, but we did want to make a slight change in the order of our witnesses.
Okay.
We'd like to call David Garrett first. He's our return on equity witness.
Okay.
I'm not sure whether parties have crossed for him or how long that cross might be. Then we would go to the order in the list. We would go to Melissa Whited next, then Colin Fitzhenry.
So if we did lunch right now and did it for half an hour, would that work for you and your witnesses?
That would work for our witnesses, yes.
Okay. In that case, that's what we're
Your
going to...
Honor, I just have one question to ask. If MEA witnesses may be dismissed?
Yeah.
No one intends
yeah.
to recall them?
Yeah,
Okay.
yes.
Thank you.
Yeah. Okay, so we will come back at 1:45. back at it. So, People's Counsel.
Yes, Your Honor. OPC will call Mr. David Garrett to the stand.
David Garrett.
Please proceed. Is he sworn in?
Oh, yeah, that's right. Oh, that.
I do.
All right, good morning, or afternoon, Mr. Garrett. Do you have before you a document entitled The Direct Testimony of David Garrett, filed in this case on January 30th, 2026, which includes 79 pages of narrative testimony, 17 attachments, and 2 appendices?
Yes.
Your Honor, I would like to have Mr. Garrett's direct, marked for identification as OPC Exhibit 31.
So marked.
The motorin table, I believe, was 30. I presented earlier today. I guess while we're here, is that entered into evidence? I believe it was, but to clarify. I'm sorry. Sorry, that's a quick. I believe I entered it, but just for the record,
Yeah.
if we can confirm. Okay, thank you. So 31 Garrett direct. Okay. Was this document prepared by you or under your direct supervision?
Yes.
And do you have any corrections or updates to make at this time?
I do have one update. It's not a correction because it was accurate at the time it was written when my testimony was filed on January 30th, but I'm referring to page 5 of my testimony. Direct testimony starting at line 4. The question is, how does your cost of equity estimate and proposed ROE compare with the expected returns on the U.S. equity market among prominent investment companies? Starting on line 11, it says BlackRock projects an even smaller return of 5.2%. After filing my testimony, BlackRock did update that number to 7.74%. So the 5.2 is correct at the time, but now updated to 7.74. And the phrase before that, an even smaller, would of course then not apply.
Thanks. Your Honor, I'm just going to hand out for the record the printouts of that citation Mr. Garrett just gave.
7.74%.
There we go.
Mr. Garrett, is what I just handed out a printout of the BlackRock estimate that you just talked about updating.
Yes.
And could you identify, if you could turn to page 4, this is where the printout doesn't seem to work very, in terms of actually printing it doesn't seem to work very well, but you can see the number you were citing there.
Yes, on page 4, you see it says central expected return 7.74% in that chart.
Thank you. Your Honor, I'd like to mark this as OPC Exhibit 32.
So marked.
Okay. And with that update, if you were asked the same questions today under oath, would your answers be the same?
Yes.
Your Honor, I move that OPC Exhibits 31 and 32 be entered into the record.
Without objection, so admitted.
And Mr. Garrett, do you also have before you a document entitled The Surrebuttal Testimony of David Garrett, filed in this case on April 16th, 2026, consisting of 22 pages of testimony.
Yes.
Your Honor, I would like to have Mr. Garrett's sir rebuttal marked as OPC Exhibit 33.
So marked.
Was this sir rebuttal testimony prepared by you or under your direct supervision?
Yes.
Do you have any corrections to make to that testimony at this time?
No.
If you were asked the same questions today, would your answers be the same?
Yes.
Your Honor, I move that OPC Exhibit 33 be admitted into evidence.
Without objection, so admitted.
Thank you, and the witness is now available for cross-examination.
Okay. Would Pepco like to go first?
No, the company wishes to go last.
Okay.
No questions, Your Honor.
MEA.
No questions, Your Honor.
Staff?
No questions, Your Honor.
Well, see what a difference that made? Pepco.
Good afternoon, Mr. Garrett. How are you?
Good afternoon. Good. How are you?
I'm going to first have you refer to page 4, line 6 of your direct testimony.
Okay.
Now, there is where you recommend an ROE for Pepco of 7.7%. Is that right?
Yes.
And I'm going to have you now turn to your surrebuttal testimony at page 4, lines 6 and 7.
Okay, I'm there.
What page was that again?
That was page 4 of his surrebuttal, lines 6 and 7.
Okay.
Now there, do you say your recommendation, your 7.7% recommendation is a departure from the norm, and that's a quote?
I do describe it as that in that sentence, yes.
Okay. And could you turn to page 17, lines 9 through 13 of your surrebuttal testimony?
Okay.
And there you state that your recommended authorized ROE of 7.7% would be unprecedented, correct? That's the term that you used?
Yes.
And by unprecedented and departure from the norm, would you agree that if the commission were to approve this 7.7% ROE, that would be highly unusual?
I think just quantitatively, given this commission and other commissions, the authorized ROEs they typically adopt, 7.7% would be notably lower than the norm, yes.
Would your statement that it's unprecedented and not the norm also mean that you're not aware of any state regulatory commission approving an ROE that low?
I'm not aware. No, I'm not aware of an ROE that low.
All right, I'm going to ask you to turn to page 75, lines 10 through 15, and this is of your direct testimony.
Okay.
Now, there is where you first discussed the concept of double leverage. Is that right?
Yes.
All right, let's move to a couple pages later on page 77, lines 12 through 14 of your testimony.
Okay.
And there you state that the double leverage approach is not typically presented in regulatory proceedings and considered by regulators. Is that correct?
Yes.
Now, would that also mean that you're not aware of a state regulatory commission that has used double leverage to arrive at an ROE recommendation?
That's true. I'm not aware of any that have. For just a brief context, I've raised the concept of double leverage, but more in conjunction with a capital structure adjustment where I'm describing this concept. In this case, I actually calculate a weighted average return on equity for the parent, with the idea being that that could be equated to the cost of equity for the sub. But the answer to your question is yes.
I'm going to mark an exhibit. May I approach the witness, please?
Yes.
And this will be Pepco exhibit number 58. Mr. Garrett, are you listed as the sponsor of the data request that I've just handed you that is marked as Pepco exhibit 58?
Yes.
And there, the question is, are you aware of a regulatory commission that has authorized an ROE equivalent to an estimated cost of equity using the double leverage approach?
You're asking if that's what it?
Yes.
The question asks. Yes. Yes.
And your response is that you are not aware of that. Is that correct?
That's an accurate summary of my response. Okay. Yes.
I would like to move Pepco Exhibit 58 into evidence.
Without objection, so admitted.
All right, remaining with the double leverage topic, may I have you stay on the same page, page 44, but let's go to figure 14. And that figure is entitled Exelon WACC, or WAC.
I'm sorry, Counsel. Did you mean 77?
Yes. Oh, did I not say 77?
I think you said 44.
Oh, sorry about that. 77.
Yes, I'm there.
All right, wonderful. So figure 14, this figure shows a 5.65 weighted cost of capital for Exelon. Is that correct?
Yes.
And according to your double leverage approach, this would mean that Pepco's cost of equity should also be 5.65%, correct?
It suggests that a cost of equity estimate for Pepco could be 5.65% under this approach.
Now, you would agree with me that investors require a higher rate of return for assuming more risk. Is that a correct statement?
I would generally agree with that. Higher risk in an investment would result in a higher required return from investors.
And you would also agree that a common stock is riskier than a utility bond, such as a publicly traded, or such as utility bonds. Is that right? I'll restate that. Would you also agree that a common stock is riskier than an investment in bonds?
Yes, generally speaking, equity investments are going to require a higher return because they have more risk than debt, especially for the same. I mean, it may not across all companies necessarily, but just generally speaking, I agree with that statement. Yes.
And conversely, would you agree that a utility bond, for example, would be less risky than common stock?
For the same company?
In general.
Generally speaking, the cost of equity, which is synonymous with the required return on equity, should be higher than the required return of in bonds. Yes.
And would you also agree that a reasonable investor would expect a higher return on equity stocks than utility bonds?
Generally speaking, yes.
May I approach the witness? I'd like to show him
Yes.
testimony from Adrian McKenzie, the company's ROE witness.
Oh, thank you.
Okay, I have just handed you the rebuttal testimony of company witness McKenzie. May I have you turn to page 8 of his testimony, his rebuttal testimony?
Okay.
All right, there you'll see a table AMM-R1. And would you agree that this table shows that for January 2026, the utility bond yields were 5.86%?
Yes.
Do you have any reason to disagree that that's what the BAA-rated utility bond yields were in January 2026?
No.
So would this mean that your cost of equity at 5.65% is actually less than the bond yields for January 2026 at 5.86%?
Numerically, 5.65%, of course, is less than 5.86%. But just for context, the double leverage approach is recognizing that the equity reported on Pepco's balance sheet is not pure market-driven equity. So there's a lot of debt baked into that number. But 5.65% is less than whatever the number was, 5.8 something percent.
5.86%. So again, your double leverage approach is assuming 5.65% for the cost of equity.
Yes, it's suggesting under this viewpoint of the way of looking at parent-subsidiary relationships that the equity on the subsidiary's balance sheet is funded by the parent, and so it necessarily includes the debt issued by the parent. So the answer to your question is yes, but with that context.
So would it be logical to assume that a reasonable investor would expect a lower return for the cost of equity than an investment for bonds?
The way that you frame that question, I would agree that just generally investors expect higher returns for equity investments than bonds. But that wouldn't change my opinion on what this model is indicating under the more realistic assumption that Pepco is not a standalone company that actually issues equity in the market.
Thank you. I'm just focusing on the application of your method. The result of the double leverage approach, though, results in a cost of equity that is less than the cost of bonds, following your calculation of the double leverage approach.
The 5.65% number indicated from this model is less than the bond percentage that I think 5.86% that you cited.
And can you still, in your testimony, you do state at page 78, lines 6 through 8, that the double leverage approach results in a reasonable estimate for a cost of equity. Is that your testimony?
Yes, I do think it's an indication of a cost of equity, which is certainly different than my proposed authorized return on equity, because those are different concepts and almost always different numbers. But yes, I mean, I would stand by the testimony as I wrote it here.
Page 78, starting at line 18, that's where you do, as you just noted, state that you're not recommending 5.65%, that you are recommending 7.7% ROE. And that is because of gradualism, correct? That's your testimony?
In part, yes, I think that's a consideration that generally, pretty much in every case, I do consider, given what is, in my opinion, a pretty large discrepancy between the status quo, the typical authorized ROEs, and utility cost of equity.
And I'm sorry.
That's the end of my answer.
And you also said that an ROE lower than 7.7% would be a shock to existing investors. Did I characterize your testimony correctly on that page?
I said that?
Yes, it's starting at page 78, line 18, moving over to page 79, line 2. So on line 2, you said it would be a bit of a shock for existing investors.
I said bit of a shock.
Okay.
But yes, I do. I mean, it would be surprising. Yeah, it would be, I mean, surprising for stakeholders in general. It's notably lower than the typical ROEs that commissions adopt, and probably what people are anticipating would be adopted.
Right, remaining on the topic of double leverage, you have not used double leverage to calculate an ROE before, have you?
Not presented in testimony in this way.
I'm going to have you turn to Schedule AMMR-16 of Company Witness McKenzie's testimony that I previously handed to you. And that's Exhibit 16. Should be the last page.
Okay.
Now there you see a chart. It says at the top, comparison of rate cases. And maybe a third of the way down the page, it says method. In the column on the far right-hand part of the page, it says double leverage ROE. You see that?
Yes, I do.
And this is an analysis of, well, first, let me ask you, is this an analysis of your most recent 6 cases in which you've testified?
I think that's what Mr. McKenzie was intending to present here.
And in those past 6 rate cases, you have not proposed this double leverage approach. Is that right?
I mean, well, in the past 100 cases, I haven't. Yeah, I've said this is the first. This is the first case. So, yeah.
Now, would you agree that you are singling Pepco out by using this approach only for the company?
I wouldn't state it like that, because for one, I'm not recommending that as the authorized rate of return. I'm raising the issue to just as another indication that these cost of equity estimates are likely much lower than the typical authorized ROE. So I don't know about agree with singling out, because I think I'm likely to start presenting that more in cases, but this happened to be the first one.
May I approach the witness? I'd
Yes.
like to mark another exhibit, a DR, as Pepco Exhibit 59.
All righty then, let's see it. Of course. I mean, no, I guess we'll just. Or 4 or 5. We're fairly heavy drinkers, so. We with the liver as a muscle, use it or lose it. Are you sure you didn't get like 2?
Did you get to?
think we're short one.
You're short one.
Yeah, there we go. And this is going to be 59. Yeah, right. Hey, I paid for 5 pieces of paper. I want to get 5 pieces of paper. Okay. Okay, 59. So noted.
Yes. Now, I've handed you OPC's response to Pepco's data request 7-3. Are you listed as the sponsor of this DR?
Yes.
And was this data request prepared under your supervision and direction?
Yes.
And here you say that this is the first case in which you've calculated a separate cost of equity estimate based on the concept of double leverage. Is that correct?
Yes.
I would like to move Exhibit 59 into evidence.
With no objection, so admitted.
And if I have not moved 58, I'd also like to move that. Oh, that's
I
it.
think you had.
Okay. All right, I have no further questions for this witness.
Okay. Who's next? AOPA. MEA.
No questions.
Staff.
No questions.
Redirect, I believe?
Yeah, redirect, yeah.
Thank you. Briefly, Your Honor. Mr. Garrett, you, in questions with Pepco counsel just now, there's a lot of talk about this being your recommendation not having much precedent around in other cases. Should commissions be determining ROEs based only on what that commission or other commissions have done or do and have done in the past?
I would strongly advise against that approach because, for one, it negates, it kind of counterfeits all of the analysis that's been presented in the case. I mean, you have MEA's witness, Dr. Kimes, which I think adds a lot of valuable testimony to discussion. Of course, I might be biased, but I think my testimony does the same. I mean, there's a lot of great, we're running like Nobel Prize winning models in economics and stuff like that. And if it's just going to kind of just take an average of what everyone else is doing, that there's really not much, this would add no value to that. So I think it should be considered. So yeah, the short answer is no. It's really not the best way to do that. And what the result clearly is going to be an authorized return that exceeds any reasonable estimate of the cost of equity of these very low-risk companies.
Thank you. And one moment, please. You discussed the cost of equity and investors requiring a higher return, or equity and investors requiring a higher return generally on equity than debt. Would you say a utility stock compared to utilities debt is significantly riskier than the utilities debt? That such that that it would justify, say, Mr. McKenzie's return of 10.5%?
No, in my opinion, the cost of equity for a utility company, it would not be materially higher than its cost of debt. And the reason is because there's no foreseeable scenario where equity holders are standing in line behind bond holders in a bankruptcy proceeding in which all of the utilities assets are just going to be sold at a giant garage sale. That's just not happening because this company, like all utilities, effectively has a social safety net provided by customers and the government. Ultimately, customers would bail the company out of any financial trouble unless you're going to operate under the assumption that we, the commission, the state, the federal government would just let the company entirely fail and not provide service. So for that reason, you're trying to estimate something that can't be directly observed, the cost of equity. But you do have a starting point on a real number, which is the company's cost of debt, I would suggest as a floor for what the cost of equity would be. Perhaps Mr. McKenzie would think the floor is something higher than that, but it's definitely can't, we could say, go lower than that for all intents and purposes. So then you start going up from there with how much of an extra premium there would be on equity. And I think the CAPM very likely overstates the cost of equity. That's my CAPM result in this case was 8.2%. It probably overstates it because of the beta term, which gets in technical discussion that's outside of the scope of your question. But the other reason is the CAPM doesn't fully account for the idea that a company could be insulated from bankruptcy risk. It wasn't designed to be conducted on those types of companies. So now I forgot your original question, but that's my answer.
Yeah. Thank you. I think you answered enough. Nothing further, Your Honor.
Okay, we'll go to questions from the commission, starting with Commissioner Suchman.
No questions.
Okay, Commissioner Hoover.
So in a number of these cases, not just with Pepco, but the other utilities, when we are dealing with the issue of rate of return, and in reaction to proposals by the utilities that we increase the rate of return, the counter argument we hear from OPC and staff and some of the other parties is that we need to adopt the policy of gradualism as to not move the rate of return up in a dramatic fashion. And while the company's witness spoke against the concept of gradualism, I'm not quite sure that this is what he was anticipating. So I guess my question to you is, if we apply the notion of gradualism on the way up, why shouldn't we apply the notion of gradualism if we're going to go down?
I think it's certainly prudent to consider because it kind of puts all of the stakeholders, it could put them on notice if there was going to be a new normal at a particular commission where they're going to be adopting numbers again, which a very strong opinion that the cost of equity is much lower than the typical authorized ROEs, but I think it could be prudent to get there more gradually. And I think I've taken that approach before this commission in many cases where I'm recommending 9% or something like that, even though my CAPM model is suggesting 8% maybe. In this approach, we just took a different approach in this case. I think Dr. Keim's testimony, I don't know if he uses the word gradualism, but in looking at his testimony, that 9% recommendation, it was 9%, I believe, is effectively on the basis of gradualism. So certainly as a commission, never been a commissioner, but I imagine that's something I would consider when making decisions, yes.
Okay.
McLean?
No questions. Thank you, sir.
Linton?
Thank you, Mr. Chairman. Good afternoon.
Good afternoon.
When witness O'Donnell testified, I think pretty credibly, she talked a lot about the importance of and the impact of a lower ROE on investor risk perception. And in your rebuttal testimony on page 19, you start on it a little earlier. You start on 18, but on 19, you respond to some of the concerns that she raised regarding investor perception in the utility jurisdiction, and specifically the RA rankings. I think it's fairly safe to say that if we were to move in the direction that you recommended, that we would probably see investor perception, at least as it's measured by different external organizations and entities, as looking a little negative in the Maryland area. So how would you respond to what she stated in her testimony, and just the general perception? How should the commission weigh that as part of our deliberation?
Well, I've been thinking about that exact issue a lot lately, and I do have a good response. And that's because, yeah, well, the narrative from is usually utility presents a witness like this, pretty much in every case where they're highlighting credit ratings and things like that. I think for the commission, it's important to understand that the utilities and the credit rating agencies they're on the same side of the issue. And in fact, that's why if you're reading a credit rating report, a lot of times you see the same buzzwords that you're seeing in testimony. The testimony can be not to, not mean this a cheap shot to anybody, but basically they both say more money and less risk would be good for us. It's like, well, I could have told you that. Anyone can conclude that. So are they going to see something as going the other direction as negative? Well, of course, because we all want, they want to maximize profits. It's perfectly normal. But the commission is in the business of setting fair rates. Moody's and all these other, they're not interested in that. So they're simply going to tell you what is best for their clients, actually. I mean, the companies pay the credit rating agencies, which creates a conflict of interest. So they're on the same side of the issue. They want more money and less risk. That's fine. I want that too. We all want that. But if you're setting fair rates, I would suggest you would have to push back against that narrative. And as far as getting some kind of these rankings, that's not a race you want to win. You give them the most money of all the other commissions, and you're at the top of that list. But that's not where you want to be, I wouldn't think.
Okay. Thank you. Thank you, Mr. Chairman.
Okay. I have a few questions, but let me begin by saying that I don't think there's any risk of us beating out Arkansas and being number one. Okay, so I think your argument is tantamount to saying that. Well, wait a minute. First of all, I always assumed that Pepco was a wholly owned subsidiary of Exelon. Exelon has 100% of their stock. There are no minority shareholders, correct?
That's my understanding.
Okay, I'd always assumed that, and I don't see any dissent from counsel from Pepco. So let's assume they're.
I'd have to check on that.
Okay, I'd always assumed that they were all wholly owned, but let's proceed from the assumption that they were wholly owned subsidiaries. So I think your argument is that because they're a wholly owned subsidiary, really the only relevant entity is Exelon, not Pepco, from an investment standpoint.
Well, I don't know if I'd say only relevant. I mean, it is the publicly traded entity, and when we're doing the cost of equity modeling, we're using other publicly traded holding companies.
Okay.
So the investors are, the stocks of those companies are what investors are directly purchasing.
Okay, so in your proposal, you're saying that the debt ratio should be 61%? Am I in the roughly?
Well, if you're talking about the capital structure that
Yeah.
I'm recommending for rate-making purposes, of course, their actual capital structure is
Right.
within their discretion of company management, as I understand it. But if you're running a CAPM on a group of holding companies with that have betas, those betas are directly affected by the capital structures of those companies. So if there's a discrepancy between the company you're studying that's not publicly traded, Pepco in this case, you have to adjust for the discrepancy between the company's capital structure, which is much less risky because it has more equity.
It's like, yeah.
So it's a correct mathematical adjustment to the CAPM.
So how are you, I mean, without going into the actual details of the calculation, are you basically taking Exelon as a large holding company group and saying 61% of their capital is from debt and 39% is from equity? Is that how you get those percentages?
Well, are you talking about the double leverage model or the?
Yes.
Oh, okay. Well, that is it's similar. It's related to what I was just saying, but
Okay.
yes, I'm conducting. This is page 77. I'm referring to.
Yeah, that's where I am.
Yeah, that is the book values of debt and equity for Exelon. I do estimate the cost of debt. It's it's more of a historical looking. There's some different ways of doing that would give you a tight range. So
But you're basically saying
Yeah.
you should only be concerned with Exelon's capital structure and not the capital structure of the regulated entity Pepco.
Oh, well, separately, I do think you should be very concerned with Pepco's capital structure. I'm recommending a rate-making capital structure that should be authorized by the commission that is different than their actual capital structure.
Your Honor, if I could clarify,
Sure.
you're looking at page 77.
Yeah.
The table there is related to Mr. Garrett's analysis of the double leverage concept.
Okay.
His recommendations are on his final recommendation is on page 8 of his direct, the figure 2.
Let me go up there. I was going to say, I thought it was a smaller percentage, like 57% or something.
Yeah.
Yes, that 57% is the average debt ratio of the proxy group, the same proxy group Mr. McKenzie and
Okay.
I both used. And I think that adjustment should be made to effectively make the CAPM results more accurate.
Okay, so here's what I'm struggling with. I look at this my instinct is to look at this sort of simplistically as an accountant, but I understand there are other methodologies for pricing things. So that 57%, that's not tell me again how you get to the 57%, just the concept of it.
That is the average debt ratio of the proxy group that they actually have.
And these
They're
are
booked-
holding companies?
Yes, we use a bunch because we can't run the CAPM on Pepco because it doesn't have a stock price. So what's very common in these proceedings, which all the witnesses in this case have done, and in every case I'm aware of, is they use a group of utility companies that are publicly traded, which tends to be these holding companies. And now you can conduct the DCF and CAPM on those companies because they actually have publicly traded stocks. And so, as part of that analysis, I'm also looking at the capital structures of those companies. Because once you run the CAPM on those companies, that risk associated with the outcome of the CAPM is necessarily tied to the capital structures of those companies. So we need to align Pepco's capital structure with the average capital of the proxy group in order to get that apples to apples comparison.
So your argument is if we were to implement this kind of methodology, it would not put it would not put Pepco at a disadvantage if they wanted to borrow money at this weighted average return percentage. That's what you're saying?
That is now that does include the 7.7% too, the weighted average return. So there's two substantial adjustments in there, the capital structure adjustment and the 7.7% return, which is relatively not gradual compared to other recommendations, and as we established would be, it would be substantial. But if your question to me is, can utilities still borrow money? Yes.
No, my
absolutely.
question was a little different. It was that if we were to adopt this methodology and if we were to adopt a return on equity based on this methodology, that it would not give Pepco a disadvantage compared to where it is right now. A substantial disadvantage.
I think if you're referring to disadvantage as in,
well, the ability to raise capital.
I don't see a scenario in which they would not be able to raise capital. I think when utilities say that, they're referring, my interpretation of it, reading between the lines a bit, is they're saying we don't want the stock price to drop. You still can raise, if like a utility issues equity, no one's going to buy it. That's just not a realistic scenario, or issues debt. Like, no, we don't want that. It's pretty much a guaranteed return on the debt side. Again, because they're not failing. We're not letting them ever fail. They would still be able to raise capital. When they say that, I think sometimes they refer to our peers are getting this really great deal, and we want to get it too. So don't. As far as we were talking, about the negative outlook, they would perceive that as negative because it's less than what they want. But the question is it fair? That's the real issue.
So your answer is it wouldn't put them at a disadvantage for raising capital?
No, they should still be able to raise capital.
Do you want to ask a question?
Yeah,
Go
just
ahead.
to follow up, witness O'Donnell didn't challenge the ability to raise capital. Her concern was being able to raise it at the rate that they're getting it now. And you don't see that this is going to, I mean, they'll always be able to borrow. They're always going to be able to secure debt. But the question is, can they secure it at the favorable rates that they're seeing now?
When I see this testimony, what a lot of times witnesses do, it's pretty, and just it's, I know they're trying to be persuasive, but they'll focus on the cost of debt. And speaking for customers, it might sound a little bit extreme, but we don't care about the cost of debt. What we care about so much more is the weighted average cost of capital. So if their debt costs go up as a result, which I still think it would be incumbent on company management, there's no direct link between the commission made this decision and our cost of debt went up because we got a credit ratings downgrade. Every financial decision they make affects their credit rating. So they have a big part to play in this process. But let's say to your questions, if a decision from the commission ultimately, indirectly, resulted in a slight increase in the cost of debt, the weighted average cost of capital would be so much lower that we would gladly, if I give you $5, you give me $20 back, that would be like me mulling over, I don't know if I want to pay $5. I mean, I'm netting $15. So companies in the real world, they're always trying to minimize cost of capital. But utilities don't have that same incentive. They're not trying to minimize it. So I don't know exactly if, Ms. O'Donnell, I think she's referring to the cost of debt, favorable terms. That's okay. We're covering the cost of debt. We're writing a check for that. We've got that covered. You don't have to worry about that. And if it goes slightly higher, we're okay with that arrangement because the cost of capital is so much lower, the weighted average. That's what we care about. That's what every company cares about. And there's a natural incentive to minimize that cost of capital, like your other costs of the business. So I disagree with her narrative overall, especially as if some of it's premised on the idea of really this is what's best for customers. I mean, with all due respect, the company has no one to speak. They have no standing to speak on what's best for customers. So they'd still be able to raise capital. It may be a slightly higher cost of debt. That's okay. We're writing the check for it. We don't care. Okay.
Oh, and Your Honor, I confirm there is one other entity in there, PHI, Pepco Holdings. You
That's
had asked
right.
the question about,
So really, Pepco
Exelon.
Holdings owns 100% of Pepco, and Exelon owns 100% of
100% of
PHI.
PHI.
Okay, right. Okay, but that's not a minority shareholder. So.
Triple leverage.
There you go.
No, sorry.
Right, it should be 75-25. Just joking. That was not a statement by me. Okay, thank you very much. Your next witness.
Apologies while we.
Sure. We'll break for pause for 3 minutes. Sure.
That's it.
Hey. Proceed.
Good morning. May I ask for the witness to be sworn in? I do. Good afternoon, Ms. Whitehead. Can you please state your name for the record?
Melissa Whited.
Can you also please state your title, employer, and business address?
Yes, I'm a vice president of consulting at Synapse Energy Economics at 485 Massachusetts Avenue in Cambridge, Massachusetts, 02139.
Do you have in front of you a document entitled The Direct Testimony of Melissa Whited on behalf of the Office of People's Counsel that was filed on January 30th, 2026?
Yes.
Was this document prepared by you or for you under your direct supervision?
Yes, it was.
Does this document contain 21 pages of narrative testimony and one exhibit?
Yes, it does.
Your Honor, I'd like to mark Ms. Whited's direct testimony as OPC exhibit number 34.
So marked.
All right. Ms. Whited, do you also have a document entitled Sir Rebuttal Testimony of Melissa Whited on behalf of the Maryland Office of People's Counsel filed on April 16th, 2026?
Yes, I do.
Was this document prepared by you or for you under your direct supervision?
Yes, it was.
Does that document consist of 22 pages of narrative testimony and one exhibit?
Yes, it does.
Your Honor, I'd like to mark the Sir Rebuttal Testimony of Melissa Whited as OPC exhibit number 35.
So marked.
Do you have any additions or corrections to make to these documents?
No, I don't.
If you were asked the same questions today under oath, would your responses be the same?
Yes.
And for these reasons, do you adopt these pre-filed testimonies as your own sworn testimony in this proceeding?
Yes, I do.
Your Honor, OPC moves that OPC exhibits 34 and 35 be admitted.
With no objection, so admitted. What?
Could you let me know what OPC Exhibit 33 is? I'm sorry I missed it, Your Honor. I'm keeping our list.
Yeah.
So rebuttal. So rebuttal.
Mr.
of-
Garrett's.
Thank you.
Rebuttal.
Apologize.
And the witness is available for questions.
AOPA?
No questions.
MEA?
No questions.
Staff?
No questions.
Pepco?
We do have questions. Good morning or good afternoon. Sorry, Miss Whitehead. How are you?
Good afternoon.
Good afternoon. I'm Taylor Beckham. I'm representing Pepco in this case. I wanted to start with your testimony in this case, 9820, is that in case 9702, the prior rate case that Pepco filed, the commission approved the continuation of seasonal rates, right?
Correct.
Okay. And you also testified that the commission in case 9702 directed Pepco to include a proposal to gradually eliminate seasonality, and they also directed Pepco to do a cost analysis of seasonality in this instant rate case, right?
Correct.
Okay. But didn't, in case 9702, the commission only approve seasonal rates from April 1st, 2024 through March 31st, 2025? Is that right?
I'm not aware of those dates on the approval.
So I will hand you I'm going to hand you an excerpt of the order that I'm referring to. Your Honor, may I approach? Yes. Do you see there on what I handed you that the commission on page 190 approved the current seasonal rates for the year April 1, 2024 through March 31, 2025?
Yes, I do.
Okay. And while the commission directed the company to include a proposal to gradually eliminate seasonal rates, the company or the commission did direct Pepco to give notice to customers that seasonal rates would be eliminated in the future, right?
Yes.
Okay. So the company did a cost study at the direction of the commission, correct?
Correct.
And you understand that the company's position in this case is that seasonal rates should be removed?
I understand that's the company's position.
And Mr. Schaefer, the company's witness sponsoring the class cost of service study in this case, has indicated that the embedded costs of the distribution system are no more in the summer than in the winter, right?
So Mr. Schaefer, provided a cost study regarding embedded costs that he claimed was not relevant for rate design.
Right, but his testimony has been in multiple instances that the distribution system is no more expensive in the summer than it is in the winter, right?
His position, as I understand it, is that distribution system costs are fixed, and so they do not vary on an embedded cost basis
Between seasons, right?
between seasons.
Are you aware of any other studies from any other jurisdictions in which the embedded costs of the distribution system are seasonally differentiated?
For the purpose of rate design?
My question is, are you aware of any other studies from any other jurisdictions in which the embedded costs of the distribution system are seasonally differentiated?
I typically see marginal cost of service studies looking at the difference in seasonal rates or in seasonal costs as opposed to embedded cost studies.
So no embedded cost studies.
Not that I'm aware of.
Okay, but your position in this case is that Pepco customers should continue to experience at least 99% higher rates in the summer than in the winter, right?
My position is that the seasonal differentiation should be based on the underlying cost differentials. And so if that is currently, if the cost differential is that summer costs are that much higher than winter costs, then that would definitely be a consideration. There are other considerations as well, such as customer acceptance, gradualism, but I do think that that a cost analysis should inform seasonality and rates. So you should reflect the different costs in the different seasons in rates, and that's a basic premise of efficient rate design, is that you reflect costs in rates.
Are you aware of any other utility in the state of Maryland that has seasonal rates?
No, I'm not.
So is there a reason that only Pepco customers should experience 99% higher rates in the summer and other Maryland customers should not?
My position is that it would be best if all of the utilities in Maryland adopted more cost-reflective rate design. While Pepco is the only one currently, I think it would be very helpful to provide price signals to customers that reflect the actual costs on the system, and the fact that there's a lot of unused capacity in the winter, and we are much closer to capacity in the summer. And so by providing more accurate price signals across all utilities, it would help customers make decisions about how to consume energy, when to consume electricity in a way that is beneficial for the grid and better utilizes the grid. Right now we have a lot of extra capacity in the winter, and we're telling customers, oh no, we should actually have higher prices in the winter if we get rid of these seasonal rates, then actual cost studies would show. At the same time, by eliminating seasonal rates, we would reduce the price signal in the summer when we have actual capacity constraints on the system, right? When we have those high peaks. The summer peaks are 20 to 25% higher than winter peaks. That, for at least Pepco's system. So in my opinion, we should be providing customers with price signals that more accurately reflect those cost differentials so that they can make effective decisions about when to consume electricity, what appliances to purchase, whether to purchase heat pumps and adopt heat pumps. So that's what my recommendation would be. And I think
So
that's great.
are you aware that
currently
Pepco-
has seasonal rates?
Okay.
Yes.
Are you aware that Pepco only serves customers in Prince George's County and Montgomery County?
Yes.
Okay. And the reason, and I think I just heard you say it, the reason you support higher rates in the summer for Pepco customers is to incentivize heat pump adoption, right?
No, the reason that I support higher rates for Pepco customers in the summer is because Pepco's system is summer peaking. As I mentioned, the peaks are 20 to 25% higher in the summer, so we don't want customers to just be consuming more electricity in the summer. At the same time, we have a lot of extra capacity in the winter, so we do want customers to be consuming more electricity in the winter. Heat pumps are a technology that do that, and so by taking away seasonal rates, we're punishing those customers. We're providing them with inaccurate price signals. That's going to lead to less efficient use of the system, and that's going to result in greater peak demand in the summer and more investments and a costlier system. So this is about providing accurate price signals for customers. It's not about promoting a specific technology, although I will acknowledge that heat pumps can help Maryland reach its energy policy goals.
Are heat pumps only available for Prince George's and Montgomery County residents?
No, heat pumps are available nationwide.
Right. And certainly beneficial electrification shouldn't only occur in Prince George's and Montgomery County, right?
Correct.
Okay. And you've submitted testimony in this case that innovative rate designs that would support beneficial electrification and heat pump adoption that would support Maryland's policy goals should not occur in a working group?
No, that's not my position.
Can I direct you to your rebuttal testimony on page 20? And I'm looking at it starts on line 19, but really I'm focused on line 20, where you say, if the commission elects to reduce or eliminate seasonal differentiation in standard residential rates, it should not rely solely on the working group process?
That's correct.
And instead, your position is to direct that the commission in this case file, or direct Pepco to file one or more opt-in rate designs that are cost reflective and support beneficial electrification, including heat pump adoption by a date certain, right?
My position is that...
Is that your testimony here?
Yes, by date certain, but that doesn't mean not as part of the working group process. I've been a participant in the working group for many years, and it can be a very helpful forum for parties to discuss different rate options and to work collaboratively. However, it's open-ended, and so without a commission directive to develop something by a date certain, that process may take years. It may take much longer than it needs to. So what I'm asking for is not that we not do it as part of the working group, but that the commission provides some direction and a specific date so that those conversations in the working group happen effectively and efficiently.
Okay, and Pepco's not the only utility in the state of Maryland, right?
Correct.
Okay. I'm going to turn you back to the snippet from the order, and I'll just give the number, order 91181, that page 191, where the commission did direct Pepco to provide a cost analysis and customer impact study in its next rate case, but the commission indicated that it may revisit the issue of Pepco's seasonal rate removal in the context of its proceedings on time of use rates. Do you see that?
Yes, I do.
Okay. And I think you just mentioned you're involved in the PC 44 working group.
Yes.
And you're aware of the, I think it's 9761 Drive Act proceeding?
Yes, I am.
Okay. And are you aware of Public Conference 77?
Yes, I am.
And those are statewide, or those are commission-directed dockets?
Yes.
Where all utilities can participate in them?
That's true.
Right. And just to reiterate, you see that the commission actually indicated that it would revisit this conversation within its time of use proceedings.
You're talking about this order on page 191?
Yeah.
That the commission may revisit it, yes.
And is the Drive Act proceeding a time of use rate proceeding?
It does involve discussion of time of use rates, yes.
And is PC 44 the rate design working group? Does that involve time of use rates?
Yes, it does.
And then does PC 77 also involve time of use rates?
Yes, it does.
Okay, no further questions. Thank you.
Yes. One moment, Your Honor. Ms. Whited, do you recall Pepco's counsel asking you about embedded cost studies?
Yes, I do.
Can you please explain when embedded cost studies, when or how they're appropriate?
Yes. So embedded cost studies are great for cost allocation. You take the company's revenue requirement, you have to allocate it across the classes. But when it gets to rate design, marginal cost of service studies or marginal cost analysis is much more appropriate. And this is because of basic economics, which holds that efficient price signals are based on marginal costs. And in the case of electric utilities, that's long-run marginal costs, as witness Bluzuna has also acknowledged. And the reason is that if you only relied on embedded cost of service studies to develop rates, you would be backward-looking, right, and not thinking about how customer behavior impacts costs going forward in the future. And so if we're only focused on those historical costs and we're designing rates saying, okay, those historical costs, those embedded costs don't change, then we're providing no price signals to customers about how their behavior now impacts costs in the future. So for example, if customers use more electricity on a hot summer day, that in turn can lead to additional investments in the electricity system, right? And that's more costly. So that's the concept of marginal costs. And that's a really important component of rate design because we want to provide efficient price signals to customers to guide customer behavior. So if you're only looking at embedded costs, you're missing that entire part of rate design. And I do want to acknowledge that, of course, we need to recover those embedded costs, right? So if you only do pricing based on marginal costs, it's only by pure coincidence, Bonbright says, that those marginal costs will equal the company's revenue requirement. So you have to do some adjustments. And there are other considerations such as, gradualism. In this case, we already have seasonal rates, so gradualism here is not a concern if we keep seasonal rates. My main concern is that Pepco would move away from marginal cost pricing entirely, and that's just not consistent with economics. It's not consistent with efficient price signals. And that's the reason for looking at marginal costs as opposed to only looking at embedded costs like Pepco did.
Thank you. And do you recall Pepco's counsel asking you about other proceedings before this commission that involve time of use rates, such as PC 77, case 9671, the Drive Act proceedings?
Yes, I am.
Is your recommendation in this case at all inconsistent with what's going on in those proceedings and in furtherance of Maryland's energy policy goals?
No, not at all.
I have no further questions. Thank you.
Okay, Commissioner Hoover goes first.
So we've been dealing with affordability issues related to the dramatic increases in the supply part of the energy issue. And one of the things we've done, quite honestly, is try to move things around given the different seasons for the utility, and in fact take advantage of the shoulder months as a way of trying to avoid having the perfect storm of the high supply cost increase occur at the same time as the usage goes up. Is the recommendation you're making us today going to make that ability for us to continue to do that more difficult?
I don't think so. And certainly it would not be at odds with the long-term goal of affordability by providing customers with efficient price signals, right? You don't want to have shocks, and that's very difficult when supply costs are changing rapidly. But underlying this all, is the idea that if we don't provide customers with efficient price signals that reflect the underlying marginal costs, then customers are going to use electricity in less efficient ways, driving up costs on the system, and that's going to undermine affordability. So I think we need to keep that in mind, those long-term principles of affordability and economic efficiency in mind.
Okay, all right, that's all I have.
McLean?
No question, sir.
Linton?
No questions.
Suchman?
No questions.
I have a question. I agree with the notion that we should be giving proper price signals to people, perhaps to use more electricity during the wintertime, but isn't the real reason people don't use heat pumps the high upfront cost of heat pumps and not the price signals?
I think that depends on the individual customer, but a lot of people do take into account the operating costs, right? And so if you have the high upfront cost, I agree completely. That is certainly a barrier, and we have rebates provided in Maryland and elsewhere to help defray those costs. At the same time, I think customers do want to know, how much is this going to cost me to operate? And you can't do a lot about the supply portion of the bill, but on the distribution side, if you get rid of seasonality there, you're going to be increasing heat pump customer bills by, say, $45 by my calculations for 2,000 kilowatt hours per month, that kind of usage. So an extra $45 a month to a customer using their heat pump, I think that's going to factor into customers' calculations. So to offset that, what are you going to have to do? You're going to have to increase the rebates that you provide customers, because it's not going to pencil. It's going to make it more difficult to pencil for customers. So, it's either you increase the rebates to compensate for the fact that you just increased the winter distribution rate. I don't think that that's the most efficient way of encouraging customer responsiveness. I think that providing price signals in the rates is more efficient. Anyway, that's...
Okay, thank you.
long-winded.
That was my only question, so thank you very much. And your next witness.
At this time, we'd call Colin Fitzhenry to the stand.
I do.
All right, I'm going to dive in. Good afternoon, Mr. Fitzhenry. How are you?
Good. How are you doing?
Good. Can you state your name for the record, please?
Yes, it's Colin Timothy Fitzhenry.
And can you please state the name of your business and its address?
Yes, my business is Burbaker and Associates, and the address is 16690 Swingley Ridge Drive, Chesterfield, Missouri 63017.
And what position do you hold at, I think it's abbreviated BAI?
That's correct. I'm a principal.
Okay. And Mr. Fitzhenry, did you file direct testimony in this case titled the Direct Testimony of Colin T. Fitzhenry on January 30th, 2026, under mail log number 326735, consisting of 41 pages of narrative testimony, 1 appendix, and 1 exhibit?
Yes.
And did you also have file revised direct testimony of Colin T. Fitzhenry dated today's date, May 1st, 2026, under mail log 329632, consisting of 28 pages of narrative testimony, 1 appendix, and 1 exhibit?
Yes.
And what is the difference between the initial version of your direct testimony and the revised version that was filed today on May 1st?
I have revised my direct testimony to remove the forecasted fiscal test year recommendations.
And just for the record, I believe that FFTY stands for fully forecasted test.
Fully forecasted test year recommendations. My apologies.
Are there any other corrections that you would like to make to your direct testimony?
Yes, I have one correction on page 22, footnote 27. The footnote reads, see direct testimony of OPC witness Melissa Whited. And that's Pontomac Edison's Power Company's application for an electric multi-year rate plan, ML number 234018, case number 9655, filed March 4th, 2021. That footnote should read, see direct testimony of OPC witness Dennis Stevens and Paul Alvarez, Pontomac Edison Power Company's application for an electric multi-year rate plan, ML number 234018, case number 9655, filed March 4th, 2021.
Thank you. Your Honor, at this time I would like to mark the revised direct testimony of Colin T. Fitzhenry as the revised direct testimony filed on May 1st, 2026 is OPC Exhibit 36.
So marked. Please send us an email.
Mr. Chair, for the sake of convenience, for purposes of cross-examining this witness, it may actually be easier if we were just to rely on the testimony that all the parties had prior to today.
Okay.
Because then otherwise we're gonna go back and forth in terms of page numbers.
Right.
And it's
Well-
gonna be confusing for everybody.
Sure. We can certainly accommodate that. What I would suggest is that I'm going to go ahead and just put in the direct testimony under an exhibit.
Yeah, no, that's fine. I'm just, for purposes, I'm assuming Mr. McKeel would rather rely on the testimony that was already, okay. And I would too. Thank you.
Very sensible plan.
I have copies I can give him unless you've got it already.
I have the initial versions and the red line version.
Okay, cool.
Yep.
Okay.
But we'll still accept the so marked, and what else do you
Yeah.
want?
So just for the marking purposes, just to clarify, OPC Exhibit 36 will be the revised direct testimony of Mr. Fitzhenry, and OPC Exhibit 37 will be the originally filed version of his direct testimony. That was the version filed on January 30th, 2026.
Okay. So marked.
Thank you. And Mr. Fitzhenry, did you also file sir rebuttal testimony in this case titled the sir rebuttal testimony of Colin T. Fitzhenry on April 16th, 2026, under mail log number 329095, consisting of 24 pages of narrative testimony and 1 exhibit?
Yes.
And were confidential and public versions of your sir rebuttal testimony filed?
Yes, there were.
Did you have cause to be filed the revised sir rebuttal testimony of Colin T. Fitzhenry dated May 1st, 2026, under mail log number 329632, consisting of 18 pages of narrative testimony and 1 exhibit?
Yes.
And can you please explain the difference between the initial version of your testimony and the version that you filed on May 1st?
Yes, similar to my direct testimony, my sir rebuttal testimony was revised to remove the fully forecasted test year recommendations.
Okay, thank you. And can you explain why you did not file a confidential version of your revised sir rebuttal testimony?
Yes, my confidential portions of the testimony were related to the Quanta study, which is my understanding is no longer confidential.
Okay. Your Honor, I would like to mark the revised rebuttal testimony of Colin T. Fitzhenry filed on May 1st, 2026 as OPC Exhibit 38.
So marked.
And then I would like to mark, similar to what we did with the direct testimony, I will mark the public version of Mr. Fitzhenry's rebuttal testimony as OPC Exhibit 39.
So marked.
And then the confidential version of his rebuttal testimony as OPC Exhibit 39C.
So marked.
Is that?
There is no C on 39. It's all public now, is my understanding, Your Honor.
So I guess it's
The-
40.
The consensus in the room is that we don't need to do that, so it will just be OPC 38 and 39 for the rebuttal testimony, one revised, one original.
Yep. So marked.
Mr. Fitzhenry, were each of these testimonies prepared by you or under your supervision?
Yes.
And if you were asked these same questions today, would your answers be the same?
Yes.
Your Honor, at this time, I would move for admission into the record. I guess I can move all of them in. And,
Yeah.
So it would be OPC Exhibits 36, 37, 38, and 39.
Without objection, so admitted.
And the witness is now available for cross-examination by other parties.
Okay.
No questions, Your Honor.
MEA,
No questions.
staff.
Staff has a few questions. In your direct testimony on page 21, you say the legal standard for prudence is a no hindsight test. Could you explain what that means?
And just to be clear, are you referring to the revised version or the
All of my questions will use the original
version?
versions.
Okay. Thank you.
Yes, so a no hindsight test means that you can't use new information that was not available to the utility at the time the decision was made in determining prudency.
So it all depends upon the information that was available at the date of the decision?
Yes, that's correct, or decisions.
Turning to your rebuttal testimony on page 10 through 11, you offer a timeline that led up to the construction of the White Flint substation.
Yes, I'm there now.
For the events on this timeline, if you were going to apply a prudency test to the White Flint substation, which of these events would be the date that would be the basis of the no hindsight test?
Yeah, so I would say the most important date would be, item number 6 on page 11. Essentially, when the company made the decision to resume construction. With that said, if the company were to have knowledge that, all or parts of the substation would not be useful, even during the construction phase, if they could limit the ongoing costs to be incurred and passed on to customers, if not all components of that substation were needed, that should also be considered. So my answer is number 6, following the quanta load study would be the most important time before construction began, but additional considerations should be made during construction.
Thank you. Turning to page 15, at lines 3 through 7, you discuss the fact that the substation now operates at a significantly low utilization ratio as evidence that the initial forecasts were flawed and that the project should have been deferred. Could you tell me why this is not use of hindsight in evaluating this decision at that time?
Well, I think it's really the evidence leading up to this comment that demonstrates, the no hindsight review. Essentially, what I do in the pages leading up to this is identify several evidentiary pieces that were available to the company when they made that decision. And ultimately, what that culminated in was that, where we stand today is that the most recent forecast demonstrates a low to zero utilization ratio for the utility, and that only confirms that the evidence in the record up to that point demonstrated that this project was not prudent to execute at the time the company made that decision.
Thank you very much. You don't recommend that the entire White Flint substation be disallowed, do you?
That's correct. My recommendation proposes that 64.2% of the plant additions included associated with ITN I believe it's 74020 should be disallowed.
And what is the basis of your percentage of disallowance?
Yeah. So what I looked at was the company's most recent forecast, and my disallowance is based on the understanding that the project is in service, and that a portion of the capacity may be used and useful, but the majority of the project will not be useful to customers over the most recent 10-year forecast.
Thank you. And if the commission were to adopt your recommendation and disallow for this rate case 69 or 64.2% of the cost of the substation, would the company have the opportunity to recover any of this disallowance in the future?
I think my recommendation, to be clear, is that the commission disallow the approximately $44 million, I believe, associated with the cost of this substation. With that said, my understanding is that the cost recovery for this substation, since it's a large capital investment, will incur over many decades. I believe the commission has wide discretion to revisit any of its past decisions and reconsider the cost recovery of capital investments that are in service.
If by the time of the next rate case after this one, it turns out that, say, the White Flint substation is being used at, say, 75% of its capacity, would the company have an opportunity at that point to request a further allowance of the White Flint substation?
I mean, if your question is more a legal nature, in which you're asking me about what within the regulatory framework allows a company to request something or not request something, I don't know the exact answer to that. That would be more dependent on a legal interpretation.
Would that be something you would recommend?
Would I recommend that if the utilization ratio, well, the 64.2%, to be clear, is an unutilized ratio. The actual portion being, forecasted to be utilized is the opposite side of that, the 34%. So let's say, are you asking that, say, 75% of the substation is
being used at that time?
Would I recommend that the commission revisit the decision?
Yes.
I think it would probably, I would have to probably look at the full evidentiary record of, what else is going on that's included in that forecast. For example, is that just due to a substation retirement or other variables that would have to be considered? I'm not sure I could make that recommendation with just that limited amount of information.
Thank you. Staff has no further questions. Thank you.
Thank you.
Pepco?
Yes. Could you turn to page 7 of your original direct testimony, sir?
Sure.
I think it might be the same as your revised, but I don't have a copy here, so I'm just going to stick with your revised if you're okay with that.
My original, correct?
Your original, I'm
Yes,
sorry.
That's fine.
And I'm looking there at pages 9 through 14, and you indicate there that the company measures electric service reliability using several reliability metrics, SAIDI, SAFE, MAFE, and CME. Is that correct?
Could you give me a line number? I'm sorry.
Yeah, I'm looking at lines 9 through 14, sir?
That's correct.
And you would agree with me, would you not, sir, that Pepco uses the above referenced metrics because those are the metrics the legislature required Pepco to report pursuant to PUA Section 7-213 and the service quality and reliability standards promulgated by the Commission as required by Section 7-213?
I understand that the company's required to report those metrics, yes.
And that's why the company used those metrics in its testimony, is that correct?
I can't speculate on behalf of the company. If you can point me to a page number of Mr. Allen's testimony where that's asserted.
All right. Mr. Alla's testimony is in the record, right?
It is.
Okay. And you've reviewed, have you not, PUA Section 7-213, sir?
Yes, I have.
And you would agree with me that that section required the Commission to promulgate those service quality and reliability rules, is that correct?
That's my understanding.
And you would agree with me that SADE and SAFE were specifically mandated by the law to be reported, is that correct?
Yes, I believe that to be correct.
So you would agree with me that Pepco is not cherry-picking information like you claim at page 10, lines 18 and 19 of your direct testimony. Pepco was showing the data the legislature and the Commission requires the company to report to demonstrate service quality and reliability. Is that correct?
I understand they're reporting on information that's required. I think a more fulsome reliability analysis would include SADE without MEDs, as I state here in my testimony.
Okay, so it's your view that the correct metric to focus on is SADE with major event days. Is that correct?
I would say it should be focused in addition to the other metrics you've discussed.
And if you look at your direct testimony, the original direct testimony, page 11, lines 1 and 2, you indicate there that SADE, and for the court reporter, and I apologize, SAIDI with MED reflects the total customer experience, measuring the total average outage duration, including all catastrophic weather and extreme events. Is that your testimony, sir?
Yes, it is.
And you claim at page 11, lines 1 and 2 of your direct testimony that Pepco, quote, ignores, close quote, the SADE MED metric. Is that correct?
That's correct. It wasn't reported in the company's direct testimony.
But that's not what you say. You say that the company is ignoring that. Is that correct?
Can you point me to the line number?
Yes, it's on page 11, lines 1 and 2.
Right. I think what I'm suggesting here is that the company ignored SADE without excluding MEDs in its direct testimony.
Okay, but you would agree with me that Pepco doesn't ignore SADE with MEDs. Is that correct?
My understanding, it's been reported in by the company in other proceedings.
Okay, I need to get an exhibit marked, Your Honor. I believe it'll be Pepco Exhibit 60.
60, yeah.
Mr.
There you go.
Fitzhenry, I hand you what I asked be marked as Pepco Exhibit 60, and that's OPC's response to Pepco Data Request 9-7. Is that correct, sir?
That's correct.
And you're the sponsor of that
Yes,
data
I am.
request?
Yes, I am.
And you would agree with me, well, first of all, I'd move the admission of Pepco Exhibit 60.
So marked and without objection admitted.
And you would agree with me, sir, that in the past that the Office of People's Counsel has requested that the commission promulgate regulations related to Sadie Med. Is that correct?
Can you restate that question?
Yeah, well, just look at Exhibit 60, sir. And that asks you to enact the state goal, the commission's promulgated certain rules. Do you agree the commission did not promulgate regulations in COMAR 2050 that include Sadie with Med as part of the regulations to enact the state goal?
Yes, I agree.
And so those aren't part of the requirements of the state goal that is found in statute, in the statute that we talked about earlier, 7-213. Is that correct?
That's correct.
And you would agree with me, sir, would you not, that in case number 9353, that OPC asked this commission to set minimum Sadie Med standards in the service quality and reliability standards last year?
That sounds correct.
Well, let me get an exhibit marked, since it only sounds correct to you, sir.
Yes, I don't recall the exact request.
Yeah, we'll clear it up. May I approach the witness?
Yes.
I believe this is Pepco Exhibit 61, Your Honor. Mr. Fitzhenry, I hand you what I asked be marked, that has been marked already as Pepco Exhibit 61. Are you the sponsor of that data request, sir?
Yes, I am.
And I have excerpt a quote from the commission's order there, order number 91799, where at page 47 the commission stated the commission will not set minimum Sadie Med thresholds, since staff notes that it makes no conclusions regarding the need for resiliency programs at any utility absent more data. Do you see that?
Yes, I do see that.
And does that indicate that the commission rejected OPC's request to promulgate a Sadie Med requirement in the service quality and reliability rules, sir?
This data request doesn't have OPC's exact recommendation. It just has the commission's response to OPC's recommendation, or I guess staff's note to OPC's recommendation. With that said, subject to check, I'll concede that it appears that OPC did make a recommendation in this proceeding to include Sadie with MED.
And did you want me to go through the entire order, sir? Or
I said I had agreed subject to check. If that's good enough for you.
That good enough for my work, sir.
Okay.
Thank you.
Do you want to enter this?
I do, Your Honor. With that, I'd move the admission of Pepco Exhibit 61.
Without objection, so noted and admitted.
And you would agree with me, sir, nevertheless, the commission has required its staff to report on each Maryland utility's Sadie Med in the annual reporting that companies do to comply with the service quality and reliability rules. Is that correct?
That is correct.
Okay. And then I need to get another exhibit marked, Your Honor, and I guess it'll be 62. And Mr. Fitzhenry, I hand you what has been marked as Pepco Exhibit 62, And that's a package of data requests. Data requests 14.2, 14.3, 14.4, 14.5, 14.23, and 133, sir. Are you the sponsor of all of those data requests?
Yes, I am.
I would ask that Pepco DR, or Pepco Exhibit 62 be admitted to the record.
Without objection, so admitted.
And so in DR 14.2, I asked you whether or not the staff calculated Sadie Med for the 5 years 2018 through 2022, and that based on the staff's calculation included in their report filed on annual reports that Pepco was the most resilient utility in Maryland. Is that correct?
Yes.
And that was based on Sadie Med?
Yes, it was.
And in DR 14.3, for the 5 years 2019 through 2023, staff in its annual report in the service quality and reliability rules found that Pepco for those 5 years was the most resilient utility based on staff's calculation. Is that correct?
Yes.
Had the best Sadie Med? Pepco did for those 5 years?
Yes, I believe that to be correct.
And DR 14-4 for the 5 years 2020 through 2024. Same thing. Pepco was the most resilient utility in Maryland based on staff's calculations, correct?
Correct.
And last but not least, in staff's annual report in 2024, which was the most recent one, the same calculation indicated that Pepco's 5-year average of Sadie Med was the lowest in Maryland. Is that correct?
Yes.
And so Pepco's Sadie Med was 41, correct?
The average for 2024 was 41.
Right. And Potomac Edison was 52.2?
That's correct.
All right. And then finally, you didn't provide in your direct testimony or your sir rebuttal testimony, did you, sir, any industry benchmarking regarding the use of Sadie Med for resiliency programs? Is that correct?
I did not compare Pepco's Sadie Med metric to that of other utilities.
Okay. And then finally in 133, we asked you to determine what quartile Pepco was across all utilities for Sadie Med, and you didn't conduct that analysis. Is that correct?
That is correct.
Now, you have reviewed Mr. Allo's rebuttal testimony. Is that correct?
I have.
And would you agree with me, sir, that Mr. Allo's rebuttal testimony indicates that nationwide Pepco has consistently been in the first quartile for Sadie Med?
Yes, I recall that statement.
And you don't dispute that anywhere in your sir rebuttal testimony, do you, sir?
I do not.
Now, in your sir rebuttal testimony at page 9, line 17, if you could turn there, sir, and again, I forget what we're calling it, the original. Yeah, I'm looking at the original. I think that's, if you could look at page 17 there, sir.
I'm there.
And I'm sorry, I meant page 9, line 17, and my apologies. That's the testimony. That is out now. Page 9, line 17. Do you see your answer there? And that's your answer to Mr. Allo's rebuttal testimony, is that correct?
That's correct.
And you indicate that Pepco should, even though Pepco has a good Sadie Med number and it's in the first quartile nationwide, they should still be driving for improvement in Sadie Med. Is that correct? I'm looking at line 16. Furthermore, despite the first quartile performance,
Yes, the average Pepco customer has not seen meaningful improvements in duration of outages over the last 5 years.
right. And so Pepco should still, even though they're in the first quartile, Pepco should still be trying to improve its Sadie Med. Is that correct?
No, that's not my conclusion here. My conclusion is that the company has consistently made distribution investments over the past 5 years that were meant to improve system performance and improve reliability. As a result of those investments that were paid for by customers, customers should receive the benefit of that improvement by seeing reduced outages from their perspective, right? Over that 5-year period, there has not been any noticeable trend in a decrease in outage minutes experienced by the average Pepco customer.
All right. I need to mark another exhibit. It's Pepco Exhibit 63. I hand you what's been marked as Pepco Exhibit 63, sir. Are you familiar with this package of DRs?
I am.
And you're the sponsor of the answer to DR 134, is that correct?
I am.
And you're the sponsor to 1435, and you are the sponsor of 1436?
Yes.
Okay, I would move the admission of Pepco Exhibit 63.
With no objection, so admitted.
And so in your direct testimony at page 12, lines 8 through 12, you argue that Sadie Med is important because long duration outages are ones that the customers care about because it can lead to food spoilage. Is that correct?
That's correct. I would say the average residential customer cares more about long duration outages.
Right.
Than a momentary outage.
And you would agree with me, as you did, I think you answered DR 1435, that for Pepco customers, 65.5 minutes is the average total outage minutes experienced. Is that correct?
Yeah, that's correct. So what that means is that there potentially could be a customer experiencing 0 minutes, whereas there also could be another customer experiencing 8 hours, right? It's just the average across the entire customer base.
Right, and that happens sometimes when you have major storms or a derecho. Is that correct, sir?
Long duration outages?
Yes.
Yeah, potentially those could lead to long duration outages, sure.
And most of the time, customer long duration outages are caused by what I'll say are quote unquote acts of God. Is that correct?
I have not reviewed the cause codes associated with Pepco's outages, so I can't really represent any conclusions about this particular data set. I would say in general, yeah, when you see severe weather events, those are more likely to lead to long duration outages than maybe an outage experienced on a blue sky day or when there's not a large scale weather event occurring.
And you would agree with me, would you not, when it comes to blue sky, Sadie and Safety, that at least for a number of years, Pepco has had the best Sadie and Safety in Maryland?
That's my understanding.
And so they've got both the best blue sky Sadie and Safety, and they have the best Sadie Med. Is that correct?
I mean, I can't speak for the recent performance or what happened in just last year, but I would say, generally speaking, based on 5-year averages, it's been in the top tier of Maryland utilities.
Okay, fair enough, sir. If you could, sir, I'd like to have you turn to page 12, I believe, of your direct testimony, and I'm focusing there on pages 8 through 12, sir. Let me know when you're there.
I'm there.
And so there you say that OPC advocates for prioritizing O&M solutions, particularly proactive vegetation management, as an impactful method for reducing frequency and duration of outages customers care about the most. Is that correct?
That's correct.
And as we talked about, those long duration outages that customers care about most, according to you, are ones that can lead to food spoilage. Is that correct?
I would say, like as I said previously, I would say a longer duration outage is generally more impactful to the average residential customer.
And it's OPC's position and your position in this case that proactive vegetation management can help reduce long-term duration outages. Is that correct?
Yes, I would suggest it's one of the solutions for reducing long duration outages.
I need to get another exhibit marked. It would be Pepco Exhibit 64. Mr. Fitzhenry, I hand you what I asked be marked as Pepco Exhibit 64. Is that Pepco? Is that your response to Pepco DR 135?
Yes.
And does that ask the basis of your claim that about outages related to vegetation management, sir?
Yeah, this supports the basis of that claim.
And you cite a document in there, do you not, sir?
I do not cite a specific document in this DR.
Okay. You say that the statement is based on both reliability data and broader industry empirical studies. Is that correct?
Yes, that's correct.
Okay. I would move the admission.
Without objection, so admitted.
You would agree, would you not, Mr. Fitzhenry, that Pepco conducts proactive vegetation management?
Yes.
And you responded to that in DR 1418, is that correct?
Do I have that here in this?
You don't. I could hand it. I was just trying to cut down on the
Sure,
exhibit.
sure. I would say I responded to that DR.
Okay.
Sure.
Okay. And you agree that Pepco conducts proactive vegetation management, correct?
Yes.
And Pepco conducts cyclical pruning and vegetation management in compliance with the service quality and reliability standards found in COMAR 2050-1250. Is that correct?
That's my understanding.
And you would agree with me that to the extent the company has legal rights to do so, it removes danger trees. Is that correct?
My understanding that's part of the company's practice, yes.
And you would agree with me that Pepco has no rights to remove danger trees that are not on Pepco's right-of-way. Is that correct?
That's my understanding with usual utility practice.
And you would agree with me that Pepco asks customers if it can remove danger trees from private property, but if the customer refuses, Pepco can't remove those trees. Is that correct?
Again, I would say that's usually, in line with standard utility practice for vegetation management.
Okay. And you would agree with me that Mr. Williams testified under oath that in 2025, 65% of the vegetation management outages caused on the Pepco Maryland system were caused by off right-of-way trees?
I don't recall listening to his testimony, but subject to check, I would agree with you.
All right. I need to get another exhibit marked. It'd be Pepco Exhibit 65.
But will we get to 100? That's what.
Are you cutting them off?
Yeah, I'm cutting them off at 100. Sorry.
Sir, I hand you what's been marked as Pepco Exhibit 65. Is that your response to Pepco Data Request 9-30, sir?
Yes, this is the attachment I provided.
And you're the sponsor of that data request?
Yes, I am.
And this data request seeks you to provide copies of the broader industry empirical studies that supported your statement about long duration outages. Is that correct?
Yes.
And you cite there to a report on vegetation management resilience investment guide conducted, I guess, by the Berkeley Labs. Is that correct, sir?
That's correct.
With that, Your Honor, I'd move the admission of Pepco Exhibit 65.
Without objection, so admitted. I'm cutting you off at 100.
Okay, fair enough. I'm going to take that deal, sir. I'm only on 65.
I know, you go all the way up to 99.
I will not. I'm going to take the way under on that. But I have insider information. Could you turn to page 3, sir, of that document?
I'm there.
And there it indicates disadvantages. Do you see that, sir?
Yes, I see that.
And the report says often it is vegetation debris that comes from plants outside utility right-of-ways that causes the most damage in extreme events. Do you see that?
Yes, I do.
And you would agree with me the fact that most vegetation outages are caused by off right-of-way trees is consistent with your own experience reviewing vegetation management issues with utilities. Is that correct?
You're saying that's consistent with my own experience?
I am indeed, sir.
I can't say from my own experience whether that's more common or less common than
Okay.
trees within the right of way. I understand from the company's testimony for that it was the majority for Pepco, though.
Fair enough. And in fact, in the study that you cited me to as I was learning all about this, it says it's often vegetation and debris from outside the utilities right-of-way that cause the most damage. Is that correct in extreme events?
Yes, that's correct.
And extreme events are the events that we're talking about when we're discussing Sadie Med. Is that correct?
It could be potentially be an extreme event, an extreme event. Although I would say that your conclusion here is not accurate. That simply because often it is vegetation debris that comes from plants outside of the right of way that cause the most damage in extreme events. That's mostly because the vegetation inside the right of way was already removed, right? Had that vegetation been there, then it would likely have caused damage. So I can't say that there's any sort of causal principle to your conclusion that damage outside the right of way is more likely to cause damage than vegetation inside the right of way. It's simply because that vegetation isn't there.
And that vegetation isn't there because Pepco has proactively trimmed that vegetation in compliance with this commission's rules. Isn't that correct?
I would say largely there's less vegetation inside the right of way due to vegetation management. That's correct.
And your own study that you cited me to said off right-of-way trees in extreme cause outages, right?
I would say off right-of-way trees are outside the company's control, right?
Mm-hmm.
But that doesn't support the conclusion that, ensuring that vegetation management inside the right of way is done, with an adequate frequency and with, prudently, would somehow not avoid future outages or long duration outages.
Sure, but you would agree with me that this commission has dictated the pace of our vegetation management, is that correct?
I agree with that.
Okay, may I approach the witness, Exhibit 65, and I would move the admission of Exhibit 65, and I need to get another exhibit marked.
I think we already accepted that.
Okay, I'm sorry. This is Pepco Exhibit 66.
Get your kicks on Exhibit 66. Committee.
Are you on the committee?
Mm-hmm.
So did you see Jeff Wood or send something?
No, I haven't been.
Now, Mr. Fitzhenry, I hand you what I asked you marked as Pepco Exhibit 66. Are you familiar with that answer, sir?
I am.
And I asked you a series of questions to get to where in your testimonies that were attached to your Appendix A of the direct testimonies that you filed at various commissions on where you had testified about vegetation management. Do you recall that?
I do.
And initially, you had said you hadn't testified about the issue of vegetation management in response to a series of DRs. Do you recall that, sir?
I'm not sure that was my response. And in several of these data requests, you asked, various questions about where I've testified previously and about reliability. I'm not ever sure I ever fully responded that I had never discussed vegetation management in any of my testimonies.
All right, fair enough. But in response to this data request, you provided me some information about the vegetation management testimony that you had given. Is that correct?
That is correct.
And that was for a company, Consumers Energy, before the Michigan Public Service Commission, right?
That's correct.
And it says, you observed the majority of Consumer Energy's outages were the result of trees outside the row. And row stands for right-of-way, is that correct?
That's correct.
52%, is that correct?
That's correct.
And that's the only information you gave me. And that indicates that, at least for this utility, that action is fully consistent with what occurred in Pepco. Is that correct?
I'm not sure I understand the connection there.
Most vegetation management outages are caused by off right-of-way trees.
Well, that's not what this says. This says that trees or trees outside of the right-of-way trees outside the right-of-way cause 52%.
Okay. So it doesn't disaggregate those?
Yeah, that's my understanding of this response, yes.
Okay. Do you know what the percentage was?
These percentages were not aggregated by me. I asked for a DR to this company asking for the type of outage by cause code, and that's how they provided the information. So I have no way of disaggregating those two values.
All right, I'd move the admission of Pepco Exhibit 66.
Without objection, so admitted.
You didn't conduct any analysis on how proactive vegetation management would avoid specific capital investments. Isn't that correct, sir?
Yeah, that's correct.
And you do not make any recommendations with respect to Pepco's vegetation management study or vegetation management budget in this case. Is that correct?
That's correct.
Now, would you agree with me, sir, that O&M solutions such as vegetation management may yield temporary benefits with expenditures recurring more frequently than CapEx solutions that have longer duration benefits?
I would say that certainly operating expenses are expenses that incur on an annual basis. Vegetation management has to be performed on an annual basis because vegetation regrows. Capital investment depending on the type of investment, generally has an operational life longer than a single year. And that will only need to be additional capital investment, only needs to be performed when generally that equipment either fails or reaches the end of its operating life.
Okay, and you would agree with me, sir, in order number 91799, the commission stated the commission takes no position on OPC's conclusion that targeted improvements that promote O&M over CapEx are preferable, since O&M solutions such as vegetation management may yield temporary benefits with expenditures recurring more frequently than CapEx solutions, which have longer benefit durations, correct?
Subject to check. I don't have that order in front of me.
All right. At page 12 of your direct, lines 8 through 12, besides vegetation management, you claim there may be other, quote, solutions. Is that correct?
So page 12 of my direct testimony.
I did, sir, and I was focusing there on lines 8 through 12.
Sorry. I'm sorry, I was looking at the wrong one.
Yeah, no worries.
Yes, that's my testimony.
Okay, I need to get another exhibit marked, Your Honor. It'd be Pepco Exhibit 67. Mr. Henry, I've handed you a package of DRs that have been marked as Pepco Exhibit 67. Those are DRs 18, 916, 917, 918, 919, and 920, sir. Are you the sponsor of all of those data requests, sir?
Yes.
And in each of those data requests, starting with 8.1, I asked you what the other operational strategies might include, and you indicated refurbishment, routine maintenance, condition-based maintenance, grid optimization and control, and non-wire alternatives. Is that correct?
That's correct.
And you agreed in 916 that Pepco does refurbish equipment, correct?
Yes.
917, you agreed that Pepco performs routine maintenance. Is that correct?
Yes.
918, that Pepco performs condition-based maintenance.
Yes.
919, that Pepco engages in grid optimization and control. Is that correct?
Yes.
And on 920, sir, you indicate you didn't suggest that the company should expand its grid operations, optimization and control solutions or other programs. Is that correct?
That's correct.
So Pepco essentially does all of the other items that you suggest in your direct testimony. Is that correct?
It does not do non-wire alternatives, or it was not mentioned in these discovery responses.
Okay. Well, we're going to get to that. Sir, at page 24, lines 6 through 8 of your direct testimony, you recommend that you be provided with broad directive that the company to prioritize reliability and resiliency investments designed to improve safety and safety. Is that correct?
I'm sorry, you said page 24.
Lines 6 through 8. I believe it's in your direct testimony, sir. And if not, let me look at your sir rebuttal.
Yeah, I'm looking at my direct testimony, and page 24 references the White Flint substation.
I'm sorry. Then it's in your sir rebuttal testimony. I apologize, sir. Could you turn to page 24 of your sir rebuttal testimony?
Okay, I'm there.
And I'm focusing on lines 6 through 8. your recommendation provided was a broad directive for the company to prioritize reliability and resiliency investments designed to improve safety with MED. Is that correct?
Yes.
Now, we've already agreed that Pepco has the best blue sky reliability, and we've also agreed that Pepco has the best safety MED of Maryland EDCs. Is that correct?
That's correct.
So doesn't that indicate, sir, that Pepco is prioritizing reliability and resiliency investments that are improving those metrics?
You're saying the company is currently prioritizing investments that include that improve safety without MED and safety without MED?
And
Just broadly.
safety with MED.
Well, I would say, looking at a historical basis, the investments that the companies historically prioritized haven't improved safety with MED.
Now, at page 11 of your direct testimony, you talk about the correlation between reliability investment and improvement in service reliability. Is that correct? Focusing on lines 6 through 11?
Yes.
And you would agree with me that that's fully based on the evidence that OPC presented in the 9353 proceeding. Is that correct?
Well, in these previous pages, I also, have some, discussion here of the historical safety with MED metrics that I present. However, in terms of correlation, I didn't present any correlation values. That was presented in the comments by OPC, I believe.
And that was our friend, the Pearson coefficient?
That's correct.
Okay. And you would agree with me that the commission, in the order that we have been talking about before, did not accept those in use of the Pearson coefficient in order number 91799. Is that correct?
I don't recall exactly what they had said in response to the usage of the Pearson coefficient. I acknowledge here in testimony that the commission acknowledged that Pepco may be reaching a point of diminishing returns on capital investments.
Then I'll need to get another exhibit marked, Your Honor. Be Exhibit 68.
Sorry.
Sir, Exhibit 68 is a package of data requests. They are data requests 1426, 1427, 1428, 1429, 1430, and 1431. Is that correct?
Yes.
And you're the sponsor of all of those data requests, sir?
Yes, I am.
I would just move the admission of Pepco Exhibit 68, Your Honor.
So marked and without objection, so admitted.
And I would move in Exhibit 67 too, also.
Did we not do that? Without objection, so admitted.
Okay. Just some highlights. You didn't do your own Pearson correlation analysis, is that correct?
That's correct.
And you didn't rely on any data sets that were developed by you, is that correct?
For what?
For coming to the conclusion that there's a correlation between the reliability investment and improvement in service
That's correct.
reliability.
I didn't perform any correlation analysis.
You performed no analysis, correct?
No, that's not correct. As I said previously, I presented historical evidence of historical trends with safety with MED in my own testimony, and that supports my conclusions in addition to the evidence provided here by OPC's comments.
Okay, and you took no steps to address the Commission's reservations about the size of the data set used in case number 9353, isn't that correct?
I didn't re-perform the analysis, so that's correct.
Okay. I'd move the admission of Pepco Exhibit 68, Your Honor.
I think we already did that.
Okay, sorry, I apologize. Could you, sir, turn to page 21 and 22 of your direct testimony?
I'm there.
And that's where you talk about the prudence standard, is that correct?
That's correct.
And you indicate there on lines 14 and 15 that the commission determines prudence of a project expenditures primarily through a retrospective evaluation known as prudence review. Is that correct?
That's correct.
And I think as you responded to staff counsel that the legal standard is no hindsight. Is that correct?
That's correct.
And so that means the commission evaluates whether the utilities decision was reasonable based on the facts and circumstances known or that should have been known at the time the decision was made. Is that correct?
That's correct.
Now, you provided in, I believe, your rebuttal testimony, sir, what you said is the timeline of White Flint. Do you recall that?
I do.
And you indicated, I believe, to Mr. Dean that the key prudence evaluation that you were doing, if I understood that right, was after the Quanta study. Is that, did I understand you to say that correctly?
Yeah. I would generally you say that, that was probably the, if we were going to pick a singular point in time that was most important to making the decision was before the company began to incur expenditures related to the project, right?
Okay, so you agree with me, and you changed your footnote in your direct testimony to point out that you were relying on, you reviewed Mr. Stevens and Mr. Alvarez's testimony in case number 9655, correct?
That's correct, I did.
And you would agree with me that Mr. Stevens and Mr. Alvarez in that testimony that was filed in 2021 indicated that Pepco had already begun construction of the White Flint substation. Is that correct?
I don't recall the exact phase of the project that the company was in at that time.
Okay.
I would say largely my understanding was that it was still within the kind of engineering and design stage and not in project execution. Whether or not the company had, broken ground, again, I would say that the majority of project expenditures, based on what I understand from the project timeline and Mr. Allo's live testimony, occurred after the Quanta study was completed.
But to properly use the hindsight standard that you tout, you should be looking at what Pepco knew when it made the decision to move forward with the White Flint solution. Isn't that correct?
Well, yes, I think, again, any number of disallowances could be recommended based on when the, when the decision or imprinted decision was made, right? So ostensibly, the company incurred expenditures related to this Quanta study, right, in order to execute that study. If the commission were to find that, at the time prior to the commissioning of that study, the utility had the information available to them to know that they should not go forward with the project, then any of the expenditures occurred after that period of time could also potentially be disallowed.
Could I get another exhibit marked? It's Pepco Exhibit 69.
Thanks.
And here, are you familiar with this DR response, Mr.
Yeah.
Fitzhenry?
Yes, this was sponsored by me.
And so I would move the admission of Pepco Exhibit 69, Your Honor.
With no objection, so admitted.
And does that indicate that's the information that you relied upon in performing your analysis to arrive at your conclusion, sir?
Yeah, at the time of my direct testimony, I would note this DR response was filed on February 20th, 2026. Since that time, additional discovery was issued. I clearly performed, more evaluation of the project in my rebuttal testimony as well.
Okay, and OPC didn't update this data request, is that correct?
I believe this data request was accurate at the time it was filed.
And you don't know whether or not OPC has a continuing duty to update their data requests?
I do not.
Okay.
I also, by the way, I'm not saying that this is inaccurate to date. I just, like I said again, based on the response here, I was providing information related to, as it referenced to my direct testimony, not my surrebuttal testimony.
Fair enough, sir.
That's the distinction I'm trying to make.
And the information that you reviewed, the additional information that you reviewed, at least that I saw in your surrebuttal testimony, was the Quanta study. Is that correct?
No, that probably was not the only piece of information. I mean, I had reviewed the Quanta study.
Oh, I took it back. Do you want me to what? Oh.
I would just say that generally there was additional evidence put into the record following my direct testimony that I had reviewed in responding to in my response to my surrebuttal testimony.
Okay, fair enough, sir. Now, your proposed disallowance is contained on pages 24 and 26 of your direct testimony, where you have requested to disallow 64.2% of the White Flint substation. Is that correct?
That's correct.
64.2, yeah.
And have you reviewed Mr. Allo's rebuttal testimony, sir?
Yes, I have.
You have a copy there with you, sir?
I do.
And could you turn to page 18 of that testimony, sir? And I'm looking at question 37.
What methodology does OPC witness use to arrive at the 64.2% figure?
Yes, sir.
Yes, I'm there.
And you didn't file any rebuttal testimony about that, and that's an accurate reflection of how you reached that calculation. Is that correct?
That's not correct. I did file a surrebuttal testimony addressing this issue.
Okay.
What I said in my surrebuttal testimony was that the main thing that Mr. Allo suggests here is that because I used the combined capacity as a utilization ratio for both Park Lawn and the White Flint substation, that somehow my utilization ratio analysis was inappropriate. And what I suggest in my surrebuttal testimony is that we look at the White Flint substation in isolation, and we only consider the Park Lawn substation capacity to meet the next 10 years. Well, the utilization ratio actually of the White Flint substation would be 0%. So with that information, my recommendation of disallowance would, I would say, be on the low end. I think you can make a reasonable recommendation to disallow the entire cost, because based on the company's most recent 10-year forecast, the White Flint substation is not needed to serve any of that capacity over the next 10 years.
And that's based on actual forecasts, correct?
No, that's based on the company's most recent forecast.
Okay. And in making your calculation, you only used one time frame. Is that correct?
In the calculation of the utilization ratio?
Yes.
Well, I would say it's a 10-year forecast, so a 10-year time frame.
But only one 10-year time frame.
Sure, I only looked at a singular forecast.
Okay. Did you also review Mr. Lowe's testimony, sir?
Excuse me, whose?
Staff witness Lowe.
I believe I did a cursory review of that testimony.
Okay. Well, let me ask you. You would agree with me, sir, that staff data request 9-1, Pepco referenced a response to a data request in case number 9702, where Pepco had provided all requested forecast documents for 2011 through 2023 that supported the repeated overloads the company had observed at the Park Lawn substation through its annual 10-year forecasting process. Is that correct?
Yeah, I do understand that the staff submitted that data request.
And did you review that data request?
Not at the time of my direct testimony, but I did prior to filing my surrebuttal testimony.
Okay. Let me hand you a copy of Mr. Lowe's direct testimony, sir. Can you turn to page 8?
Yes, I'm there.
And on page 8 of that testimony, Mr. Lowe indicates at lines 7 through 14 that Pepco had explained it proceeded due to persistent overload projections at Park Lawn and combined White Flint Park Lawn forecast exceeding Park Lawn capacity, stating the conditions were identified across 10 annual 10-year forecasts and that the project is based on forward-looking peak demand, not historical peaks. Pepco also describes reliability improvements, e.g., reduced overhead exposure, improved redundancy, and continuing cutovers to fully integrate the White substation into the network. Do you see that?
That's staff's testimony, yes.
And do you agree that staff witness Lowe did not recommend disallowing any of the White Flint core projects?
Yes, that's his recommendation.
And that's based in part on the persistent overload forecasts that were provided for those 10-year periods. Is that correct?
I'm not sure he draws that conclusion. He says here that the project's already in service. The project appears to be near complete. That's essentially why he's making that recommendation.
All right, but he does cite the persistent overloads for that 10-year period based on Pepco's load forecast that he reviewed, correct?
Yeah, it says Pepco explained, so he's basically referencing company assertions here.
They're actual forecasts that were attached to that data request, and you reviewed it, right?
That's correct.
So they're not assertions, they're actual load forecasts, right?
Well, they're actual load forecasts, whether they're accurate load forecasts or not, is more of a subjective review or a review of expert review.
Okay. You would agree with me that the annual 10-year forecast, along with the quanta study that Pepco relied upon to determine there was a persistent overload at Park Lawn Substation?
I would agree that the quanta study suggested there'd be an overload at Park Lawn Substation.
And those 10-year forecasts that were provided in response to staff DR 19-1, 10 years of 10-year load forecasts, those also showed a persistent overload at the Park Lawn Substation. Is that correct?
Yes, but based on staff's testimony here, I don't see any sort of evidence that staff reviewed the validity of those forecasts. I think what this demonstrates is that there was an acknowledgement that the forecasts existed, that they showed an overload. I don't see any analysis as to, that suggested that this witness reviewed the veracity of those forecasts. And that's my primary concern. In my review of those forecasts, I don't find that the analysis to be adequate to support, over $100 million capital investment.
And in your response to DR 435, you didn't cite that data request, staff 19-1, as a data request that you reviewed. Is that correct?
I don't recall.
Okay, but that's in evidence and we can look at it.
As I said here, I did not, as I said previously, I didn't look at all the forecasts provided by the company, in particular this data request, till my rebuttal testimony filing.
Okay, fair enough. You would agree with me that capacity expansion projects like White Flint must be justified based on load forecasts. Is that correct?
Yes, I believe that's a component of the justification for a capacity expansion project.
And you would agree with me that a 10-year load forecast represents the appropriate planning horizon. Is that correct?
I think a 10-year forecast is useful in most instances. Depending on the situation, there could be instances where a different number of years would be necessary.
I need to get another exhibit marked, Your Honor. It's going to be Pepco 70. I think I'm going to get inside that. I still got 30. I don't think I've got 30 to go, but we'll see.
Yeah, I've started betting pool.
Have to make the case, or try. Sir, I hand you what I asked be marked as Pepco Exhibit 70. And that was sponsored by you, sir? Is that correct?
That's correct.
And that indicates a 10-year load forecast represents the appropriate planning horizon because it balances the necessity of long-term infrastructure lead times with the need for planning to be based on reliable data. In my opinion, a time frame that exceeds beyond 10 years introduces an unacceptable level of speculation that undermines the reliability and accuracy of forecasts used to plan utility investments. Is that correct, sir?
That's correct.
All right. I move the admission of Pepco Exhibit 70.
Without objection, so admitted.
And you would agree with me, would you not, that forecasts of load growth can be different from actual load growth? Is that correct?
That's correct.
And you would agree with me, sir, that the information that part of the information that forms the basis of your recommendation is the direct testimony of witnesses Alvarez and Stevens in case number 9655. Is that correct?
Part of the information that informs my recommendation, I would say, yeah, I would say it's a small part of the evidence in my my testimonies.
And you would agree with me that that testimony was filed on March 4th, 2021?
That's correct.
And you would agree with me that Pepco has performed further 10-year load studies after March 4th, 2021, is that correct?
That's correct.
And you would agree with me that all of Pepco's load studies and the Quanta study performed demonstrated a persistent overload at the Park Lawn substation, is that correct?
I agree that that's what the Quanta study shows. Again, I believe that those forecasts are inaccurate. And I believe that the study was not sufficient, did not sufficiently review economic development projects within the Whitefoot study area. So it led to a capacity forecast that was extremely overinflated and was not representative of the best data available to the company at that time.
But nowhere in your testimony do you attack the Pepco load studies. Isn't that correct, sir? I don't see it anywhere. If you can point me to where you do that.
Yeah, I don't recall. I mean, I think I suggest that there was evidence at the time back in 2021 that load studies, there was concern from the commission explicitly about, the company's forecasting at that time. And then, again, the load study that was done prior to project completion or for the most of the project execution period was what I principally reviewed.
And you would agree with me that the load studies that occurred after March 4th, 2021 by the company, those weren't reviewed by Mr. Stevens or Mr. Alvarez, is that correct?
Yes, that's my understanding.
Okay. Need to get another exhibit marked, Pepco exhibit
71.
Sir, I've handed you what's been marked as Pepco Exhibit 71. It is OPC's response to Pepco DR 4-20. Are you the sponsor of that DR, sir?
Yes, I am.
And are you familiar with that DR, sir?
Yes, I am.
And I would move the admission of Pepco Exhibit 71.
Without objection, so admitted.
And you would agree with me, sir, as you state in your response to Pepco Exhibit 71, that the commission did not make any determination as to the accuracy of Pepco's load studies in Order 89868. Is that correct?
As I recall, they expressed concerns. I don't think they made any exact determination as to the accuracy of those studies.
Yeah, you say, while the commission did not make any determination as to the accuracy of Pepco's localized load forecasting in relation to the White Flint substation in Order 89868, correct?
That's correct. That's my response here.
You agree that you've not made any claims that the methodology of Pepco's 10-year load forecast is not consistent with the traditionally generally accepted load forecasting methodology?
Are we talking about forecasts made prior to the Quanta study or after the Quanta study?
I'm talking about just globally Pepco's load forecasting. It's done with good utility, general utility specificity.
So are we considering the Quanta load study to be within a Pepco load study or not? I guess.
No.
Okay. Outside of the forecast done outside of the Quanta study, I haven't made any specific recommendations or drawn any conclusions regarding the veracity of those individual studies.
Now, how many load studies have you performed, sir?
Countless. I couldn't tell you an exact number.
Countless load studies, and who
yes.
were you employed by when you conducted those load studies, sir?
Well, at my current employer, I conducted those load studies. We prepare lots of day-ahead load forecasts for clients that participate as market participants in both PGM and the MISO service territory. So I look at, a range of from anywhere between 5 to 15 independent variables to make hourly predictions about what their load would be. In other instances within regulatory proceedings, I've represented other clients where we've intervened in resource planning proceedings, and I've made adjustments to company load forecast. I reviewed countless capacity planning load forecasts, similar to the manner I've done in this proceeding as well. So I do rate forecast analysis for the Department of Defense, the Army, the Navy, rate forecasting for large clients throughout the United States that require us to adequately account for retail sales and load forecasts in many jurisdictions across the United States, and including large customers, municipalities, and investor-owned utilities.
And what investor-owned utilities have you conducted a load study for, sir?
I don't recall them all. I know I've done, like I said, I didn't do it on behalf of an investor-owned utility.
Oh.
I did it, in reference. I've made adjustments, like again, to investor-owned utility load studies, as I have in regulated proceedings.
And
primarily.
you've never worked for a distribution utility, is that correct?
That's correct.
You've only worked for Dynegy, not only. I don't mean to disparage that.
Yes, you're correct. They were a wholesale supplier, a merchant generator, if you will, at the time, and operating in a deregulated environment.
Okay. Now, you would agree with me, sir, that you reviewed the Quanta load study that was attached to Mr. Allo's direct testimony that was filed on October 14th, 2025, prior to filing your direct testimony. Is that correct?
Yes, I did review it, yes.
And you failed to discuss the Quanta study in your direct testimony. Is that correct?
That's correct.
So for the first time you present any criticism of the Quanta load study is in your sir rebuttal testimony. Is that correct?
Yes, I believe that's correct.
And so the issues that you identified in your sir rebuttal testimony could have and should have been identified in your direct testimony. Is that correct?
No, I would not say that's the case. The purpose of my sir rebuttal testimony is to respond to the rebuttal testimony evidence provided by the company. With that, in response to my own direct testimony, your company witness, Mr. Allo, addressed the quanta study numerous times. So that required me to respond to those arguments by providing additional analysis from my perspective of the quanta study.
And you would admit, sir, that the decision to build a substation must be based on projections, isn't that correct?
I believe that's a component of the decision-making process, yes.
I need to get an exhibit marked, Exhibit 71. 72.
Thank you.
You're welcome. And this is your response to DR 4-11, is that correct?
That's correct.
And it indicates you reviewed the quanta study, is that correct?
That's correct.
Mr. McHugh? We're short
Oh,
Oh, wait.
I'd move admission of 72, Your Honor.
Without objection, so
Okay, I need to get another exhibit marked, Your Honor. Exhibit 73. Mr. Fitzhenry, I hand you what's been marked for purposes of identification as Pepco Exhibit 73. And that's your response to a package of DRs 10.5, 10.7, 423, and 425. Are you the sponsor of all of those?
Yes, I am.
And 10.5 indicates that you did not address whether Pepco considered non-wire alternatives because such considerations have little specific relevance to the conclusions and recommendations.
Included in my direct testimony.
Okay. Same with 4.7. You did not address Pepco's consideration of expanding the Park Lawn substation, is that correct?
I did not in my direct testimony, that's correct.
And you agree that the White Flint substation is providing service to customers?
Yes.
Okay. And you agree that the White Flint, North Bethesda area is still growing and there's more development to be planned there. Is that correct?
I would agree that based on the company's most recent forecast, which I have not disputed, the load growth projected goes from approximately 57.9 MVA to 63.5 MVA over a 10-year period, representing, an approximately, 1% increase per year.
And so there's still development going on at the White Flint area, is that correct?
I can't say with any certainty there's development. A 1% load growth could be from any number of reasons. It's a fairly small amount of load growth. It could just be customer usage patterns. I have no idea exactly whether this represents, additional development.
Is there any, you said not in your direct testimony, you didn't have any non-wires discussion in your sir rebuttal testimony either, did you, sir?
No, I did not. I did listen to the live testimony of probably mispronounced Mr. Baklavar's, testimony, and I understand that, he had a pretty substantial testimony with respect to, non-wire alternatives. And I would say
You
that
mean Bala Kumar?
Bala Kumar.
Yeah.
Yeah. Sorry.
You're making me hungry.
Yeah. So again, well, that was not really a feature of my direct or rebuttal testimony. I have, listened to that testimony, and I largely concur that, more formal analysis should have been completed, prior to project execution, which included, an examination of at least cost alternatives where the company developed, detailed cost estimate of alternative projects.
Okay, and that's nowhere in your pre-filed written testimony, correct?
I did not address, alternatives that I recall in my direct or rebuttal testimony.
Thank you very much for your time.
Do you want 73 to be admitted into?
I sure do.
Okay, without objection, so admitted. Are you done?
I hope so.
Okay.
I would like to go home today.
I'm so pleased. Yes, I'm going to make it very, very brief, though. Mr. Fitzhenry, both staff counsel and counsel for Pepco asked you some questions about hindsight analysis and what that means. Can you explain the difference between improper hindsight and a prudence review that it considers whether the company's forecasts were reasonable?
Right. So, what my recommendation is based on was that at the time the company decided to primarily go forward with the, quanta study, with the White Flint project, it relied on, a faulty load study, and that was the quanta study. And as I suggest in my rebuttal testimony, the company did not, or the quanta study did not properly vet new economic development projects. The vetting criteria in here, I can read them to you. Permits must have been granted or seem likely. I mean, in each one of these instances where they said they vetted these projects, there's a service request received and processed by Pepco or ongoing decisions leading to one taking place. Essentially, these are not requirements. The company left themselves out in each instance when reviewing these individual economic projects so that they did not require them to meet projects in order to be included in the quanta load study. In addition, in review of the Appendix A, they look at certain individual economic developed projects and assign a certainty to them, but there's many projects that don't have any sort of evaluation of certainty included in that analysis. And finally, if you look at the actual results of the quanta study, there's evidence here that the quanta study demonstrates that the winter capacity by 2033 will be in the range of, and I can tell you the exact numbers. $194 and 262 MVA by 2033 in the winter, right? What that means is that this own study demonstrates that the capacity of the currently designed Park Lawn White Flint substation would be exceeded by this forecast. And what that tells me is that, well, the company did not even effectively evaluate the results of its own forecast if the forecast demonstrates that what they constructed was not adequate to serve the capacity in the exact forecast. So I think there's numerous flaws with this forecast. The company repeatedly said that this forecast was relied on to support the decision to go ahead with the White Flint substation. I think prudent management here would have reviewed this forecast, understood the flaws, and either commissioned a new forecast or decided not to go ahead with the project.
Thank you, Mr. Fitzhenry. I don't have any more redirect here.
All right. Thank you very much.
Thank you.
Oh, wait, question. McLean.
Yeah.
No questions, sir.
Okay.
Thank you.
See, I'm not a liar yet. Linton?
No questions.
Suchman?
I do have questions.
Okay.
So let's go first to your direct testimony, page 24. And with counsel, and then also with your counsel and with Pepco counsel, you spoke about the accuracy of the underlying load growth forecast.
That's correct.
And the fact that you don't look back. You sort of take it as it was at the time. But how do you assess accuracy?
Mm-hmm.
You can only assess accuracy by looking at the results.
Yeah.
So you do have to look at the current state now and know how well you forecasted.
Yeah, that's absolutely true, and that's why I use the current forecast to make a determination about the level of disallowance, right? Because this gives us the best insight into the use and usefulness of the White Flint substation. Relying on previous forecasts that are now outdated, right, wouldn't provide us the best information about whether or not the project will be used and useful in the future. The most recent forecast, by nature of its more recent inception, is our best insight into that information. With that said, when we compare this forecast, right, and we look at the values here, right, relative to what was provided in the Quanta study, which was commissioned and paid for by the company, we're showing that in 2033, the total MVA of the White Flint study area is 62.4 megawatts, right? And I can go to that Quanta study and look at that year, 2033, and tell you that that's maybe 30% of the value, or 33% of the values represented in that study. So this isn't just well, they were off by 10%, right? They were off by 20% in their forecasting. There was some forecasting error. They didn't do a great job, right? We're talking, what in the Quanta study shows values 3 times higher than the company's most recent forecast. It's basically, you'd have to get, a 150 megawatt data center to come in and make up the difference here, right? So it's not even in the same ballpark. So that just gives you a sense of the magnitude of the difference. And certainly when you look at the change from forecast to forecast over just a short few years, when you see a significant change like that, it should raise alarm bells. And when I went back to look at the Quanta study, I clearly identified certain issues with the study that should have been identified by the company at the time they made the decision to go ahead with the White Flint substation.
Okay, so now table CTF3.
Yes.
You have both Park Lawn and White Flint, but I'm assuming you did analysis that looked just at Park Lawn, because on the next page you talk about the 2025 forecast of 57.9 MVA. And that's still below even just the Park Lawn substation.
That's correct.
Right. Even if you take out White Flint.
Yeah, and that was the purpose of my response to the company in the Missouri rebuttal testimony, that even under an incremental analysis, which means let's take White Flint out of the equation, right? Would Park Lawn be able to serve the full capacity over the company's most recent 10-year forecast? And the answer to that question is based on the company's own most recent forecast. The answer to that is yes.
Okay. And were you in the room when I asked witness Allo, the company's witness, to give us, it was a bench data request, to just take Park Lawn out of their 10-year forecast? So beginning in 2016 and taking it to the present, were you here when I asked that question?
I watched it on YouTube.
Okay.
I have not evaluated that bench request, or I'm not sure if it was even provided yet, to be honest.
Okay, because from at least from my perspective, it'll be interesting to be able to then look to the 2 years of historical and 8 years of forecast and follow it each year. And I'm assuming that that's going to give us a sense of how well the company was doing in terms of forecasting for each one of those successive years.
Yeah, I would suggest that, as part of the decision-making process, that if you were to review the Quanta load study and the forecast in there and then compare them to this load study, I mean, they were done approximately, I guess, 2 years apart, because the company's most recent load forecast study versus the Quanta one, and there are night and day differences between the values being represented there.
Okay, so let's turn to your surrebuttal testimony and page 13. And what I'm going to do is I'm going to reference, this is in Mr. Allo's rebuttal testimony, and this was a response to OPC data request 5-3, and so I'm assuming, and I'm assuming you've seen this. So starting on line 12, you lay out sort of where things stand now, and this is kind of following up on what we talked about earlier.
Right.
You want to test to see how well you forecasted. And so you're giving two examples. So Evolution Labs, Stonebridge, and Life Science Center. And I'm then going back to the response to the data request, where the company laid out the drivers for White Flint, and I think they noted 12 projects. So these are two of those. And what you've laid out here is that one was 5.6 megawatts, one was 20 megawatts, and they're not moving.
That's right. That's my understanding as well.
Okay, so I'm assuming you think that this is relevant to the question of whether the company was accurate in their forecasting of need.
That's correct. I think these projects should have been better vetted. In particular, when you look at large development projects like the Life Science Center of 20 megawatts, right? Prudent utility management. When you have these large-scale projects, what the company will actually do is ask the developer for a load ramp schedule, right? They provide them with their own forecast of when they expect to come online, start ramping up. That way, the utility can use that information to inform their decisions. Every single data center project we have right now, any of these large-scale projects, use this type of methodology where they provide a ramp schedule, a load ramp schedule to the utility, so the utility can take that information and have it inform their decision-making process, right? I've seen no evidence that Pepco asked any of these developers, any of these project developers for load ramp schedules to inform their own forecast.
So did you ask the company this in a data request?
I don't recall whether I asked them specifically for that information, but I don't see it. Yeah, I think in preparation for this, my cross-examination, that is something that I considered, and I don't recall seeing that in the evidentiary record.
Oh, okay. Oh, sorry. Making a mess. I guess I was so excited about it. So what are these called?
Yeah, so a load ramp schedule.
Load ramp schedule?
Yeah, and it's common utility practice that when you have large development, the utility requests the developer to provide this information. Like I said, we're seeing this when this could be a large industrial customer just expanding their operations. It doesn't necessarily have to even be a new business project or a new development like this.
Okay, and this would be something that is would have been expected if the utility were to actually be doing an accurate load forecast, is that it would have expected a load ramp schedule for any one of the developers.
That's correct. I think in instances where we're talking about capacity expansion projects, right? We're making investment to meet additional capacity. That would be to expected,
Okay.
Especially in a project of this scale when we're talking about spending over $100 million of capital.
Okay, so I know witness Allo did communicate, or his staff communicated with these companies. That's what he told me. But so here we go, another bench request. So I would like to know if a load ramp schedule was prepared for all of the companies identified in OPC data request 5-3, and a load ramp schedule or something akin to a load ramp schedule. If it's called something else, but it represents the same. Would it have been called anything other than load ramp schedule?
I can imagine. I don't think it has just a common, utility terminology in all jurisdictions. But in many of the jurisdictions I've worked in, I've heard it referred to as that term. So.
Okay, and include in that the date that it was presented to the company. So, okay, thank you. That's all I have.
Hoover?
So along some of the lines that Commissioner Suchman's been talking about, the company presented some evidence related to the economic development projects that they expected to be happening in the White Flint area, and that was part of the justification for the substation. And you mentioned the medical facility, but where do we, cross the line between, requiring the company to perform certain things, studies and analysis on potential economic development projects, and get into the thing of where we're, either micromanaging or backseat driving the company?
Yeah, I mean, it's I would say that we shouldn't be focusing our time on a step, a 1 MVA step down transformer, right? There's a certain scale to these investments when additional examination of the investment should be done, right? Because you're right, there's an administrative burden to looking at producing these studies, these really complex studies, and every time there's a capacity expansion project, we wouldn't expect the company to make that type of investment. That wouldn't necessarily be cost effective for customers, right? But certainly when we look at these larger projects and we're talking about spending over $100 million, I think due diligence would suggest that performing doing a little bit extra tasks to ensure that that those forecasts are reliable, or having certain administrative procedures and a process for reviewing these capacity expansion projects would also be are also necessary. So I wish I could give you like a really clear delineation of when we should and shouldn't be performing these extensive analyses, but I think it is a little bit subjective in nature, and ultimately I think that's what you guys get to do is make that determination. So
I
that's
guess,
part of.
and the flip side of that is, is there a danger that we wind up, paralyzing the system with over-analysis? Because, obviously they can't build a substation in a week.
That's right. That's right.
Fairly long time frame, and do we run the risk of them having problems if we decide, oh, you need to build this thing, that they now find out the, supply chain problems and other stuff that we've run into with other utility development projects, stuff that's literally out of their control because they're world events and things like that.
So these questions that you're asking are more prevalent now than ever, and we're seeing these questions asked across the country, of course, because of data center demand growth, right? So some of the instruments that commissions are using to make sure that we're not overspending, because we do see examples of overspending. Like, for example, in a recent reconciliation proceeding in ComEd's multi-year rate plan that I took part in, ComEd made a $72 million investment on behalf of a customer looking to expand its data center operations. They provided them a 150 megawatt load forecast, and only a portion of that load materialized. Now they're looking at overinvesting. So the commission is making decisions about how they can improve the process and ensure that we don't have these types of overexpending on these types of projects. And those are including, could include larger customer deposits, a reexamination of SIAC, signed customer agreements, customers being able to prove their creditworthiness, that, if they make this investment on their behalf and not all the load materializes, that the developer has the creditworthiness to pay back the money that was spent by that on behalf of that customer. So yeah, I mean, we're living in unprecedented times, and I think we have to examine. We're no longer talking about in most instances smaller scale substations, substation rebuilds. We're talking in some jurisdictions, capacity expansion is driving 40% of all utility investment, right? And it's just a new paradigm, and it requires a new assessment of what is the most viable strategy to ensure that we balance utility expenditures, cost recovery from customers, and risk exposure to current and existing customers who would be burdened with those costs if they don't have proper protections.
Okay, thank you.
So, no, he went first.
He went, I was gonna
that's
say
right.
something, but you got it, so.
Okay. No, okay, well, all right. So basically, to boil your argument down to just one point, it would be that rather than making the White Flint substation have a capacity of 95, it really ought to only be 45, 50. Is that basically the sum of your argument?
I would say that's very, very high level, yes, summary of my argument, that not all the capacity of the White Flint substation is not needed. Had the company done better forecasting, it could have avoided a lot of that cost, and that's the basis of my disallowance.
So you would not agree with any developer who says that slack has to, I mean, this is a lot of slack, but I mean, you would never agree with an argument that says slack has to be embedded in the, in planning, that you have to have large buffers.
No, I think my recommendation provides a lot of slack. As I said in my Sir rebuttal testimony, if you actually look at most companies' most recent load growth, they don't need the White Flint substation to serve that. Not over the next 10 years. I mean, the Park Lawn substation MVA capacity was 85 megawatts, and it's only going to grow to 60-something megawatts. So they have that buffer, right? So, if the commission deemed that, a full disallowance of the White Flint substation is the most appropriate, I think there is, evidence in the record to back up that assertion. What I did here was, provided that little more additional slack, though. I looked at the, capacity served by both the White Flint and the Park Lawn substation in summation, and then compare that to develop that utilization ratio. So, I think we provided. I think my recommendation provides a lot of slack to the utility, to absorb some of those additional costs by giving them partial cost recovery.
And finally, our staff attorney asked you, hypothetically, if it turned out that in 4 or 5 years, rather than being at an estimated 35.8%, they were, say, at a higher percentage, like 50%, would you be supportive of, at that point, allowing? You seem very hesitant. I didn't understand your hesitancy.
Yeah, it just seems it's hard to make sort of that type of assumption without additional context, right? I mean, I think certainly I think a utilization ratio. I'm using it as a proposed disallowance here. So if the commission decided to tie cost recovery to a utilization ratio going forward, I mean, I think that's a reasonable approach. So I'm not fully against it. It's just it's hard for me to say when in this exact proceeding 3 years from now, right, when we have additional information, to make a recommendation for that period, when I haven't seen that evidence, right? But yeah, I think, for the time being, I think the commission has wide discretion to allow or disallow cost recovery for a certain project. I certainly think the commission should be allowed to adjust that cost recovery over time. But prudency, as the company has repeatedly said, relies on a no hindsight review, and I think given the information available to the company at the time, that either this project shouldn't have been built or an alternative should have been considered.
Okay, Chuck, did you?
I'm sure you're good.
Okay. I think we're covered then. Thank you very much.
Yep, thank you for the questions.
So is your last witness available to us?
He is available, but he's going to be the one that's appearing virtually, so I think we need to set that up.
All right, great. Yeah, we do need a 5-minute break. Let's aim for 4 o'clock.
Okay.
So is Morris still around?
Morris retired as of January 1st this year, but he's still in the office.
Well,
Yeah.
Will you tell him I say hello?
Yeah, I will.
And Greg Myers, he's still around?
Greg Myers, yeah. So, well, he's actually, he went to part-time. He's on council now.
let's get going. We ready?
Thank you, Your Honor. OPC calls to the stand Mr. Dustin M.J. Madsen. Are you with us, Mr. Madsen?
I am. Can you hear me all right?
Yes, we
Yes.
Speak a little louder.
Yeah. It just happens.
Your Honor, does Mr. Madsen need to be sworn in?
Yes. Well, I don't know if he can see you, but he can certainly hear you when you're. Does he have to see you? I don't. Okay.
Mr. Madsen, can you hear me?
I can.
This is the court reporter. I need to swear you in. Can you raise your right hand? Do you solemnly swear or affirm under the penalty of perjury the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And Your Honor, pursuant to the Commission's November 5th, 2021 notice, I attest that Mr. Madsen is alone in a separate room and not in communication with any other individual.
Very well.
Mr. Madsen, could you please state your name for the record?
My name is Dustin Michael Jorgen Madsen.
And could you please state the name of your business and its address?
My business is Meridia Consulting Corporation, and its address is 401 Ryland Street, Suite 200A, Reno, Nevada 89502.
What position do you hold at Emridia?
I am the president.
Did you have cause to be filed a document titled The Direct Testimony of Dustin M.J. Madsen, filed on January 30th, 2026, under mail log number 326735, consisting of 53 pages of narrative testimony, 1 appendix, and 3 exhibits?
Yes, I did.
Did you also file a document titled The Revised Direct Testimony of Dustin M.J. Madsen, dated on May 1st, 2026, under mail log number 329632, consisting of 30 pages of narrative testimony, 1 appendix, and 2 exhibits?
Yes, I did.
What is the difference between the initial version of your direct testimony and the revised version filed today on May 1st?
My direct testimony was revised to remove the portions of my testimony that responded to the company's direct testimony in respect of its FFTY proposal. Specifically, I removed Section 2 and Section 5, as well as certain other discrete components of my testimony that addressed the FFTY. I also removed Exhibit DMM2. In addition to adjustments related to the FFTY, I also withdrew my operating revenue adjustment, and that was an adjustment to remove Section 4 sub B from my originally filed direct testimony in respect of the adjustment to annualize the billed distribution revenues.
Thank you. Your Honor, I'd like to mark the revised direct testimony of Mr. Madsen filed today on May 1st as OPC Exhibit 40.
So marked.
Mr. Madsen, did you also file a document titled The Surrebuttal Testimony of Dustin M.J. Madsen on April 16, 2026, under mail log number 329095, consisting of 47 pages of narrative testimony and 4 exhibits?
Yes, I did.
And did you also file a revised surrebuttal testimony of Dustin M.J. Madsen dated May 1st, 2026, under mail log number 329632, consisting of 32 pages of narrative testimony and 2 exhibits?
I did.
Can you explain the difference between the initial version of your surrebuttal and the revised surrebuttal filed today on May 1st?
Yes, I can. The changes to my surrebuttal are consistent with the changes to my direct testimony. Specifically, I removed my original surrebuttal Section 2, subsection A, regarding my response to the FFTY rebuttal of Mr. Lemming. I also removed other portions of my surrebuttal in respect of FFTY matters that were spread throughout the surrebuttal, individual sentences here and there, and removed Exhibit DMM SR2. I also adjusted my surrebuttal to remove matters related to the operating revenue adjustment, and those adjustments were related to the removal of Exhibit DMM SR3, Section 2, Subsection B, and Section 6, which was my reply to the rebuttal testimony of John T. Corsi. There was also several other minor adjustments to certain sentences as well.
Thank you, Mr. Madsen. Your Honor, I'd like to mark the revised rebuttal testimony of Dustin M.J. Madsen filed on May 1, or 2026 as OPC Exhibit 41.
Well, actually,
Well, I was going to say so marked, but I was going to recommend that we undertake the same treatment we did for the other revised testimonies. Use the original testimonies because we just direct our questions to the portions that don't deal with forecasted test years.
Yeah, that understood, Your Honor.
Okay.
So would you prefer OPC enter the initial versions that Mr. Madsen filed, or
I don't care in what the notations are. I just want to be clear as to what we're actually using in this hearing.
and actually for what we did with Fitzhenry was the revised testimony had one exhibit number and the original one had a separate number. So
Right.
what I think we would do here is Madsen's revised direct would be 40, his original direct would be 41, and then do the same thing with the Surabo.
Understood, Your Honor. And Mr. Madsen, I also instructed him to be prepared to answer questions based on the pagination of his original testimony.
No, right. But I'm talking about the exhibit number. So, because you were going to put 41 on his surrebuttal. What I'm saying is put 41 on his original direct.
Understood. I'll do that, Your Honor.
Okay.
Your Honor, I'll mark Mr. Madsen's initial direct testimony filed on January 30th as OPC Exhibit 41.
Right.
Okay, so marked.
And Your Honor, I'd like to mark the original, the initial surrebuttal testimony Mr. Madsen filed on April 16th as OPC Exhibit 42.
So marked.
Actually, flip it.
Flip it? Okay, Your Honor.
And then the next
That'll
one would be
make it consistent with
all right.
Fitzhenry.
Okay.
So the revised surrebuttal
So I'll mark
would be...
I'll mark the revised surrebuttal as OPC Exhibit 42.
Yeah.
Your Honor.
Okay.
And the initial version of Mr. Madsen's surrebuttal is OPC Exhibit 43.
Now we got it.
I'm sorry, was it 41 or 40?
So the revised surrebuttal would be 42,
Okay.
the original surrebuttal 43.
43, thank you.
And you want to move them into evidence?
In 1 minute, Your Honor.
Okay.
Got to do a couple questions.
Mr. Madsen, for each of these testimonies, your direct and your surrebuttal, you identified a change regarding the withdrawal of your operating revenue adjustment. Could you please explain why you're withdrawing that adjustment?
Yes, having further considered the record of this proceeding, I determined that my reliance on the PJM forecast to project the load growth in the rate effective period was improper. In particular, I have taken into further consideration the company's own testimony and submissions made by OPC in respect of the PJM forecasts. And based on this further assessment, I determined it was appropriate to remove the adjustment I was recommending from my TTY-CF revenue requirement. The overall impact of the change that I recommend is it increased the incremental revenue requirement I recommend from a reduction of 1.697 million to an increase of 14.825 million.
Thank you, Mr. Madsen. So for the testimonies marked, just previously marked, were these prepared by you or under your supervision?
Yes, they were.
And are there any other corrections to your testimonies that you'd like to make at this time?
I have none.
And if you were asked the same questions today, would your answers be the same?
Yes, they would be.
Your Honor, I move for the admission of OPC Exhibit 40, 41, 42, and 43.
Without objection, so admitted.
And the witness is available for cross-examination.
Okay. AOPA. MEA?
No cross, Your Honor.
Staff?
No cross.
Pepco?
Very briefly, Your Honor.
Good afternoon, Mr. Madsen.
Good afternoon. I can't see you, sir, but
I was about to say, I'm not sure if you can see me, but I'm Matt Seegers. I'm an attorney that's representing the company in this proceeding, so it's nice to meet you virtually. You answered my first question. I was going to ask what the impact of your removal of the operating revenue adjustment was on your revenue requirement recommendation, so thank you very much for that. I'm going to be working off, as the chair indicated, your April 16th version of your SIR rebuttal. Are you able to turn to page 24 of your SIR rebuttal, sir?
I can.
And I'm looking at the discussion beginning at line 14, and let me know when you're there.
I am there.
Okay. Here you maintain your complete disallowance of all the rate case costs for the company. Is that correct?
That is correct, sir.
Okay, and just to make sure, this is one of the this is a portion of your testimony that that's staying in. Is that correct? It's not one that has been removed.
That is correct.
Okay. And in support of your argument, you state, beginning at line 21, and going on to the next page, that, quote, the commission did not direct the company to file the FFTY forecast and related testimony in this case. Is that correct?
That's correct.
Okay. But as you note, starting at line 19 on page 24 of your SIR rebuttal testimony, the commission explicitly said that the company's next rate case can be any of its choosing, so long as its application is accompanied by the requisite information to calculate a historic test year. Is that correct?
That is correct.
Okay, and the commission, in that order, if you're familiar with it, they did not prohibit the company from filing a forward-looking test year case. Isn't that correct?
Based on my recollection, I did review that order, and I don't believe there was a prohibition. That's correct.
Okay. And the commission also did not say that if the company elected to file a forecasted rate case, that the company would not be eligible for rate case cost recovery. Isn't that correct?
To my knowledge, that is also correct, yes.
Okay. Now, you responded to a data request that was actually attached to, let me try it this way. Have you reviewed company witness Nelson's rebuttal testimony?
I have.
Okay. You responded to a data request that was attached as a portion of an exhibit to that testimony. I don't know if you have his rebuttal testimony in front of you, but I'm looking at your response to Pepco data request 513, which was attached to Mr. Nelson's rebuttal testimony as schedule CN-R-2, page 7 of 11. I can share a copy with your counsel.
Yeah, that would be preferable. Thank you.
I should be able to track that down.
Sure, take your time. Yes, it's the Nelson rebuttal, and it's schedule CN-R-2, page 7 of 11.
I am there, sir.
Okay. Now, this data request asks if you were aware of any prior decision by this commission in which the commission did not give a rate case cost recovery to a utility based on the form of the rate application that was filed by the utility. Is that correct?
That is correct.
Okay, and your response here was that you were not aware of any such precedent. Is that correct?
That is correct.
Okay. Thank you very much for your time, Mr. Madsen. I have nothing further.
Redirect?
No redirect, Your Honor.
Okay, I believe the first question goes to Commissioner Linton.
Thank you, Mr. Chairman. No question.
Suchman?
No questions.
Hoover?
Actually, no questions.
McLean?
No questions, sir.
I have no questions either. Thank you very much.
Thank you.
All right, that completes People's Counsel. We'll proceed to staff. Just very quickly, Mr. Seegers, what volume of questioning do you anticipate for the company?
I do.
For the staff.
I do not have very
Well,
many.
from the company to the staff, is what I
I
meant.
do not have very many initial questions, Your Honor. As always, depending on the answers, I may have more, but initially I don't have many. I do believe that staff wanted the opportunity to recall company witness Nelson regarding a data request.
I swear, it's one question, Mr. Chairman, and it's an accounting question.
Oh, so therefore I should be in favor, huh?
I even said to council, maybe Friday afternoon, a long
Call
week.
them up. Do you
But
want
the chair is an accountant.
What?
But the chair is an accountant. I mean, it's
Yeah.
Friday afternoon after a long week, but bad idea, but the chair is an accountant.
Is he here? I can't.
He is.
Oh,
He is
there he
here.
is. Come on up. You're the next contestant. Do you need a 30-second break? Okay, we're going to take a 30-second break for administrative electronic purposes.
The company's response to updated 50.
And when you start to speak, you'll still be under oath.
Updated 50.
Sounds good.
Thanks.
Okay.
May I approach?
Yes.
May I get the witness?
Oh, absolutely, yes.
That ties. That ties. I think Oliver's is more of a maroon burgundy.
Mr. Nelson, thank you for waiting all day, and thank you for coming back. Do you have Pepco's updated response to? Oh, I'm sorry.
Yeah.
Are we ready?
Yeah. So give him a second.
I'm sorry. So short.
Because I took the 30 seconds literally, didn't I? Oh, yeah. I mean, ideally, we wouldn't want to see double there's prostitute. Be all dressed up, yeah.
Yeah, way better. So for you to go to the
Yeah. It's walking distance for us. It's great.
It's going to, it's already been marked, and they already stipulated to it, so if you don't object to it, it's going to go right in. And I just have one question. Quick, sorry. Thank you.
Okay, let's get going. I'm sorry, what? Oh, yeah.
We're on camera all the time.
Well, we're handsome buggers, aren't we?
Well, actually, we're on camera.
Right. You're
Mr. Chairman, we're finally getting back to staff number 4. Thank you so much. We already marked it for identification. You already did. Thank you so much. This is updated. It's Pepco's updated response to staff data request 57. And I believe that the company will stipulate to its authenticity and will agree to, if the chairman approves, entering into the evidentiary record.
Without objection, so entered. As, I guess, as what? Same number?
As staff data request 4. I mean, as staff exhibit 4. I'm sorry.
Okay.
Staff exhibit 4.
All right. Without objection, so entered.
Mr. Nelson, thank you for coming back and thank you for staying all day. Mr. Nelson, I want to ask this as tactfully as possible, but would you be surprised if we found maybe an error in staff, perhaps an error in the response, the updated response to staff 57?
I would be surprised.
Okay, good. So then we'll ask you, where did you get the information? If I'm looking at the chart, and the right section, may we ask you?
That on
Sure.
page 2 or the
Yes.
chart on the back?
It's the third page.
The yeah, okay. Looking at the TTYCF unadjusted numbers, is that right? That's what you're saying?
Yeah, and that'd be great if there isn't an error. Where'd you get the numbers, sir? Did they come from your, I don't want to read a long schedule. We printed it out. You could look at it, but it's the, did it come from one of the supporting schedules with your surrebuttal?
I don't know. I mean, this is pulled from our financial records, so it would be inherent. This being that this is from the TTYCF unadjusted numbers, so these are inherent in the EPIS as of September 30th, 2025, within our jurisdictional cost of service.
Okay. May I approach one more time, Mr. Chairman?
Yes.
And can we show this to the witness? It's not in evidence yet. It's just, it's what we think the numbers came from. Can we just show him the name of the schedule? Is that all right?
Where did this come from?
Well, we pulled these out of. I'll tell you what. In the interest of time, we'll go back.
Show it to him to see if he knows what it is.
Okay, Mr. Nelson, would you be surprised if we looked, those numbers resembled numbers from the TTYCF supporting schedule, section 1N, attachment A 2-4. I don't expect you to memorize those. Okay, your counsel's going to give it to you. So what I've circled there is, these are the numbers that these are the numbers that these are the ones that are E85. These are the numbers they gave us. Okay. That's the ones we got. Okay. I'm sorry, Mr. Nelson. The ones that your numbers, the numbers that Mr. Seegers just handed to you, that's circled, those are your numbers from your schedule, but they're not the numbers that you submitted with updated response to 57. And so there's a little bit of a variance there. And that's what we're trying to ask you. And I don't expect you to be able to memorize it. I know, what are you going to say?
Yeah, I mean, I can't reconcile just what's
I understand.
the basis here.
I guess that's what we want to just ask you. Do you see an error? Do you see what we're saying? You have the chart now.
Yeah, I mean, I'm looking at this, and obviously, like I said, I don't have the base.
Sure.
I would need to look at that full schedule and attachment to kind of understand what we were showing there versus what we're showing here. I feel confident in the data that we've pulled together for the terminal plant closings included here, and the different projects that you've identified and how we've sort of laid out their flow through the jurisdictional cost of service.
But they don't match the number. Okay.
Understood.
Okay. Thank you so much.
Would it help? I'm sorry. If you could specify where in his testimony, would it help if I provided him a copy of the testimony so he can look at the actual schedule?
Well, the actual schedule is Mr. Chairman, I'm just wondering if Ms. Harmon,
Yeah.
I'm wondering if the witness can take back the information and just be able to explain if there's a problem.
Sure.
Right.
Thank you so much.
And how would you want him to submit that information?
Yeah, he can respond through his attorney as a bench, as a data response.
We can update the data
Okay.
response. Sure.
Thank you so much.
All right. Yeah, you'd have to be a real wizard to look at that and be able to decide whether it's correct or not, I think. Yeah. I've met people like that, so I don't know. Okay,
Thank
you
you.
very much. All right, your first witness.
Yes, staff's first witness is Mark Riley.
Microphone? I can't hear you.
I just want to ask a question about this data. Is this the type of data that we're going to get in response to the Commission's data request 1 that we all got an email about yesterday, or is this different?
I don't know. Do you know the answer to that? Did you hear her question?
I have no idea.
You'd have to ask the company.
Yeah, right.
Oh, I mean,
I'd like to ask Mr. Seegers.
I have not yet seen it, Your Honor, so I don't know if I can answer that question right now. And as always, our answers will be as fulsome as we possibly can.
We have no doubt. Thank you. Could Mr. Riley be called to the stand, and could he be sworn in, Mr. Court Reporter?
I do. My name is Mark, M-A-R-K, Riley, R-I-E-L-L-Y.
Good afternoon, Mr. Riley. Do you have in front of you the direct testimony of Mark Riley entered into this proceeding with the date of January 30th, 2026?
Yes.
Mr. Riley, and that's associated with ML 326736?
I assume so.
Mr. Riley, do you have any additions, deletions, or corrections?
No, I do not.
Mr. Riley, was this document prepared by you or under your supervision?
Yes.
Mr. Chairman, may we ask you to mark this as Staff 6?
So marked.
Mr. Riley, if I were to ask you each of these questions now while you're under oath, would the answers be the same?
Yes.
Mr. Riley, is this your sworn testimony in this proceeding?
Yes, it's part. I'm only swearing to this part, right?
Yes, sir. Thank you.
Yes.
Your Honor, we ask that Staff 6 be moved into the evidentiary record.
Without objection, so admitted.
Mr. Riley, do you have in front of you 2 surrebuttal testimonies, which you caused me to file into this docket?
Yes.
And they're under ML 329093?
I assume so, yes.
And Mr. Riley, was one of the surrebuttal testimony labeled FFTY and TTYCF?
In the file name, yes.
Yes. And was the other labeled TTYCF?
Yes, in the file name.
Did you cause me to file these documents dated April?
did.
Oh, thank you. And Mr. Riley, are there any additions, deletions, or corrections?
No.
Mr. Chairman, we'd ask you to identify these as Staff 7 and Staff 8. Staff 7 being TTYCF, Staff 8 being TTYCF and FFTY.
So marked.
Mr. Riley, if I were to ask you these questions now while you're under oath, would your answers be the same?
Yes.
Are these answers your sworn testimony in this matter?
Yes.
Mr. Chairman, may we ask that Staff 7 and 8 be moved into the evidentiary record?
Oh, without objection, so entered.
And at this time, we wish to tender the witness for cross-examination.
Okay, AOPA.
No questions.
MEA.
No questions.
People's Council.
No cross, Your Honor.
Pepco.
Just a few. Good afternoon, Mr. Riley.
Good afternoon.
Good to see you. Could you please turn to page 1 of your surrebuttal testimony, please?
Are you talking the short surrebuttal or the long surrebuttal?
I'm talking about, well, the version I have was filed on April the 16th.
They were both filed on the same day.
I am talking about the one that is, let's see here. This is 8 pages long.
Okay.
Not including the schedules.
Okay.
Is that Exhibit 7 or 8?
I believe it's 7, I think.
Okay. I have the testimony.
Okay. And
you said turn to page 1?
Page 1, please. And I'm looking at the language beginning at line 21. Let me know when you're there.
Yeah.
Okay. Here you update staff's revenue requirement for the TTYCF to 69.456 million. Is that correct?
Correct.
Okay. And after you submitted this surrebuttal testimony, you've submitted some data requests and the company has responded. Does staff have any updates to that number, to that revenue requirement?
The revenue requirement will be updated based on the case rate expenses that were submitted by Pepco.
Okay, and that was actually one of the areas I wanted to ask you about, but we can get to that in a little bit. So is that the only adjustment that you're anticipating at this time?
Correct.
Okay, so does that revenue requirement, still include a complete disallowance of RMA2?
Yes.
Okay, then that's what I would want to ask you about. Now, as a general matter, would you agree that all of the costs included in RMA2 are actual, known, and measurable?
Actual, known, and measurable.
Mm-hmm.
I have some concerns that they're not measured correctly.
Okay, well, are you disputing that they are actual costs?
Oh, they should, RMA2?
Yes,
is
RMA2, sir, yes.
Okay, is actual.
Okay, thank you. Now, could you please turn to page 2 of your rebuttal testimony? And I am looking at the discussion beginning at line 7. Let me know when you're there.
Okay.
Okay. Here you recommend that the commission should disallow RMA2 of the TTYCF. Is that correct?
Correct.
And at line 13, you state that the basis of your disallowance is that the company did not provide the allocation amounts for 8 specific Pepco DC/Maryland projects. Is that correct?
Correct.
Okay.
Subsequently, they have provided it.
Of course, yes. And you got to my next few questions. You did ask a data request. I believe it was a day after you submitted your rebuttal testimony, sir. Is that correct?
It sounds correct.
Okay.
I'm verifying the date.
Okay, and as we end, that is actually, the company's response to that is staff exhibit number 4. Is that correct, that we were just reviewing with company witness Nelson? I can
Yes.
give you.
Correct. The response.
Yes.
The 57-1. Correct.
Yes.
The 57-1 update.
Okay, yes. And based on the discussion with Mr. Nelson, I may have to alter my questions a little bit. But isn't it correct that the company did provide the allocation amounts for each of the RMAs, but on page 2, there's a breakout for each RMA, including RMA2. Is that correct?
Could you repeat the question?
Sure. Isn't it correct that in the company's response,
the 57-1.
Yes, for 57-1.
Just hold on a second. I'll see.
Sure.
Mr. Chairman, can we bring it up to Mr. Riley?
I actually have extra copies too, but if you want to give it to him, that's
Because
fine.
I think I left mine over there.
That's fine.
Okay.
And if you turn to page, it's the 3rd page of that response, but it says the attachment update page 2 of 2.
Okay.
And for RMA2, isn't it correct that the company did provide the jurisdictional allocations for each of the Pepco and each of the projects that are split between Maryland and DC?
Correct.
Okay. And so I understand that staff may have some questions about the numbers and about whether or not they may reconcile. If Mr. Nelson is able to address and answer staff's concerns about the numbers, would staff agree that you now have the jurisdictional allocations for the projects in RMA2?
Yes.
Okay. So if Mr. Nelson provides that, would staff be amenable to recommending that the company get recovery for RMA2?
Yes.
Okay, thank you. And then my only other question, Mr. Riley, is regarding, as you said before, just the rate case update. On page 4 of your rebuttal testimony, and I'm looking at the discussion beginning at line 14.
Page 4, line 14. Got it?
And here you address the rate case expense, what Mr. Nelson, what he talks about regarding RMA 10, the rate case expense. Is that correct?
Right. In his rebuttal.
Yes, in his rebuttal. That is correct. And on page 5 of your rebuttal, beginning at line 10,
Okay.
You state that if the company provides additional information regarding its rate case expenses through the hearing, staff will review the information and consider revising its adjustment for rate case expenses. Is that correct?
Correct.
And were you either present in the room or listening during Mr. Nelson's live rejoinder?
I was listening to it, but
Okay.
tell me if there's something I need to know based on what he said.
Well, either if you know or would you accept subject to check that Mr. Nelson and the company entered into the record Pepco exhibits 30 and 30C, the updated rate case expenses?
Okay.
Um,
I've received those.
Okay, okay. And have you had a chance to review those additional
Yes.
invoices? Okay, and so will staff be updating its revenue requirement to include those additional rate case invoices?
Yes. I sent a response back to Pepco, I think it's DR6. Did you read it about rate case expenses? You wanted to know what was disallowed, and I indicated there was one invoice I didn't receive.
Yes.
Am I going to receive that invoice?
We actually responded and said that we did include a copy of that invoice, and we indicated where you could find it.
Okay, I'll verify it.
Okay. So, great. Thank you very much, Mr. Riley. That's all I have.
Okay, thank you.
Redirect?
Mr. Riley, you were asked about the response to staff data request 57. Was that the first data request that we asked about this, or had there been, was that the first data request about this topic?
It probably was the first data request on the RM2 update, yes.
Okay, and did the company submit the chart? Did the company submit a chart, an Excel spreadsheet?
Well, the first response, I think that goes back to DR54 and DR56. They just provided a narrative description without any numbers. The allocation numbers. They did provide some numbers, but not an allocated.
And did you subsequently request specific?
Yeah, that was DR57-1.
And have you carefully reviewed that updated chart that they sent?
Yes.
And did you find errors?
Yes. Let's clarify and not use the word terms. Error.
Yeah. Did you find something?
Not reconcile what they did in their cerebral testimony to what they presented in DR57-1. That's a more accurate description.
Thank you. That's all, Mr. Chair. Thank you.
Any questions from the bench? No. Okay, thank you very much. Ms.? Yeah.
Drew's done. Staff calls Drew McAuliffe to stand.
So you're telling me this so you can skedaddle after love?
I'm just trying to give you information.
You have told me like 4 or 5 times.
I know. And my kids tell me that all the time.
Okay.
I think the problem is Bruce listens to like half of what I say, so I'm very used to repeating myself.
Right, half listener, yeah. All right. Yeah, please swear him in.
I do.
Good afternoon, or almost evening, Mr. McAuliffe.
Afternoon.
Could you please state your name and business address for the record?
Sure. It's Drew McAuliffe, DrewMcAuliffe. My business address is 6 St. Paul Street, Baltimore, Maryland.
Thank you. Do you have in front of you a document entitled The Direct Testimony of Drew McAuliffe, dated January 30th, that was 2026, that was pre-filed, consisting of 51 pages of text and 4 exhibits marked DM1 through DM4?
Yes.
Was this testimony prepared by you or under your supervision?
Yes.
Do you have any deletions, corrections, or additions that you would like to make at this time?
No.
If I were to ask you these questions in your testimony today under oath, would your answers be the same?
Yes.
Do you adopt this testimony as your sworn testimony for purposes of this proceeding?
Yes.
Mr. Chairman, I ask that the direct testimony of staff witness Drew McAuliffe be marked as staff exhibit number 9.
So marked.
Turning to your surrebuttal testimony, do you have a document in front of you entitled the surrebuttal testimony of Drew McAuliffe, dated April 16th, 2026, which is pre-file, consisting of 29 pages and one exhibit marked DMS-1?
Yes.
Was this testimony prepared by you or under your supervision?
Yes.
Do you have any deletions, corrections, or additions that you would like to make at this time?
No.
If I were to ask you these same questions in your surrebuttal today under oath, would your answers be the same?
Yes.
Do you adopt this testimony as your sworn testimony for purposes of this proceeding?
Yes.
Mr. Chairman, I'd like to ask that the surrebuttal testimony of staff witness Drew McAuliffe be marked as staff exhibit 10. And at this time, I ask that the staff
So marked.
exhibits 9 and 10 be moved into the record.
Without
The witness-
objection, so entered.
The witness available for cross-examination.
No questions, Your Honor.
No questions.
No questions.
No questions.
Okay. Well, there wouldn't be any need for redirect then, would there? Any questions from the bench? No. Oh, wait. Yes, we have a question.
It's actually not a bad one. Good afternoon, Mr. McAuliffe. Just a quick question for you. Since I would consider you to be the policy witness for the technical staff. Would that be fair to say?
Yeah. I think
Okay. All right. So, as you know, the commission did issue a order with establishing discovery procedures back on December 8th. And over the course of this proceeding, we've heard from not only witnesses from the company, but from all of the other parties that there have been different challenges along the way with discovery. Now, I know some of that is typical in discovery. There's a lot of little elbows rubbing and shoulders rubbing back and forth. But in your opinion, and basically on the staff's position, we haven't received anything on our end in terms of discovery disputes that I'm aware of. Has the staff seen anything that needs to be brought to our attention, or has the process worked as it should have? Because as you know, the original multi-year pilot, transparency was a big component of that.
Sure.
And of course, we were initially dealing with a fully forecasted model. And of course, that's now a historic test year model, but
Sure.
transparency is still very important. So I just wanted to get your thoughts on it.
Well, I would say it's hard for me to speak for the other witnesses, the staff witnesses. I would say that the transparency issues, in my experience, are typically with the accounting and engineering witnesses. So my team in the electricity division dealing with rate design, cost of service, and return on equity. Those are a little more, I'll just say, opinionated kind of areas, and we don't need as much data. So I'll say personally, I haven't had too many problems. Frankly, in every case, we don't always exactly get what we want, and sometimes you have to ask the same question multiple ways, multiple times. But yeah, I would just say I'm hesitant to speak for staff as a whole on that issue specifically.
Okay. All right, that's fair enough. I'm at least the question is on the record now. So transparency, I think I can speak on behalf of the whole commission to say that transparency is still an important component
Sure.
of these types of cases. So, but we've been hearing that refrain from a number of witnesses. I'm not pointing just to the company, but the company witnesses have said it too. So it's been across the board. So thank you. That's all I had, Mr. Chairman.
Okay. Oh, Fred.
So the company's witness, Mr. McKenzie, specifically criticized this use of gradualism and as opposed to rate of return, and identified your testimony as one of the ones where he disagreed with it. So I guess I want to give you a chance to respond to his thought that the use of gradualism is sort of an inappropriate tool to use when it comes to dealing with rate of return.
Sure. Well, so I believe the commission first cited gradualism in case 9424, I believe. That was around 2016. I believe that was the Delmarva, the other PHI company case. I don't believe it's inappropriate, obviously, as I cited in my testimony many times. I did not, and I believe Mr. McKenzie brought this up, and I had a DR sent to me as well saying, the company was unsure if I used gradualism or how I applied it. Frankly, I didn't apply it at all, as I stated in my testimony. My recommendation is gradual in and of itself, and the fact that it's the same number they currently have. But I don't agree that it's improper to use gradualism, because those large swings can, and I believe you asked the question earlier today, does gradualism apply on the way down as well? I would agree it does. And yeah, it just gives folks a steady base to know, where the commission's coming from if there was to be a large kind of sea change and policy change in how the commission awards ROEs. I think that would be helpful to the company, to ratepayers, to the S&P and Moody's, the creditors that we hear from as well. So I think it's reasonable to just kind of give that base to know that there won't be wild swings back and forth. Actually, I think it came into account during kind of the COVID years as well. Frankly, I would argue ROEs didn't get low enough then, and the commission cited gradualism in those cases. So, for example, in BG's first MIP 9645, I personally recommended a 9.4 ROE for electric, and the commission only went 9.5. So, we also heard Witness McKenzie say that it's kind of this dislocation between where commissions are awarding ROEs and where they should be based on interest rates. Well, I would argue there isn't a dislocation because they didn't get low enough in the first place. So he's saying they're not moving high enough now. Well, they didn't go low enough to then need to kind of bounce back up. They're still appropriate in my opinion. And so yeah, I think gradualism is appropriate, and I believe this commission and other commissions used it even on the way down a few years ago when we saw interest rates extremely low.
Okay, all right, that's it. Any other questions? Yes, sir. Okay, thank you.
Thank you.
Your next witness. Okay. There we go.
I'm sorry?
So tell me, do you have a question?
I'm going to put a data request in, but I'm
If you could please swear in Mr. Lowe.
I do.
Good afternoon, Mr. Lowe.
Good afternoon.
Do you have with you a document entitled The Direct Testimony of Chris Lowe, consisting of 78 pages of narrative testimony?
Yes.
Has this document been pre-filed in the case?
Yes.
Mr. Chair, I ask that direct testimony of Christopher Lowe be marked for identification as Staff Exhibit 11.
So marked.
Is this document prepared by you or under your supervision?
It was.
And do you have any additions, deletions, or changes that you'd like to make at this time?
No, I do not.
Do you adopt this document as your sworn testimony in this case?
Yes.
Your Honor, I ask at this time that Staff Exhibit 11 be moved into the evidentiary record.
With no objection, so admitted.
Do you have with you a document entitled The Cerebral Testimony of Christopher Lowe?
Yes.
And has this been pre-filed in the case?
Yes.
I ask that the cerebral testimony of Christopher Lowe be marked as Staff Exhibit 12. Was this document prepared by you or under your supervision?
Yes, was.
And do you have any additions, deletions, or changes that you'd like to make at this time?
I do not.
And do you adopt this document as your sworn testimony in this case?
Yes.
Your Honor, I ask at this time that Staff Exhibit 12 be moved into the evidentiary record.
With so marked and admitted without objection.
Thank you. And finally, do you have with you a document entitled The Supplemental Surrebuttal Testimony of Christopher Lowe?
Yes.
And has this document been pre-filed in this case?
Yep. Yes.
Your Honor, I ask at this time that the Supplemental Surrebuttal Testimony of Christopher Lowe be marked as Staff Exhibit 13.
So marked.
Was this document prepared by you or under your supervision?
It was.
And do you have any additions, changes, or deletions you'd like to make at this time?
No, I do not.
Do you adopt this document as your sworn testimony in this case?
Yes.
And with that, Your Honor, I ask that the supplemental surrebuttal testimony, Staff Exhibit 13, be moved into the evidentiary record.
With no objections, so entered.
Thank you. The witness is available for cross.
AOPA?
Your Honor, I just want to have some data responses admitted.
Okay. Mr. Seegers, did you want to go first, or does it not matter?
We have no questions, Your Honor.
Okay. I saw you playing with your microphone, so I wasn't sure.
Oh, no. Just fidgeting.
I'm feeling you.
It's been a week.
Yeah.
A little bit.
Yeah.
Hey, but you get to go home.
Yeah.
Here we go.
Okay.
Did you need another one? Yeah.
Oh, I know.
Your Honor, I have just passed out staff response to AOBA Data Request 1, Question 1-1, 1-2, 1-3, 1-4, and that's all, and 1-4, which I would like to have marked as AOBA Exhibit 18.
So marked.
Could you please take a look at that, Mr. Lowe, and see that you are the witness who responded to those data requests?
Yes.
Are they true and correct to the best of your information, knowledge, and belief?
Yes.
Your Honor, that's all I have. I ask that AOBA Exhibit 18 be admitted.
Without objection, so entered. MEA,
No questions, Your Honor.
People's Counsel,
No questions.
any redirect?
No read.
No read, okay. From the bench, Suchman, then Linton, and then McLean.
Good afternoon, Mr. Lowe.
Good afternoon.
I actually just have a single question or a single sort of focus. And if you could turn to your direct testimony, page 8. And it's my understanding that you are not recommending disallowing any of the costs for the White Flint portfolio at this time. Is that correct?
Correct.
Okay. And some of why you're not recommending disallowance is that you have you reference the 10 annual 10-year forecast studies that are showing overload projections. Is that correct?
Correct, yeah.
Okay. Did you perform any analysis of the adequacy of these forecasts? Sort of any independent, or did you just sort of accept what?
I did not independently perform or validate Pepco's forecast.
Okay.
Yeah.
So you just based it on what their sort of summary of what the forecast showed and demonstrated in terms of their need.
Well, my review not solely based on the forecast numbers. I look at the records entirely, involving the part loan area constraint, the local planning development, and also low growth and all other factor that I had to consider.
Okay.
Yeah.
But in terms of the studies themselves,
The study.
You didn't do any independent analysis
Just reviewed.
and then you didn't look to see if they were accurate, in terms of what is presented in the studies.
Well, I did not validate, so.
Right. But you also didn't do a look back you didn't look at what they provided and then look to see if they were accurate or within the ballpark of what they were forecasting.
I did look at a number and how the number fluctuated over the years, but I did not validate the accuracy of the numbers.
Okay. That's all I have. Thank you.
Linton?
Thank you, Mr. Chairman. Good afternoon, Mr. Lowe.
Good afternoon.
So I have a couple of questions for that you can find in your rebuttal testimony. It is on page. Wait a minute. I think it was page 4. Yes, page 4. Starts on 3, works over to 4, regarding the smart fault sensors program.
Okay.
You've recommended disallowance of the program, the cost that the company is seeking to recover. Did you have a chance to hear witness Allo's testimony?
Yes.
Okay. So I was wondering if you had any response to his testimony. You have a question on page 4, line 11, regarding your current recommendation, and that, of course, was before witness Allo testified.
Well, my only concern is that the pilot program, was not fully evaluated, and in my view, Pepco had not fully demonstrated the effectiveness of the program in practice. That's my only concern.
Okay.
Yeah.
So, witness, as you know from his testimony, witness Allo suggested that they intended to produce a report of some
Right, I
kind,
remember that.
demonstrating that it was valid, but it took them, I guess it took them extra time to complete all of the installation work. So I'm curious about it because we have this, it sounds as though we have a scenario where we've spent several $1 million to set everything up, and they started running it, and now it's at a point where it's not finished. We've already spent the money. So I'm just trying to figure out where do we reconcile it?
If the company can prove that the 2024 amount is needed to complete the pilot program, then I believe that you can justify that the program is complete, and then the amount for 2024 can be recovered. And also, I believe that the company still have to provide the complete evaluation or show the effectiveness of the program.
Okay. All right. So I guess I'll leave it to the company for whatever steps need to be taken from there in light of your testimony in response to my question. It just seemed as though the pilot was started, but we don't have an actual answer. So I don't know what happens from there, but it sounds as though you're looking for the company to take the next step, aside from just asking for recovery of monies that we already spent.
Right. I think the next step would be for the company to show the pilot is completed and all the device is operational, and that's the next step. And also I need to see the fully benefit that's realized because of those smart devices.
All right. Thank you very much.
I'm actually good.
You're good?
Yeah, no
Okay.
questions. Thank you, sir.
All right. Thank you very much.
Thank you.
Next witness. Fred, you no. Oh, okay. That's okay. Next witness.
Oh, could we ask Alessandro Lee to come to the stand and ask that the court reporter swear him in, please?
Alessandro. Yeah. Spell okay. Alessendro. I do.
Good evening, Mr. Lee. Do you have in front of you the direct testimony of Alessandro Lee for this proceeding, which you caused me to file on January 30th, 2026? Do you have that in front of you, sir?
I do.
Mr. Lee, do you have any additions, deletions, or corrections?
No, I do not.
Your Honor, we ask that the direct testimony of Alessandro Lee be marked as Staff 14.
So marked.
Oh, thank you. Mr. Lee, if I were to ask you these questions now, while you're under oath, would your answers be the same?
They would.
And Mr. Lee, is this your sworn testimony in this proceeding?
Yes, it is.
Mr. Chairman, we ask that staff 14 be moved into the evidentiary record.
Without objection, so entered.
And Mr. Lee, do you have the surrebuttal testimony of Alessandro Lee? And I want to note the mail log number was 329093. Do you have that in front of you?
Yes, I do.
Okay. And Mr. Lee, did you cause me to file that for you on April 16, 2026?
Yes.
Mr. Lee, do you have any additions, deletions, or corrections?
No, I do not.
Mr. Chairman, may we ask that you mark the surrebuttal testimony and exhibits of Alessandro Lee as staff 15?
Without objection, so entered.
And Mr. Lee, if I were to ask you these questions now while you're under oath, would your answers be the same?
Yes, they would.
Mr. Lee, do you adopt this as your sworn testimony in this proceeding?
I do.
Your Honor, it sounds like it already happened, but may we ask you to move staff 15 into the evidentiary record?
Without objection, so entered.
Thank you. And Mr. Lee, do you have in front of you the supplemental surrebuttal testimony of Alessandro Lee?
Yes, I do.
And did you cause me to file that on your behalf on April 23rd, 2026?
Yes.
Do you have any additions, deletions, or corrections?
No, I do not.
Mr. Chairman, would you mark the supplemental surrebuttal testimony of Alessandro Lee as staff 16?
So marked.
And Mr. Lee, if I were to ask you these questions today while you're under oath, would your answers be the same?
They would.
And Mr. Lee, may we accept this as your sworn testimony in this proceeding?
Yes.
Mr. Chairman, would you enter into the evidentiary records staff 16?
Without objection, so entered.
And we tender this witness for cross-examination.
Okay. AOPA.
No questions.
MEA.
No questions.
People's Council.
No questions, Your Honor.
Pepco.
No questions. Good to see you again, Mr. Lee.
Okay.
Thank you. Nice to see
All
you.
right.
as well.
Any questions from the bench? You're free to go. Thank you.
Thank you.
All right. Almost. Okay. Next witness.
May we ask that Latanja Bunch come to the stand and be sworn in?
Latangia Bunch, Lytangia. Yes.
Good afternoon, Ms. Bunch. What's your position at the Public Service Commission?
I'm a regulatory engineer.
Thank you. Do you have before you a document entitled The Public Direct Testimony and Exhibits of Latanja Bunch, dated January 30, 2026?
Yes.
Was this document prepared by you or under your supervision?
Yes, it was.
Do you have any changes or corrections to this document?
No, I don't.
Was there a confidential version of this document?
Yes.
Okay. Your Honor, I'd like to mark the public version as Staff Exhibit 17 and the confidential version as Staff Exhibit number 17C.
So marked.
Thank you. Do you also have a document entitled The Surrebuttal Testimony Exhibits of the Latanja Bunch?
Yes, I do.
And was this document prepared by you?
Yes.
And do you have any corrections or changes to either this document or to your direct testimony?
No, I don't.
Do these documents constitute your testimony in this proceeding?
Yes.
Your Honor, I'd like to mark the surrebuttal testimony as Staff Exhibit number 18.
So marked.
And I'd like to move Staff Exhibits 17, 17C, and 18 into the administrative record.
Without objection, so entered.
And the witness is available for cross-examination.
No questions, Your Honor.
Okay.
No questions.
No cross, Your Honor.
Pepco. Okay. Any questions from the bench? Okay. Okay. Thank you very much.
Thank you.
And that completes staff's case in this proceeding.
Brandon Bowser.
We're-
Oh, I'm
One
sorry.
more.
That's okay.
I'm sorry.
Could we ask that Brandon Bowser take the stand and Mr. Court Reporter ask that you swear him in? Brandon Bowser.
terrible if after all this time. Right. So, Fred,
Mr. Bowser, good af- oh. Oh, I'm sorry.
Brandon, Brandon. I do.
Mr. Bowser, good evening. What is your job title here, sir?
I am the director of the Telecommunications, Gas, and Water Division.
Okay. And Mr. Bowser, do you have with you the direct testimony of Brandon Bowser, ML 326736, dated January 30, 2026?
I do.
Mr. Bowser, was this direct testimony prepared by you or under your supervision?
It was.
Do you have any additions, deletions, or corrections?
I do not.
Mr. Chairman, at this time, we ask that you mark Mr. Bowser's direct testimony as staff 19.
so marked.
Thank you. And Mr. Bowser, if I were to ask you each of these questions now while you're under oath, would your answers be the same?
Yes, they would.
Is this testimony your sworn testimony in this case?
It is.
Mr. Chairman, we ask that staff 19 be moved into the evidentiary record.
Without objection, so entered.
Mr. Bowser, do you have in front of you the rebuttal testimony of Brandon Bowser, ML 327817?
I do.
And Mr. Bowser, was this rebuttal testimony prepared by you or under your supervision?
It was.
Do you have any additions, deletions, or corrections?
I do not.
Mr. Chairman, at this time, we ask that you mark the rebuttal testimony of Brandon Bowser as staff 20.
So marked.
And Mr. Bowser, if I were to ask you each of these questions now while you're under oath, would your answers be the same?
Yes, they would.
And is this your sworn testimony in this matter?
Yes, it is.
Mr. Chairman, we ask that you please move into the evidentiary record staff 20.
Without objection, so entered.
Mr. Bowser, do you have in front of you the surrebuttal testimony of Brandon Bowser, which was ML 329093?
Yes, I do.
Mr. Bowser, was this surrebuttal testimony prepared by you or under your supervision?
Yes, it was.
Do you have any additions, deletions, or corrections?
I do not.
Mr. Chairman, at this time, we ask that you mark the surrebuttal testimony of Brandon Bowser as staff 21.
Without objection, so entered.
Mr. Bowser, if I were to ask you each of these questions now while you're under oath, would the... that's okay.
I meant to note it.
Yeah, that's okay. That's good. And I'll just ask you, which has already been entered, staff 21, if I were to ask you these questions now while you're under oath, would your answers be the same?
They would.
And Mr. Bowser, is this your sworn testimony in this proceeding?
It is.
And Mr. Chairman, may I confirm that you've entered into the evidentiary record staff 21?
Apparently I did.
And just two more. Mr. Bowser, do you have the errata surrebuttal that you've caused me to file this matter in front of you?
I do.
And would that be ML 329221?
Yes.
Mr. Bowser, was the errata surrebuttal testimony prepared by you or under your supervision?
Yes, it was.
Do you have any additions, deletions, or corrections?
I do not.
Mr. Chairman, at this time, we ask that you mark for identification.
So marked.
Staff 22. Thank you. And Mr. Bowser, if I were to ask you each of these questions now while you're under oath, would your answers be the same?
They would.
And Mr. Bowser, is this errata surrebuttal your sworn testimony in this proceeding?
It is.
Mr. Chairman, we ask that staff 22 be moved into the evidentiary record.
Without objection, so entered.
We have one more. The last one. Mr. Bowser, do you have the supplemental surrebuttal testimony of Brandon Bowser? And that's ML 329360. Do you have that in front of you?
I do.
Mr. Bowser, was this supplemental surrebuttal testimony prepared by you or under your supervision?
Yes, it was.
Any additions, deletions, or corrections?
No.
Mr. Chairman, we ask that you mark this as staff 23.
So marked.
And Mr. Bowser, if I were to ask you each of these questions now while you're under oath, would your answers be the same?
Yes, they would.
And is this supplemental surrebuttal your sworn testimony in this matter?
It is.
Mr. Chairman, we ask that you kindly move into the evidentiary record staff 23.
Without objection, so entered.
We wish to tender this witness for cross-examination.
AOPA.
No questions.
No questions.
No cross, Your Honor.
No questions. All righty then. Any questions from the bench? Oh, well. Oh. Head fake. Okay. Thank you very much. So we are almost at the end here. I have to do a couple of closing procedures, housekeeping matters. First of all, I have to request staff's comparison sheet.
Yes, we'll provide that.
Okay. And the briefing schedule?
I think it's due June 1, but I...
Your
oh,
Honor, if there's actually a couple preliminary or post-hearing matters the parties would like to raise, I don't know.
Sure.
If the company has any it would like to raise first.
Just one. Chair, you had asked company witness O'Donnell a question that she was going to follow up on. It was during the questioning on the NOLC. You had asked if we make that disclosure in SEC filings. She was going to confirm that, and we did. We placed a notation in our 10K that was filed in February of this year.
Okay, so it's footnote to your in your 10K, or
It's
is
not
it?
a footnote. It's actually a paragraph in a
Actually-
couple of places.
Okay, terrific. Thank you. Anything else?
Your Honor, just briefly, just a clarification on the bench data request that was requested during Mr. Fitzhenry's cross-examination. Could the commission clarify whether that was directed to the Office of People's Counsel witness, or was that to the company?
Because he wouldn't have it, the company would.
Did-
And Mr. Seegers, you understood that this was a bench request for the company.
I was not at the table, Your Honor, but I'm sure that
Oh,
Mr. McKeel did.
Or somebody.
Yes, yes.
Yes, we did.
Right, thank you.
Okay.
And then the Office of People's Counsel, we'd like to raise a concern with the April 30th bench data request. And we'd like to raise this before we discuss the time frame for briefing and before the evidentiary hearing concludes. We're concerned about a process that allows the utility to supplement or reorganize support for its case in chief through a bench data response that the response of which is received after the conclusion of the
Right.
evidentiary hearing.
This was my request, and is that what we're talking? Right, and I understand your concern, but the issue is that we don't have the data that we need. You don't have the data. I'm hearing that staff doesn't have, AOBA doesn't have. So I guess the alternative is to just not get the data, but I don't think that is a. So what are you proposing?
Well, respectfully, Your Honor, the company bears the burden of production and persuasion in this case, and there's been months and months of discovery. There's been numerous filings submitted by the company, by the interveners, by OPC, by staff. And at the point, when we're at the evidentiary hearing, if there's information that's missing in the record that the company hasn't provided or that parties haven't been able to obtain through discovery and put on the record, there's a due process concern to the participating parties that might not have the opportunity to fully review and vet the information the company has provided, conduct discovery on that if there's any new information that's not contained in the materials that we've already spent months reviewing. And had this type of request been made of the company before, or had the company provided this information, we'd have time to conduct discovery on it and have our expert witnesses review it and potentially opine on it before the close of the hearings.
Well, let me just interject. I mean, you're not completely wrong here, of course. But I think the circumstances were rather unique. With this case has been moving along for quite a while, and then the legislature made it very clear that they were going to change the rules, and the company obviously agreed to this. And the problem, in my view, and I think in the view of Commissioner Suchman and all the rest of us, perhaps, if I can speak for us all, is that the data streams were different, and we want to be able to reconcile all the information in a manner that's sensible to us. And I'm not disregarding your concern. I'm not. I don't want you to think that. But do you want to add anything?
Yeah, and I'm actually hoping. I guess I would be much more concerned if the information that we're getting actually was never disclosed in the first place. I am concerned that it is, or at least the sense I'm getting from our staff is that it's somewhere, but it's not clear. And so I guess I would admonish the company when you're putting this together not to introduce information that hadn't been shared. And I guess you can let us know if the sense you're having is that they're introducing new information, because that would be a due process problem. I agree.
Yeah. So, and I think that's the point that I had requested as a form of a friendly amendment to the on the record request, is that it had to tether itself to exhibits and testimony that was already presented during the proceeding. So there should be some ability for you, as you look at it, to say, okay, this came from exhibit XYZ by this particular party.
Can I? Okay.
Yeah, go ahead.
Okay.
Ms.
I want to move on to another point without me echoing my strong concerns for exactly what the Office of People's Counsel stated, but I want to add something. Yes, Commissioner Litton did ask when they produced this document to tie it specifically in the document to what's been submitted in the record, and that didn't appear in this bench data request. So that would be helpful if the company did exactly what Commissioner Litton asked for. I have one other.
Okay, but if I can just, so when you're talking about the record, are you also talking about responses to data requests?
Well, as far as I'm concerned, Your Honor, if there's been a response to data request that has not been submitted into the record, that's not record evidence. And I think we've been faced with this before with the company. You ask the company a specific question, and they say, well, I know it was in a data request someplace. To me, that is not record evidence. The company has the burden of coming forward with its direct case and its rebuttal and its rebuttal to make its case and to prove its request.
Okay, but the challenge we have is, as the chair explained, is that we're in a very unusual situation. And certainly I would be concerned if there was no information that was submitted to the parties in response to a question. I'm concerned that the information's buried somewhere. It hadn't or it's not tied together in a way that's usable for you and for our staff. And it's I mean, the alternative is that we could just withdraw the bench request, and then we have an incredibly for our staff an incredible challenge, which is to try to go through all of the data and try to figure out where it is. And so that's a concern of ours, because then we end up with a very convoluted process.
Right. If the legislature had never changed the rules of the game in the manner in which they had, we wouldn't be having this discussion, I don't think.
Understood, Your Honor, and we do appreciate the Commission's concern and desire for clarity on what's in the company's request. And OPC, we're us bringing this concern. We're not asking for the Commission to withdraw its request. That's a decision the Commission is free to make. What we wanted to do was note our concerns so that we can preserve our rights and the rights of the other parties to review and meaningfully respond to whatever Pepco files. My first request or suggestion would be for the company to have a date certain by which the response to the data request is due, so that the parties can anticipate when that, at the very last date, when that information will be filed. So we have an opportunity. We know it's coming. If the company can't meet that deadline, we're not going to have an opportunity to review that and at the same time prepare a comprehensive brief on the case.
Well, let me turn to the company. Do you have any, obviously, we sprung this on you very recently. Do you have an estimate as to an ETA?
I do not have an estimate just yet, but to the conversation that we have just had, the first thing I'd like to say is The comparison charts all list a revenue requirement from the parties, so that does show that a revenue that parties were able to at least derive a revenue requirement for the traditional test year by looking at our testimony. So it's our position that, what is needed to deliver a decision on the TTY is in the record. But that aside, we will be able to tie the answers to the bench data request back to testimony, schedules, and data requests. Counsel for AOBA said data requests are not in the record, but the parties had the opportunity to put that in the record through cross-examination of our witnesses. So the fact that it's not in the record should not act as a prohibition for that not being considered when we put in our, when we submit our ultimate response to the bench.
So let me make this as a proposal. How about if we keep the record open until the bench data requests are submitted and the interveners have an opportunity to review and respond?
Okay, but can we get a sense of timing? Because I think that that's still something that, that the parties are, I mean, I had suggested 10 days. We didn't actually put it in formally in what we sent to you, but,
What I would ask is we could take a little bit of a recess so that I can confer with some folks to get a timetable for you, if that would be
Yeah,
helpful.
that's
Yeah.
fair. Go ahead.
Right.
How much
So maybe
time?
maybe
5, 10?
5 minutes. Let's do
Five?
10 minutes. Let's do 10 minutes.
let's
10
do 10
minutes,
minutes.
okay.
Okay, perfect.
Okay, let's get started again. What do you have for
I have
us?
a date for you. We can have the response by next Friday, May 8th. And the information we will provide, as I mentioned before, will tie to testimony schedules and DRs that the parties already have.
In the record.
Well, the DRs may not be in the record, like through a witness, but they would have been provided to the parties through discovery. So it will tie to some type of materials the parties already have in their possession.
But we don't have that. So it has to be on the record.
But that's why it's going to be filed. So it's going to be filed with the commission.
Well, People's Counsel, you moved to the mic first, so.
Thank you, Your Honor. We respectfully, the data requests that the parties have received are not record evidence. No, we don't have the opportunity to confront Pepco's witnesses about those specific DRs. We don't know what those specific DRs may be at this point. So if to the extent that it's acceptable for us, for the company to link the responses in the bench data request to information that has been entered into the record in this case during this evidentiary hearing, but for the company to link them to DRs that the commission hasn't seen and that are not in the record, we don't think that's appropriate.
And,
if I could just, go ahead.
No, I was going to, AOPA also.
I can't express how strongly we feel about this, because this is not just for this case. This has been a recurring problem with the company. We know we filed it at some place in a data request. First of all, it is impossible for one attorney for AO, but with two witnesses, to read every single data response in this case. It's hard enough writing our own, analyzing our own, and certain others that we can see of OPC staff and MEA. So to have the company come forward and say it's in the record someplace, that's not the record. Another thing, when Pepco sends out an email, all we get is such and such an update to staff data request 4654, whatever it is, a notice that something is there within SharePoint. We don't know whether it's a response to a data request. We don't know if it's a change to testimony. The company has stopped filing what we call errata when a mistake is made. So all we get is an email that there's something on SharePoint. That doesn't fit with the procedural schedule. So we don't even know every single data response that's there. So I am totally objecting to the company relying on a data request that hasn't been submitted by any one of the parties or attached to evidence. I know Bruce Oliver does attach certain data responses from the company to his testimony. We've entered several data request responses with on the record, so have all the other parties. That's legitimate evidence, but something that the company sent out some time ago that hasn't been reviewed or entered into the record, we strongly object to that, because that does not allow the parties the due process that they need.
If just two responses to that. One, we were not aware of this data request or that we were going to be asked this until the hearing started. So we would not have known to put, certain information to the record that might be relevant to this data request. Number two, bench DRs are not new. The commission's asked these before. The parties have not raised concerns about wanting to look at it and link things to the record. We get bench data requests in hearings frequently, and this has not been a requirement from the parties or anyone else otherwise. So I would say we treat this like we've done for all bench DRs that the commission has asked in prior hearings. We file it with the commission, we submit it to the commission, and it becomes part of the record.
If I may respond, Your Honor, respectfully, counsel, these circumstances are unique. I can't recall in the years I've been practicing before this commission an instance where a commissioner has expressed concern about the company's the record being insufficient to satisfy the company's burden of proof, and then asking the company to identify where in the record the information that could satisfy that burden may be. That's a unique data request, bench data request.
I disagree. If I may respond again, as I mentioned, we have stated that there's a comparison chart shows TTY amounts that shows that information is in the record, enough information for people to develop a revenue requirement. We understand there's additional information that the commission wants to help make its decision, where this was not due to any fault of the company itself because of this legislation. And so, we're all just trying to make sure that the parties have and the commission has the information it needs to make a decision. So yes, it might be a unique situation, but it was not one that was necessarily created by the company.
So,
Go ahead.
well, thank you, Mr. Chairman. I think since I've raised the issue, I think the point is that what the data request was trying to do was organize the data that was already presented to the commission. As I mentioned, and as I think it was Council Farioba noted, the data requests that you shared amongst yourselves, we don't have access to. So if you produce documentation or a way of organizing the data that we already have that relies on data requests that you've shared amongst yourselves, we don't have it, and it hasn't gone through the evidentiary process with a witness, et cetera. So those are two different classes of evidence, so to speak. And so I think that's the point they're making, and that's the difference between what we have currently right now, the nice stack of stuff I have here, and that's not even all of it, and the things that you shared amongst yourselves as part of discovery.
Respectfully, I would say that is true of pretty much all bench data requests, right? It might include information that's not presented in the record or put into the record. And again, it's never been something anyone's ever pushed back on.
Go ahead.
If I may, I'm a little concerned about basing a commission decision on data requests that are not evidence. And so I don't know that we necessarily have to go down that path. I think my frustration, what I was expressing to you, was that it wasn't clear to me and to my staff where the information was in the testimony that would allow us to make decisions about a historic test year. And so the information that we asked should be in, because this is your case, so it should be in the record. To the extent it's not in the record, I think you need to identify that in your response as well. Not provide us the information, but just identify in what you provide to us that it's not in the record.
Just one response to that.
And if I could just, we're not submitting any new information. We're simply identifying what's not in the record. Would that be sufficient for OPC and AOBA?
That would satisfy OPC's concerns. I think, to the extent the company's able to, we were prepared to suggest an alteration of the briefing schedule depending on the time frame the company would need.
Right.
But if the company can provide a response to the bench data request that does exactly as you asked, Commissioner Suchman.
Right. It should, everything that we're asking should be in the record because it's your case, ultimately. If it's not in the record, maybe you can explain to us in your response that it's not in the record.
Can I just add one thing? I'm going to ask, because we will need more time to be looking, because we don't know what we're getting and how extensive it is, to have one brief due the same date as the date of the reply brief, so there wouldn't be an extension, and to have an increased page limit in that first brief, and that one and only brief.
Can we make that decision after we get the information from the company? can we wait till to May 8th to decide the rest of
I would
this?
like, put it this way, I would like to know now so we can,
Well, but you may not need it. You may get what Pepco is providing, and it gives you the roadmap that you need to be able to do the things that you need to do.
oh, we still need to be able to look at it, and we need to be able to analyze it. So that will take some additional time.
And so your initial brief is due when?
June 2.
June 2,
June
and the
reply-
reply is June
right.
17.
So this would not delay anything. We're not looking to delay the case. And then I was going to ask anyway for an increased page requirement, 75 or 80 pages for the initial brief. So
Yeah,
Yeah.
that's reasonable.
Okay, so what are you asking in terms of the changes in the procedural schedule?
well, I'm not changing the date of the reply brief. I would like one brief due the date that the reply brief is due with an increased page limit, either 75 or 80 pages,
So
Yeah.
you're asking for just one brief?
Correct.
And no reply brief?
No reply brief.
What other OPC, is that good with you? Do you have a request?
The OPC, we were initially thinking if the company needed, beyond May 8th, we were going to propose one brief with the date, the due date on the current date for reply briefs. So if AOBA's preference is for, even with the May 8th deadline for the company's data response, OPC can accept a single brief due on the current reply brief due date. And 75 or 80 pages would be sufficient.
Yeah, how about MEA? Do you have a position here?
I think that we're fine with what's being proposed here.
Okay.
I disagree. The parties agreed to a procedural schedule that included an initial and reply brief. The parties have pushed back in the past to try to get a single brief, so I'm not surprised that they're making that request. But no, the company insists on a reply brief. Parties had previously agreed to that, and it gives us again the ability to have that last word.
Well, all right. So let me just. I don't know. So, would you be willing to consider to push the deadline out by that period of time? Volunteer.
When the orders do.
Yeah, when the orders due.
Voluntarily push
Yeah.
the order out.
Would you be willing to consider that?
So, I mean, the concern we have is, as we extend this schedule, we're going to get squeezed at the end because we have to, under the statute, we have to get an order out by a certain date. And so if we're going to accommodate you on two briefs, we probably need time for us to do what we got to do to figure this out.
If the commission could advise on how much time they need. Now, it's only 1 week that we're asking to provide this information to the commission.
What's the current date that we would have to get something out?
August 10th.
August 10th. So I guess if we got to the end of August, we'd probably be fine.
Yeah.
20 more days. If the commission needs 20 more days, then we can accommodate that.
Okay.
If we do that, then we can deal with the two briefs.
So what's the proposal on the table for the?
I guess we were proposing that the initial brief be due, what I wrote it down, is it the 16th of June, the same date that the reply brief would have been due?
It would have been the 17th.
The 17th.
17th, yeah.
Mr. Chairman,
Yeah.
could staff be heard? We just
Yeah.
want to remind everybody that there's the effective rate date, and I believe the effective rate date is either August 10th or 11th. The schedule went right up to it, so you have a statutory responsibility.
That's what I'm.
Well,
Oh,
but
I'm
that's
sorry.
I'm
we're
asking them
right.
to push that. So.
We're asking them to voluntarily
Right.
extend that.
And not ask for a credit or something. Okay, thank you.
Yeah.
August 3rd is a Sunday, sir.
Is it?
So,
Okay.
Oh, that's a good point.
yeah, I just need to check.
Yeah. So, I mean, okay.
Yeah, let's hold on. Yeah, August 30th.
I think we're just identifying. If I might just try and recap where we are.
Yeah.
We are able to put in information that is in a DR, and Commissioner Suchman, you just want us to identify what that information is, if I understand where we are.
Actually, so in order for this to have use for the parties, it has to be in evidence. So if you're providing something that is information that no one can discover on, I think we put ourselves
Yeah,
in a problematic position if we're making a decision based on evidence that's not in the record. I mean, and so I don't want to run the risk of finding ourselves in the Court of Appeals. And so I think it has to be in the record, and if what we ask is not in the record, then I would like you to identify that to us.
So
I'm assuming everything is in the record because that's your case.
it's not, remember, we exchange discovery among the parties, and then what we want to put in the record will attach to testimony, or we will try to get it through witnesses. So not every bit of discovery goes into the
I
record.
understand that, Ms. Curry, but if you look at the request that we put out, really what the request is asking is for you to be clearer about your case, because we didn't understand it. Basically, we need breadcrumbs because our staff is having trouble figuring out where everything is, and so that's what we're asking. And I've been on the commission 3 years, and I've never struggled as much trying to figure out what you're actually asking for. And some of that is because you put much more effort into your fully forecasted test year than you did, to be perfectly honest, than you did with your traditional test year. And you had one witness, and his testimony was really not clear about, and so that's why, we talk to our staff, they're having trouble, and we have a responsibility to make sure that when we issue an order, the order is consistent with what's in the record, but we were struggling with what's in the record.
Okay.
If I might just gently push back, this to me is no different from any other bench DR that we get asked. It's not always going to tie to testimony. It's not always going to tie to items in the record. We get asked bench data requests at hearings all the time that do not tie to the record. So I do not see this as being any different.
This bench, I actually do. This bench, and I have done a number of bench requests. This bench request is massive. I mean, it is your case, and I said this when I asked for the information, that we were having trouble following the breadcrumbs, and so that's what we're asking is on some level, we're giving you a little bit of a lifeline because we're having trouble figuring out.
Well, again,
how-
look.
so
I mean,
that's-
look. Let's understand that the fundamental problem here is the legislative mandate that none of us expected to have occur. I mean, that is the genesis of this entire problem. So I suppose here, look. I mean, so the proposed alteration would be that the brief would be June 17th, the reply would be July 1st, and the order would go out August 28th, which is a Friday. Also, any information that's in the DR that's not in evidence, you would have to make a note of. We'll keep the record open, I guess, through when?
Like a week after they file the thing.
Yeah, I guess a week after you file your data request. which you say you're going to be able to do by next Friday, did you say?
That is correct.
Yeah.
Your Honor, if I may ask a clarification, when for the keeping the record open directive, is that would that allow the company to provide new evidence, or would the company be restrained as per Commissioner Suchman's request?
Restrained.
Yeah, right.
Okay, thank you.
So, are we all in agreement? Well, I'll let that percolate.
I mean, we're fine. I mean, we're
Okay.
not fine, but we understand
Okay.
what we've decided. And thank you. Okay,
Right.
thank you.
Excuse me, I just have, I have one question that I do need to consult with about
Sure.
the difference in the 20 days. I just want to make sure there's kind of nothing from our end that we need to make up that time. You may recall when the last time we had to delay a case, we had to file kind of a separate tariff. I just want to make sure logistically, make sure there's not an issue with that.
don't-
So
yeah.
if I might just be able to consult with
I don't think
with the
so.
team.
No, but go ahead. Yeah.
Okay.
Yeah. No, there's-
Yeah.
It's apparently, sometimes they feel like reflux errors, so it needs to find temporary.
Oh,
Right.
The case we filed on this with rates effective on this date, just deemed and filed like 20 days later.
Oh,
That's
okay.
what I've seen.
all right.
We can raise that.
Okay. Yeah, we're off the record.
do not,
Yep, come on.
we
So-
do not need a new tariff like we did for the other case. This was 9702. But just to confirm one more time, just so that we're clear, we are going to provide the response to the bench DR, and we're going to identify those DRs that are not currently in the record.
Okay,
Commissioner Barbe, I heard you say you're leaving the record open
yes.
until you receive that information. What we would do is provide those DRs that aren't through a witness, that have been provided to the parties, available on our SharePoint site, and have been available since we've served them on the parties, so they do have access to that information. So the parties necessarily cannot say that this is new information because they've seen it. But I do understand that you say you have not seen it. So if we attach it to what
It's
we
not
are,
just that we haven't seen it, it's not in evidence. So we can't base our decision on information that's not in evidence. And that's actually not, what I asked is that you respond to the data request based on information that is in the record. To the extent that there is that the request involves information that's not in the record, I want you to bracket it and identify and just provide that this is information that's not in the record. You don't need to I mean, at some point maybe you want to talk to the parties about where it is, but it's not in the record, it's not in evidence, and we can't rely on it when we make a decision.
if I understand the chair correctly, he's leaving the record open to allow this information in. And again, I just want to point back to the bench DRs that have happened before that have not relied on information specifically in the record. If I could just give one example. We don't typically, and we don't ever, in a traditional case, provide project lists. So we're not going to have project lists, so that we wouldn't have that information necessarily, because that's not information that is needed for a traditional case. So some of the information that you're asking would not be part of information you would usually have in a traditional case, and that's one of the struggles. You're asking for information that we wouldn't necessarily use to support a TTY. So the information we want to give it to you, you've asked for it, but it's not information we would usually have in a TTY. So hopefully that part of that makes sense. So we do want to provide it to you, despite it.
Then how about,
If I
how
may,
about this as an alternative? Provide us the information that we can rely on when we're making a decision. If there's information that is not in the record, provide it in a separate document. But it's not part of the record, and it can't be part of the record because it's not in evidence.
Well, that might change your DR then. You've asked us for information in a DR that we want to be responsive to.
Well, we assumed that the information we were asking was going to be information that is in the record. We just couldn't find it.
But remember, for a TTY, you do not get specific project lists. That's not part of a traditional test year case.
Your Honor, if I may respond to that, the not providing the specific ITN numbers for projects, that's a choice the company makes. They can provide that information with the TTYCF, even if they haven't done that in the past. That's a choice.
But respectfully, counsel, that's not a failing of us then, right? If that's never been a requirement for a TTY. So I have a simple solution, which is we provide the information to you in the response to the bench data request, even if it includes information that you're asking for that's outside of what a normal TTY would require, and any information that we have that's not in the record, that's been admitted into the record, to be responsive to your request. If you have a different request we can respond to that.
Okay, but we need to be able to parse out what's in the record and what's not in the record. If you are providing us information that is not in the record, then we need to know that it is not in the record, and that's why you're providing us the information through a data request that was never submitted, so that at least we know what has not been provided to us.
Your Honor, there was a lot of information left in the record that has IT numbers in it. I crossed on it. Other parties crossed on it. TOA was a lot of cross-examination. So there are ITN numbers in the record. The company chose it. I mean, the case was an overwhelming case to begin with, and there is a lot still in the record that has FFTY attached to it. So those ITN numbers are in the record right now. Whether the company does it in the past, again, as OPC said, it's their choice. So I don't have a problem if they want to provide a list of, we did respond to this in a DR, but it's not
Well,
in the
hold
record.
on. Let me just ask our staff a question. If we were to limit this DR only to those items that are in evidence, would that give you enough information to be able to give us enough information to be able to process?
I'm going to answer carefully. We've rested our case. We've collected what we need. We may or may not be able to evaluate the May 8th submission because our team has what they need and they're ready to go. We have to put it in the brief, but we're ready to go. And so I'm not sure that's the answer you want.
Okay.
Yeah.
No, I mean you've given me as much information as you can.
Mr. Chairman, how about if we just, I mean, at this point now, answer what you can with the information that's in the record. And just identify, I mean, if you don't have an ITN number for something, then just let us know that you don't have an ITN number for that.
And if it's not fully responsive to your request, that would be we wouldn't be deemed not being in compliance by perform or proceeding in that way.
No, I understand your concern. I think no. I mean, you do the best you can, and we'll see what's provided.
All right. So if I understand the data request now, it is to provide information that supports a traditional case and provide that to the commission
And as in evidence.
and as an evidence.
Yeah.
Is that good with everybody? Is
That's
everybody
fine.
good with
As
that?
long as it's in evidence, I'm right with you.
Now, it won't, just as a caution, it might not be responsive to Commissioner Suchman's requests. To the extent you're asking for specific ITNs
it
and
may not be
budgeted.
fully responsive, but what I think is important is if you cannot, if the information is not in the record, we need to know that as well. So if there's a particular project without an ITN number, I think you need to note the ITN number was not in the record. Because otherwise we're not going to know what is missing. We can't know that if you don't tell us what's missing.
So just so I can reframe the request again, and again, let me know if I'm understanding it incorrectly. As I mentioned, we don't give project level data in a traditional case. That's not been what we have ever done. The only reason the commission and the parties have it is because it was tied to our FFTY. So if the request now is to just ask, if you're asking us for the information to support a TTY, that is in the record as it is. If you want us to point to where that is, and this is information just supporting a TTY, and it might not include project level data, then the company can do that.
If that's the best that can happen.
If it's in the record.
It would be in the record. And it's always been our contention that there is information in the record to support a TTY.
But that's, Ms. Curry, that is some of why we needed to do this, because we were having trouble kind of parsing out what was connected to the fully forecasted versus, and that would be a big help.
Is everyone okay with that?
long as we are not receiving information.
Could you
Okay, I'm sorry. As long as we are not receiving information that was not entered into evidence, either in testimony or schedules, or somebody putting in a DR when they cross-examined or attached to testimony.
Right, has
I'm
to be in
fine with that.
evidence.
Correct.
I think OPC has an understanding of what the company has agreed to with this bench data request. We just request that the evidentiary record be closed as of the conclusion of the hearing today.
Granted.
Yeah.
Granted.
And then one very minor question, just we've noticed there's some discrepancy with the numbering of the bench data requests. I think there was a bench data request 1 issued on Monday. So if there, to the extent there's clarity on the number of bench data requests directed to the company, just for all the parties to keep track of it.
Yeah.
A
That would
bench
be
data
helpful.
request to index the bench data.
Right. Maybe the number and the date, I don't know.
Just to be, completely clear, there are a number of outstanding data requests. So if the record closes today, you would not be able to use that information. Just wanted to make sure you were aware of that by answering counsel for OPC's question that you're closing the record today. That would mean that you would not be considering those bench DRs as well. But
Is that
Yeah,
right?
let's keep it open.
No, we want to keep it open so we can use the information, the
Yeah, I
bench
guess
data.
I didn't realize
Yeah.
that.
Right,
when I
so,
said
so
we
what would
closed.
be, right, what would be the downside for the parties in closing the record today? Because we actually need this information, and I don't see our counsel. Oh, there you are. And so, Ted, would we be able to rely on information that we receive through these bench data requests if we close the record today?
Close the record, but for the bench data requests.
Yeah, okay.
Okay.
All right, that's what we're gonna do.
That's what we're going to do. We'll keep the record open until we get the information. Okay.
Mr.
Yes.
Curry, Ms. Curry, Mr. Seegers, is it fair to assume the company will make some kind of a filing that deems your proposed tariffs filed 20 days later? That's how I've typically seen it done when there's an extension to the suspension period.
I believe that is what we did in 9702. We had to make some level of filing so that the rates didn't go into effect because they'll automatically go into effect after 300 days. I'm fairly certain we'll have to do that.
Okay, all right, just wanted to make sure we're on the same page. Thank you, ma'am.
Okay. Okay, and again, the schedule, as we said it before, briefs on June 17th, reply on July 1st, and the order on August 28th.
Sir, did you extend the page lengths?
75 for, I think you said.
Oh, yes, right.
75 for the brief.
You said 75 or 80, which
Yeah,
do you-
whatever, I don't, what?
Well, I need a number. What do you?
OPC is fine with the standard page limit set forth in Comar.
Wait, no,
She wants more.
You want an increase?
Yes, 75. I would like an increase for the initial.
Okay, and does
Not for the
does
reply,
the
just
company
for the
need
initial.
a reply brief?
Yes.
Okay,
Yes.
good.
Right,
There is?
July 1st. Okay. So,
Page limit 75.
yeah, page limit 75. Is that
On the brief, yeah.
on the brief?
For the initial brief or for both the initial and the reply?
I just said initial. I don't remember what the page limit is on the reply brief. I forgot.
So
What, 50?
75 for the initial and
Right,
50 for the
50,
reply?
right, correct.
Okay,
That's fine.
75 and 50, all right. Anything else?
Yes, sir. If you could you issue a revised procedural schedule for the briefing?
Yeah,
And the page limits that we've agreed to.
right. I thought I'd done that, but,
No, we issue a written.
a written order, yeah, okay, yes, we'll do that written, yeah.
Thank you.
Yeah.
Staff has nothing else.
Yeah, get that done by Monday. Are we all clear? Is everything copacetic?
Everything is all safe.
All right. In that case, we're adjourned.